Section 69 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Gideon Henfield for enlisting in a French privateer. Philadelphia, 1793, Part 3. Let us suppose America engaged in war, and that one of her faithless children prefers the other party, joins a hostile detachment which has already invaded his own country, or enters on board a foreign privateer lying in our bay, and commits those acts which in war are lawful, in peace crimes. Does the right to emigrate, the right to choose his country, to renounce his former allegiance protect him here? It will be said that this is not a parallel case. What is the difference? 1. The offender in the latter case has a right to leave one country and become a citizen of another. 2. He has a right to disengage himself entirely from the obligations of duty and obedience to the first country. 3. The act of joining the other country of itself exempts him from those primary obligations. So far, the parallel is exact. To escape its effect, it may be asserted that a man can never lift his hand against his native country. But then, what becomes of all these rights? If the slavish doctrine of an unalienable allegiance is admitted, it totally destroys the right of emigration. Thus, after all this circuit, we are let down where we began, viz., that the emigration from one country and the reception in another must be substantially and definitively effected before the acts of hostility. Let it not be said that this doctrine violates the rights of man. It is on the rights of man that it is established. The rights of man are the rights of all men in relation to each other, and when voluntarily assumed in society, founded on principles of genuine freedom. They form a useful, benevolent, and endearing system, in which as much is received as is given. Perfect equality is one of those rights. We render ourselves equal when we all submit to the laws. That equality is destroyed if one man can set himself above them. That equality is destroyed if one man, with impunity, may involve 3 millions in war. With the honor of being the first in the 18th century to unfurl the standard of freedom, we unite the glory of being the first in the records of man, who deliberately composed a constitution of government, combining every noble, every useful, every rational, every patriotic object, and containing within itself the means of acquiring and securing them all. Of this, the prominent effects strike the most careless eye. The world does not exhibit a fairer picture of felicity, more useful industry, more wholesome laws, more public and private virtue, more genuine and uniform improvement, more to attract the admiration of the traveler and secure the affections of the citizen than the land we inhabit. Yet it is on such a country that inconsiderate and selfish men would pour the miseries of war. It is not fair to ask them by what authority have you or I delegated to an individual the right of subjecting us to the pressure of heavy taxes, to the desolation of property, to the destruction of agriculture and of commerce, to the dangers of military service, in short, to the havoc and miseries of war. Has Pennsylvania? Have the United States? No. Our excellent Constitution has wisely vested this solemn, awful step in the collective wisdom and patriotism of the whole country. There, the necessity of the war and the means of defense will be compared by men selected by their country and responsible to it, but not by men who involve us in what they profess they will not share with us, and in the very act which draws on us the greatest political affliction, renounce the very connection which has alone rendered us liable for their conduct. Have the Convention of France requested it? No, they have requested our neutrality. The French people who assisted us formerly did it under the sanction and approbation of their sovereign. Instead, however, of his having no power over them, as stated by the other side, the operation of most positive and powerful laws was suspended, with a view to that public assistance which afterwards took place. The intention of France was soon known. She declared herself when she thought the time mature. Mr. Duponceau, Mr. Ingersoll, and Mr. Sargent addressed the jury and argued, 1. That the indictment did not include an offense at common law. 2. That if the President's proclamation created such an offense, the case before the court was committed before the proclamation was made. 3. That though the treaty with Morocco prohibited the enlisting of American citizens under such circumstances as the present, yet there was no such provision in the treaty with France, and hence the inference from its express introduction into the former treaty is that it was intentionally omitted from the latter. 4. That independently of these grounds, as there was no statute giving jurisdiction, the court could take no cognizance of the offense. Mr. Justice Wilson: This is, gentlemen of the jury, a case of the first importance. Upon your verdict, the interests of 4 millions of your fellow citizens may be said to depend. But whatever be the consequence, it is your duty, it is our duty, to do only what is right. It has not been contended on the present occasion that the defendant has any peculiar exclusive right to take part in the present war between the European powers, in relation to all of whom the United States are in a state of peace and tranquility. If he has no peculiar or exclusive right, it naturally follows that what he may do, every other citizen of the United States may also do. If one citizen of the United States may take part in the present war, 10,000 may. If they may take part on one side, they may take part on the other, and thus thousands of our fellow citizens may associate themselves with different belligerent powers, destroying not only those with whom we have no hostility, but destroying each other. In such a case, can we expect peace among their friends who stay behind? And will not a civil war, with all its lamentable train of evil, be the natural effect? Yet what is right must be done, independent of the consequences, which I have only stated, in order to lay before you the necessity of seriously considering the case entrusted to you before you decide upon it. 2 principal questions of fact have arisen, and require your determination. The first is, that the defendant, Gideon Henfield, has committed an act of hostility against the subjects of a power with whom the United States are at peace. This has been clearly established by the testimony. The second object of inquiry is whether Gideon Henfield was at that time a citizen of the United States. This he explicitly acknowledged to Mr. Baker, and, if he declared true, it was at that time the least of his thoughts to expatriate himself. The questions of law coming into joint consideration with the facts, it is the duty of the court to explain the law to the jury and give it to them in direction. It is the joint and unanimous opinion of the court that the United States, being in a state of neutrality relative to the present war, the acts of hostility committed by Gideon Henfield are an offense against this country and punishable by its laws. It has been asked by his counsel in their address to you, against what law has he offended? The answer is, against many and binding laws. As a citizen of the United States, he was bound to act no part which could injure the nation. He was bound to keep the peace in regard to all nations with whom we are at peace. This is the law of nations, not an ex post facto law, but a law that was in existence long before Gideon Henfield existed. There are also positive laws, existing previous to the offense committed, and expressly declared to be part of the supreme law of the land. The Constitution of the United States has declared that all treaties made, or to be made, under the authority of the United States shall be part of the supreme law of the land. I will state to you, gentlemen, so much of the several treaties in force between America and any of the powers at war with France, as applies to the present case. The first article of the treaty with the United Netherlands declares that there shall be a firm, inviolable, and universal peace and sincere friendship between the States General of the United Netherlands and the United States of America, and between the subjects and inhabitants of the said parties. The seventh article of the definitive treaty of peace between the United States and Great Britain declares that there shall be a firm and perpetual peace between His Britannic Majesty and the United States, and between the subjects of the one and the citizens of the other. And the first article of the treaty with Prussia declares that there shall be a firm, inviolable, and universal peace and sincere friendship between His Majesty the King of Prussia and his subjects on the one part, and the United States of America and their citizens on the other. It may be observed that the treaty would not be less sufficient in relation to the present question if subjects and citizens had not been mentioned. These treaties were in the most public, the most notorious existence before the act for which the prisoner is indicted was committed. The notoriety may, indeed, be said to have been greater than that of the general acts of Congress, since, besides the same mode of publication, they are expressly referred to in the Constitution. Much has been said on this occasion by the defendant's counsel in support of the natural right of emigration, but little of it is truly applicable to the present question. Emigration is undoubtedly one of the natural rights of man, yet it does not follow from thence that every act inconsistent with the duty is inconsistent with the state of a citizen. Nothing is more inconsistent with the duty of a citizen than treason, but it is because he still continues a citizen that he is liable to judgment. The judge concluded by remarking that the jury in a general verdict must decide both law and fact, but that this did not authorize them to decide it as they pleased. They were as much bound to decide by law as the judges. The responsibility was equal upon both. The jury retired about 9 and came into court again about 11:30, when they informed the court that they had not agreed. They were desired to retire again, which they did. July 28th. The jury returned into court this Monday morning, having delivered into the hands of the judge a privy verdict on Sunday morning, soon after the adjournment of the court. The verdict was not guilty, and the prisoner was discharged. End of section 69. Section 70 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John Etienne Guinet for fitting out and arming a warship for a belligerent, Philadelphia, 1795. The narrative. The verdict in favor of Henfield was celebrated with such extravagant marks of joy and exultation as to show that punishment would not be inflicted on those who should openly violate the rules prescribed for the preservation of neutrality by an executive proclamation, and it exposed the government to the obloquy of having attempted a measure which the laws would not justify. The verdict was considered by Washington of such moment as to lead him to use it as the principal reason for calling an extra session of Congress. The next year, a statute was passed by Congress especially forbidding certain acts in breach of neutrality, and a grand jury indicted one John E. Guinet, a resident of Philadelphia, for being concerned in the fitting out and arming in the river Delaware, a vessel which was to be employed in making war against England and her allies. This time, the government was successful, for the jury at once convicted the prisoner. Between the day of the acquittal of Henfield and the day Guinet was convicted, A great change had come over the people of the United States. Citizen Guinet had gone too far. He had threatened to appeal from the president to the people. He had written a dictatorial letter to Washington and had received a cold reply from Jefferson, the Secretary of State. The cabinet had decided to demand his recall, and the popularity of the French minister soon took a sudden turn and collapsed like a punctured balloon. The national pride had been touched, and the public esteem for the hero of Trenton, a Valley Fortune of Yorktown, again approached the zenith. The trial. Footnote. Bibliography. Wharton Trials. See Ante. Page 616 to Dale 321. End of footnote. In the United States Circuit Court District of Pennsylvania, Philadelphia, May 1795. Honorable William Paterson, Judge. Footnote. Paterson William, 1745 to 1806. Born at sea of Irish parents. Graduated Princeton 1763. Studied law with Richard Stockton. Admitted to bar 1769. Member New Jersey Constitutional Convention. Attorney General 1776. Member of Congress 1780. Member Federal Constitutional Convention 1787. United States Senator 1789. Governor of New Jersey 1791. Associate Justice United States Supreme Court 1793. Revised the Laws of New Jersey. LLD, Harvard and Dartmouth. May 11th. The grand jury for the district returned an indictment against John Etienne Guinet and John Baptiste Marais of Philadelphia. Footnote. The United States statute on which the indictment was founded declared as follows. Section 3. That if any person shall, within any of the ports, harbors, bays, rivers, or other waters of the United States, fit out an arm, or attempt to fit out an arm, or procure to be fitted out and armed, or shall knowingly be concerned in the furnishing, fitting out, or arming of any ship or vessel, with intent that such ship or vessel shall be employed in the service of any foreign prince or state, to cruise or commit hostilities upon the subjects, citizens, or property of another foreign prince or state, with whom the United States are at peace, or shall issue or deliver a commission within the territory or jurisdiction of the United States, for any ship or vessel, to the intent that she may be employed as aforesaid, every such person, so offending, shall, upon conviction, be adjudged guilty of a high misdemeanor, and shall be fined and imprisoned, at the discretion of the court in which the conviction shall be had, so as the fine to be imposed shall in no case be more than $5,000, and the term of imprisonment shall not exceed 3 years, and every ship or vessel with her tackle, apparel, and furniture, together with all materials, arms, ammunitions, and stores, which may have been procured for the building and equipment thereof, shall be forfeited, 1/2 to the use of any person who shall give information of the offense, and the other half to the use of the United States. Section 4. That if any person shall, within the territory or jurisdiction of the United States, increase or augment or procure to be increased or augmented, or shall be knowingly concerned in increasing or augmenting the force of any ship of war, cruiser, or other armed vessel, which at the time of her arrival within the United States was a ship of war, cruiser, or armed vessel, in the service of a foreign prince or state, or belonging to the subjects or citizens of such prince or state, the same being at war with another foreign prince or state, with whom the United States are at peace, shall be punished. End of footnote. They were charged with being concerned in the port of that city on December 1st, 1794, with the fitting out and arming a vessel called Le Jumeau, with intent that it should be employed in the service of the French Republic, to cruise and commit hostilities upon the subjects and property of the King of Great Britain and other foreign states with whom, as well as with the French Republic, the United States was at peace. Guinet, being the only one apprehended, pleaded not guilty. William Rawle for the United States. Mr. Levy for the prisoner. Footnote: Levy Moses, 1757 to 1826. Born Philadelphia. Graduated University of Pennsylvania, 1772. Earliest Jewish practitioner of law in Philadelphia. Admitted to bar 1778. Recorder of Philadelphia, 1802 to 1822. Presiding Judge District Court, 1822 to 1825. Member, Pennsylvania Legislature. Trustee, Pennsylvania University, 1802 to 1826. Reached great eminence in the legal profession. End of footnote. The evidence. The following witnesses were examined: David Lenore, James Milnor, Benjamin Phillips, William Nagley, and Honorable Richard Peters. Their testimony established the following facts. Les Jumeaux entered at the port of Philadelphia in the month of, laden with sugar and coffee from Port-au-Prince, and on her arrival she mounted 4 guns and 2 swivels. The vessel had originally been a British cutter, employed in the trade to the coast of Guinea, and had 10 portholes on each side, though only 4 were actually open at the time of her arrival, to accommodate the 4 guns then mounted. Soon after, a Frenchman applied to a ship carpenter to repair the vessel, which was in a very rotten state, and after some difficulty, a bargain for that purpose was struck. But the carpenter declared he would only open the number of ports, 20, which were pierced when she came into the port, and in all other respects fit her for a merchant ship. At the time of repairing her, she was owned in shares by Lemaitre, the original owner, and 7 other Frenchmen. The 20 ports being opened and the other repairs of the vessel proceeding rapidly, the government instituted an inquiry into the subject in order to ascertain the nature and design of her equipments. On examination, the master warden found the vessel in great forwardness, her 20 ports open, her upper deck changed, etc., and 4 iron guns on carriages, with 2 swivels were lying on the adjoining wharf. He therefore desired the carpenter to desist from working any further on the vessel, and made a report on the subject to the Secretary at War, who directed that all the recent equipments of a warlike nature should be dismantled, and the vessel restored to the state in which she was when she arrived. The master warden accordingly caused the portholes to be shut up, and even refused to allow any ring bolts to be fixed in the vessel. A few days before she left the port, a witness said he saw 4 guns in her hatchway. The carpenter who repaired her said she carried with her from the wharf the 4 guns and 2 swivels that she had brought in. And according to the custom house entry, she sailed from the city in ballast, having nothing in her hold but provisions, water casks, and wood for the ship's use. It had been said at one time that she was to carry flour, at another time that she was to carry passengers, and Guinet had told the ship carpenter that she would be advertised on freight. She sailed in the middle of the day, and some of the workmen went down in her as far as League Island. It appeared likewise that she came to at Wilmington, that an apprentice to the pilot on board of her was left behind, in order to carry on some guns, cordage, and bedding, that accordingly he, in company with his master, who had returned from Wilmington after piloting the vessel thither, 2 or 3 Frenchmen that belonged to the vessel, and 2 black boys, carried into Levit on board 3 or 4 carriage guns, that the witness who did not go on board saw no appearance of other guns, which he could have done, though it was dark, had there been portholes and the guns run out, that the pilot boat returned to Philadelphia the same night, for the purpose of carrying to the ship some of her crew, and 2 or 3 hogsheads, that the hogsheads were put on board the pilot boat the next day, and being there opened were found to be filled with a number of little kegs, the contents of which were unknown, that at the same time 20 or 30 muskets, a number of lanterns, cans, etc., were put on board, that the whole of this transaction took place in the night time, between 10 and 11 o'clock, and that, during the same night, the pilot boat with 3 or 4 Frenchmen on board pushed from the wharf and sailed down to Wilmington, where the vessel still lay, that the things brought in the pilot boat being put on board the ship, she got under way and proceeded to Reedy Island, that there were then between 30 and 40 persons on board, that the witness could not perceive that she had any guns or gun carriages on deck, though this might be owing to its being dark, that the vessel dropped down to Newcastle, and the pilot boat was again sent to Philadelphia by order of an officer, as it would seem, belonging to the vessel, who met the witness there, and between 9 and 10 o'clock at night put 1 or 2 trunks and a large box on board the pilot boat at South Street Wharf, that there were then lying on the wharf 6 guns, without carriages, which Guinet told the witness he must take on board the pilot boat at 12 o'clock at night, that the mast was so weak that the witness was at first afraid to undertake it, that he went, however, to borrow a runner and tackle from an adjoining sloop, that Guinet concluded to postpone heaving the guns into the boat till the next evening, and in the intermediate time the marshal seized the guns and boat and apprehended the parties. While the vessel was repairing, Guinet was seen frequently attending the people at work, and the master warden, before whom he had attended with the owner, understood that he acted in the character of an interpreter, as the owner could not speak English. The ship carpenter did not see Guinet until the bargain was struck, and the repairs were considerably advanced, that afterwards, when the owner came, which was generally twice a day, he spoke so little English that Guinet used to translate for him, and on all occasions act as his interpreter, that Guinet sometimes brought orders from the owner to the carpenter, that he never assumed any right of ownership himself, but on the contrary, once complained to the carpenter that the owner had not given him so much as a hat for interpreting. In opposition, however, to the idea of his being merely an interpreter, it was proved that, when the marshal seized the pilot boat, Guinet claimed 1 of the trunks on board, and declared that the guns lying on the wharf belonged to him, he having, as he alleged, purchased them to sell again as merchandise. A runner and tackle was sent on board while the pilot boat was in the marshal's custody, but it has never been claimed. Guinet denied before the judge on his examination that he knew anything more of the pilot boat than that she was going to Newcastle, and he had put his baggage on board to send thither. But the pilot's apprentice, being confronted with him, insisted that he was the person who had ordered the 6 cannon to be taken on board, and that he was acquainted with the transaction. When likewise Guinet was apprehended, 2 papers were found in his possession. One of them was an account stated in his own handwriting between Lemaitre and himself, in which were charges for supplying muskets, ball, and cannon, for monies advanced at sundry times on account of the equipments, and for commissions and attendance in superintending the repairs and outfit of the vessel. The other paper was a letter from Messrs. Mendenhall and Company, of Wilmington to Guinet, dated the 20th December 1794, containing the following passage. Your favor proposed is come to hand. We think it not possible to get any 4-pound shot, or any other size here. We think it probable that we can let one of our boats go down with the things for the ship. They have taken the water cask on board already. The account shall be ready against you call. The deputy collector proved the manifest of the sloop Farmer, which brought up 6 guns, consigned from Mendenhall and Company to Guinet, and Guinet acknowledged before the judge that the guns lying at South Street Wharf were those that had been so consigned to him. Mr. Levy to the jury. This is the first prosecution that has occurred since an act of Congress was passed on the subject. Before the act was passed, an important and interesting controversy had arisen between the executive of the federal government and the French minister, in the course of which The latter contended that, if not by the general law of nations, at least by positive compact, the French Republic was entitled to repair and equip vessels of war in the ports of the United States, since the treaty, by making it expressly unlawful for the others, had, by necessary implication, made it lawful for her. As a branch of this controversy, it had likewise been insisted that an American citizen had a right to enter into the service of the French Republic, and the position certainly received some countenance from the refusal of a grand jury in Boston to find bills of indictment against persons who had acted in that manner, and from the acquittal of Gideon Henfield by a Philadelphia jury. These interpretations of proceedings were, however, disapproved by our executive, who, on the first point, contrary to the avowed sense of the great mass of the people, construed the 22nd article of the treaty to be merely an exclusion of other belligerent nations from the privilege of equipping in our ports, and not a permission to France. And this diversity of sentiment between the government and the citizens finally produced the act of Congress now in question. The section on which the prosecution is founded is, indeed, a severe and penal one, but in proportion to the rigor of the punishment will a conscientious jury require the degree of proof to be. It contemplates 4 descriptions of offense. First, to fit out an arm, or attempt to fit out an arm. Second, to procure to be fitted out and armed. Third, to be concerned knowingly in furnishing, fitting out, or arming any ship or vessel, with intent that such ship or vessel shall be employed in the service of any foreign prince or state, to cruise or commit hostilities upon a nation at peace with the United States. And fourth, to issue or deliver a commission within the territory or jurisdiction of the United States for any ship or vessel, to the intent that she may be so employed. 2 facts, then, are essential to justify a conviction. The vessel must have been fitted out and armed within the port of Philadelphia, and the defendant must, at least, have been knowingly concerned in her equipment. With respect to the first fact, there is no direct proof that the vessel sailed with more guns than she brought with her, and the mere intention to arm and equip her is not criminal, nor, even if cannon, arms, and ammunition had been put on board, does it follow as the necessary consequence that it was intended to arm her as a vessel of war in the service of France, to cruise against the friends of America. There is no evidence of such cruising, nor of the design, whether as passengers or mariners, with which the 30 or 40 persons were on board the vessel. The military stores may lawfully be sold here, or be exported to foreign countries by American citizens. The set is only punishable when the armament and stores are applied to the use of the vessel of which they are shipped. But the most that can possibly be inferred from the evidence is an augmentation of the force of the vessel, as she arrived here with guns actually mounted, and then the indictment should have been founded on the 4th instead of the 3rd section of the Act. There is a great difference in the language and penalties of the 2 sections, which undoubtedly arose from the very different nature of the cases to which they respectively apply. For it is neither so offensive in itself, nor so dangerous to the peace of the nation, that a vessel already armed should add something to its force, as that a vessel should originally be constructed and equipped within our ports for the purposes of war. Hence, therefore, the bare attempt in the latter case is made criminal, but in the former, the unlawful act must be consummated. The words of the 4th section refer to ships of war, cruisers, or other armed vessels. All the writers on the subject state that there are 4 kinds of armed vessels, 3 with commissions and 1 without commission, to wit, vessels of war, privateers, letters of marque, and all other armed vessels, and this vessel must be included in the last description, not being embraced by the others. With respect to the second essential fact, there is not sufficient evidence to show that the defendant was knowingly concerned in the illegal outfit of the vessel. He acted only as an interpreter. which, notwithstanding the generality of the word concerned, cannot fairly be included in the definition of an offense. It calls for proof of a serious intention to furnish and outfit the vessel. There was no crime in being owner of guns at South Street Wharf, and the object in ordering them to be put on board the pilot boat does not appear. The transaction with Mendenhall and Company rather proves that the guns were not intended for this vessel, as it would have been easier, more expeditious, and safer in that case to send them on board from Wilmington with the water casks and other articles, which were actually sent by them. The account found in the defendant's possession relates to the disbursements of a factor for his principal. It is not shown how it arose, whether before or after the articles were received. And after a vessel illegally equipped has sailed, it cannot be an offense within the act to pay drafts and discharge of the tradesman's bills. Presumptions unfavorable to innocence ought not to be encouraged in a case so highly penal. Mr. Rawle entered into a description of the principles and advantages of an honorable neutrality, and relied upon the good sense and patriotism of the jury to prevent their being seduced by a retrospective view of the popular prejudices that had formerly prevailed. He then contended, first, that the offense had been committed, second, that the defendant was knowingly concerned in committing it, and third, that the indictment was founded on the proper section of the Act of Congress. There is evidence that the vessel sailed from the wharf with the guns that she brought into port, that 4 other guns with military stores were afterwards put on board of her, and that she had a crew of 30 or 40 persons. It is arming a vessel when arms are put on board, she being on her passage, and it cannot be material that those arms should be arranged in a particular manner. As to the design of the equipment, there is no proof of an actual cruise, but the jury will decide whether it was any other than that charged in the indictment. There is no attempt to prove that she had a cargo or carried passengers. On the contrary, it is in evidence that she sailed in ballast, and the subdivisions of interest in the vessel are in the nature of all ownership of privateers. The defendant was knowingly concerned, as furnishing arms, knowing them to be designed for an unlawful purpose, constitutes the crime, and as an interpreter was the necessary instrument on the occasion. Even if the defendant had appeared in no other character, this would have been sufficient to convict him. But he was not merely an interpreter. He appears to have interfered on various other occasions, and his account is conclusive evidence of a confidential and important agency in accomplishing the illegal outfit of the vessel. It might afford some color of defense to say that he only attempted to send the cannon on board from South Street Wharf, if this account did not demonstrate that he was concerned in the equipment from the beginning. There is nothing to justify an idea that it arose from paying drafts after the vessel had sailed, but on the contrary, several items are for money advanced, and the charge for commissions, etc., has relation to the very moment of commencing the repairs. The agency proved by the account is corroborated by the purchase of cannon from Mendenhall and Company, which is evidently connected with the general plan for equipping this vessel. The indictment is well laid. The second section is the only one to which the case is applicable. The fourth section refers only to the augmentation of the force of the vessel, which on her arrival in our ports was, in fact, a vessel of war, either public or private. If, therefore, a man of war or privateer adds to the number or size of her guns, or makes any equipment solely applicable to war, it is an offense against this section. But if a vessel, having guns on board, and yet being neither a man of war nor a privateer, enters our ports, she cannot legally be equipped for the purposes of war. Without this construction, the act of Congress would be nugatory, as it might be evaded by bringing a single gun in the vessel. In the present case, it appears that les journaux had been employed in the Guinea trade, that she arrived here with a cargo of sugar and cotton, and being converted from a merchant vessel carrying a few guns for self-defense into a privateer armed for hostilities. It is clearly an original outfit within the meaning of the law. The distinction is justified by this further consideration, that the third section makes arming the vessel with intent to employ her in hostilities the offense, whereas the fourth section refers nothing to the intent with which the force of the vessel is augmented, as it only contemplates the case of vessels originally fitted for war by the nation to which they belong. Mr. Justice Paterson, Gentlemen of the jury, this is an indictment against John Etienne Guinet for being knowingly concerned in furnishing, fitting out, and arming Les Jumeaux in the port and river Delaware, with intent that she should be employed in the services of the French Republic to cruise or commit hostilities upon the subjects of Great Britain, with whom the United States are at peace, and it is the province of the jury to inquire whether the proof exhibited on the trial has fully maintained the charge contained in the indictment. Much has been said upon the construction of the third and fourth sections of the Act of Congress, but the court is clearly of opinion that the third section was meant to include all cases of vessels armed within our ports by one of the belligerent powers, to act as cruisers against other belligerent powers in peace with the United States, converting a ship from her original destination with intent to commit hostilities, or in other words, converting a merchant ship into a vessel of war, must be deemed an original outfit, for the act would otherwise become nugatory and inoperative. It is the conversion from the peaceable use to the warlike purpose that constitutes the offense. The vessel in question arrived in this port with a cargo of coffee and sugar from the West Indies, and so appears to have been employed by her owner with a view to merchandise, and not with a view to war. The inquiry, therefore, is limited to this consideration, whether, after her arrival, she was fitted out in order to cruise against any foreign nation, being at peace with the United States. It is true, she left the wharf with only 4 guns, the number that she had brought into the port. But it is equally true that when she had dropped to some distance below, she took on board 3 or 4 guns more, a number of muskets, water casks, etc., and it is manifest that other guns were ready to be sent to her by the pilot boat. These circumstances clearly prove a conversion from the original commercial design of the vessel to a design of cruising against the enemies of France, and of course against a nation at peace with the United States, since the United States are at peace with all the world. Nor can it be reasonably contended that the articles thus put on board the vessel were articles of merchandise, for if that had been the case, they would have been mentioned in her manifest on clearing out of the port, whereas it is expressly stated that she sailed in ballast. If they were not to be used for merchandise, the inference is inevitable that they were to be used for war. No man would proclaim on the housetop that he intended to fit out a privateer. The intention must be collected from all the circumstances of the transaction, which the jury will investigate and on which they must decide. But if they are of opinion that it was intended to convert this vessel from a merchant ship into a cruiser, every man who was knowingly concerned in doing so is guilty in the contemplation of the law. It will only then be necessary to ascertain how far the defendant was knowingly concerned, for, though he was concerned, if he did not act with the knowledge of the real object, he would be innocent. It has been alleged in his defense that he was merely an interpreter, and in fact he had appeared in that character alone. We should not have thought it a sufficient ground for conviction, but the jury will collect from the other parts of the transaction whether this is not used as a mask to cover his sufficient agency in the equipment of the vessel. He carried orders from the owner to the ship carpenter. He told the pilot boy at what time the guns should be taken on board his boat to be carried to the ship. The account found in his possession states charges for supplies of cannon, ball, muskets, and commissions for services, and the whole is conducted in a secret and mysterious manner, under the shade of night. Would he have acted this part as a mere interpreter? If it had been pure mercantile business, involving nothing repugnant to our laws, would have been so much a work of darkness. This alone casts a gloom over the transaction that will impress every just and ingenuous mind with an idea of fraud and delinquency. If the defendant has been concerned in the offense, there is no doubt that it is effected as far as it was in his power to complete it. The illegal outfit of the vessel was accomplished, and that an additional number of cannon was not sent to augment her force was not owing to his respect to the laws, but to the vigilance of the public police. Upon the whole, the jury will consider the indictment and give such a verdict as shall comport with evidence and law. The jury returned a verdict of guilty. End of section 70. Section 71 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of James Williamson for assault and battery, New York City, 1819. The narrative. Several New York gentlemen were waiting for some of the female members of their families on the sidewalk in front of the residence of one of them one spring evening when a city watchman introduced himself in their midst. One of the party made a remark about it, which angered the watchman, who swore at him, told him that he would show him what a watchman was, and dragged him to the police station where, after an explanation to the captain, he was released. Indicted for assault and battery, the watchman was convicted by a jury and fined, the judge having told him that the case was an illustration of the effect which the possession of a little power and brief authority will have on some individuals. The trial. In the Court of General Sessions, New York City, April 1819. Honorable Cadwallader, D. Colden, Mayor. April 6th. During the present term, an indictment had been returned by the grand jury against James Williamson for an assault and battery committed upon Samuel W. Coates on March 3, 1818. The jury having been selected, the trial came on today. Mr. Griffin for the people, N.B. Graham for the prisoner. The evidence. Samuel W. Coates testified that on the afternoon of March 3rd last, his mother-in-law, wife, and two sisters went to make a call on Hudson Street of this city. In the evening, the witness, his father-in-law, Robert Waite, and his son, Robert Jr., went from the Waite residence in Maiden Lane to escort the ladies home. They met the ladies returning on Broadway, opposite his residence, near the corner of Anthony Street. The party stood on the sidewalk, quietly conversing together when Williamson, a watchman on his beat, intruded himself into their circle. Mr. Waite Sr. said to him that this was very improper, and he went away, but returned again in a short time, whereupon witness said to him that such conduct was impertinent, when prisoner immediately seized him violently by his shoulder, and said, "Damn you, I'll show you what a watchman is," and threatened to drag him to the watch-house. He made use of much insulting language to witness, and of indecent language concerning the ladies, to the mob which his clamor had collected before the door of his residence. He requested prisoner to disperse the mob, but to this he paid no attention. Mr. Waite and his wife shortly afterwards went home, and witness went into his house, where he stayed about 15 minutes and then came out again, on the steps at the front of his house, where he was immediately seized by prisoner and dragged violently to the watch-house, being abused and insulted by him the whole way. After they arrived at the watch-house, The captain of the watch recommended a settlement to the parties concerned, considering it to be watchhouse law, that the watchman arresting a citizen was the sole judge as to his demerits, and had a right to detain him all night. However, witness, after some difficulty, was liberated and returned to his house. The prisoner called no witnesses. The jury returned a verdict of guilty. Cadwallader Mayor. There was no assignable motive that he could see for the act of the prisoner, and no justification for his conduct. This is an illustration of the effect which the possession of a little power and brief authority will produce in the minds of some individuals. It is the duty of the citizen to submit to a watchman, but if he unduly and unwarrantably exercises that power with which he is entrusted to the injury and oppression of the citizen, he must be responsible for the consequences. This was a case of that description. The court was disposed to inflict such a punishment as the defendant would feel, and no other consideration had influenced him not to impose a heavier fine, except his inability to pay the amount. The prisoner must be fined $50 and pay all the costs. Footnote: Graham Nathan V., member New York City Bar, 1819 to 1832. Married Jane Lorimer. Died June 18, 1832, aged 66. Griffin George, 1778 to 1860. Born East Haddam, Connecticut. Graduated Yale, 1797. Studied law at Litchfield. Admitted to bar, 1799. Practiced law in Wilkes-Barre, Pennsylvania, until 1806, and then in New York City for 52 years. LLD, Columbia, 1837. Late in life, he became interested in theological and literary studies, and was the author of The Sufferings of Christ, 1845, and the Gospel Its Own Advocate, 1850. End of footnote. End of section 71. Section 72 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trials of Major Stede Bonnet and 33 others for piracy. Charleston, South Carolina, 1718. The narrative. Down to less than a century ago, the most feared and the most reckless criminal was the pirate, the rover and robber upon the high seas. He was an outlaw and an enemy of the human race, with whom neither faith nor oath was to be kept. In the common law of England, said Coke, they are termed brutes and beasts of prey, and it is lawful for anyone that takes them, if they cannot with safety to themselves bring them under some government to be tried, to put them to death. In Norman times, piracy was holden to be petty treason, for which the offenders were to be hanged, drawn and quartered. But since the reign of Edward I, offenders received judgment as felons of the highest order, and were properly hanged. The first and oldest trial in America of piracy was that of Major Bonnet and his crew of 33 men, who, at Charleston, South Carolina, at the beginning of the 18th century, were tried in batches of 4 or more. The proceedings are fully reported and give a vivid picture of a court of justice in the colonies 200 years ago. A prisoner was not allowed counsel in those days, and a large part of the examination of witnesses was conducted by the judge. Bonnet and his crew were charged with capturing 2 different merchant vessels and taking from them cotton, molasses, sugar, and money. The captain, or major as he was called, had succeeded in getting away for a time, and so the sailors were tried first. A few of them pleaded guilty. 2 or 3 showed that they had been compelled to serve against their will, and were acquitted, but the rest were convicted and sentenced to death, after a long sermon by the judge, filled with biblical quotations. 72 hours afterwards, No less than 22 of them were hanged from the same scaffold at White Point, near the town of Charleston. Only 2 days later, Major Bonnet, who had been recaptured, was tried and convicted and hanged within a month at the same place. The trial of Tucker, Robinson, Paterson, Scot, and Bayley for piracy, Charleston, South Carolina, October 1718. The trial, footnote, bibliography, Howell State Trials, end of footnote. In the Court of Vice Admiralty, Charleston, South Carolina, October 1718. Honorable Nicholas Trott, Judge. Footnote. Trott Nicholas, 1663 to 1760. Born in England and came to America at the end of the 17th century. In 1700, he was Speaker of the House. In 1703, one of the counselors for the proprietors. From 1712 to 1719, he was Chief Justice. He was superseded by Richard Allen, who was followed by many others up to 1774. But until that time, when William Henry Drayton was appointed, we know little beyond the names of the successive Chief Justices and their assistants. Chief Justice Trott was, however, a lawyer to be remembered. His charge in 1718 and his collection of the statute law entitles his name to notice. The Chief Justice was, however, like Lord Bacon, capable of being seduced by patronage and money. He was charged, it would seem upon good grounds, with base and iniquitous practices, such as continuing cases from term to term, and for years, for the sake of fees, giving advice and acting as counselor in cases depending in his own court. But the proprietors refused to remove him. This led to the Revolution of 1719, in which Trott's power was broken down and that of the proprietors forever annihilated. But even after that, unaided by power, his great abilities gave him great weight. He died in 1760, and his name is extinct in Carolina. He is only known by the unfortunate combinations of legal learning, talents, and corruption. O'Neill, Bench and Bar of South Carolina. The following judges sat as assistant judges: George Logan, Esquire; Alexander Paris, Esquire; Philip Dawes, Esquire; George Chicken, Esquire; Benjamin Delacour Solaire, Esquire; Samuel Dean, Esquire; Edward Brailsford, gentleman; John Croft, gentleman; Captain Arthur Lone, captain; John Watkinson. End of footnote. October 28th. The commission to Nicholas Trott, Judge of the Court of Vice Admiralty, and the commission in the name of the Lord Palatine, and the rest of the Lords Proprietors, and testified by the Honorable Robert Johnson, Governor, and the rest of the Lords Deputies, for holding the Court of Admiralty sessions, was read. Then the grand jury was called, and 23 of them were sworn, the names of which are as follows: Michael Bruton, foreman; Robert Tradd, Andrew Allen, Peter Manigault, John Beauchamp, John Bullock, Thomas Barton, Anthony Matthews, Alexander Kinloch, Henry Perrinel, Paul Dawson, John Breton, John B., Daniel Gale, Thomas Lloyd, Lawrence Dennis, Elias Voisin, John Shepard, John Simmons, George Peterson, Solomon Laguerre, Abraham Lesueur, and John Cawood. The judge of the Vice Admiralty proceeded to give his charge to the grand jury, which on the next afternoon and also the following day returned a number of indictments against the pirates. Footnote. This is given in full in the report in Howell. End of footnote. October 30th. The Clerk set Robert Tucker, Edward Robinson, D.O. Paterson, William Scot, and Joe Bayley to the bar. Then the petty jury were called over. The clerk: you, the prisoners at the bar. These good men that were called last, and have here appeared, are those that shall pass between our sovereign Lord the King and you, upon your lives and your deaths. Therefore, if you or any of you will challenge them or any of them, as they come to the book to be sworn, and before they be sworn, you may and you shall be heard. The petty jury were sworn as follows: Timothy Bellamy, foreman; George Duckett, John Rivers, William Sharif, Benjamin Dennis, Hugh Durfee, Thomas Chambers, Daniel Townsend, John Lee, Thomas B., John Barton, Richard Fairchild. The crier: Oh yes, if any man can inform the judge of the Vice-Admiralty for the Vice-Admiralty jurisdiction of this province, and the rest of the commissioners of this Admiralty sessions, or the Attorney General of this inquest to be taken between our sovereign lord the King and the prisoners at the bar, or any of them, of any treason, piracy, murder, or other felony committed or done by the prisoners at the bar, or any of them, let them come forth, and they shall be heard. The prisoners now stand at the bar upon their deliverance. The prisoners were severally bid to hold up their hands, which they did. The clerk: You gentlemen of the jury that are sworn, look upon the prisoners and hearken to their charge. Then the indictment was read, charging the prisoners with having taken on the high seas a sloop called the Francis, Peter Manwaring captain, and carrying away from it a quantity of goods and chattels, included money. Footnote: The jurors for our sovereign lord the King do upon their oath present that Stede Bonnet, alias Edwards, alias Thomas, late of Mariner; Edward Robinson, late of Newcastle upon Tyne, Mariner; Barbados, Mariner; Robert Tucker, late of the island of Jamaica, Mariner; Edward Robinson, late of Newcastle upon the Tyne, Mariner; Neil Paterson, late of Aberdeen, Mariner; Joe Bayley, alias Bayley, late of London, Mariner; William Scot, late of Aberdeen, Mariner. The 2nd day of August, in the 5th year of the reign of our sovereign Lord George, by the grace of God of Great Britain, France, and Ireland, King, Defender of the Faith, etc., by force, etc., upon the high sea, in a certain place called Cape James, alias Cape Inlopen, about 2 miles distance from the shore in latitude 39 degrees, or thereabouts, and within the jurisdiction of the Court of Vice-Admiralty of South Carolina, did periodically and feloniously set upon, break, board, and enter a certain merchant sloop, called the Francis, Peter Manwaring, commander, then being a sloop of certain persons, to the juries aforesaid unknown, and then and there periodically and feloniously did make an assault in and upon the said Peter Manwaring, and other his mariners, whose names to the juries aforesaid are unknown, in the same sloop against the peace of God, and of our said, now sovereign, Lord the King, then and there being periodically and feloniously did put the aforesaid Peter Manwaring, and others his mariners of the same sloop, in the sloop aforesaid, then being, in corporal fear of their lives, then and there in the sloop aforesaid, upon the high seas in the place aforesaid, called Cape James, alias Cape Inlopen, about 2 miles distant from the shore, in the latitude of 39 degrees, or thereabouts, as aforesaid, and within the jurisdiction aforesaid, periodically and feloniously did steal, take, and carry away the said merchant sloop, called the Francis, and also 26 hogsheads, 3 tierces, and 3 barrels of rum, of the value of 263 pounds, 6 shillings, 8 pence, current money of the island of Barbados, 25 hogsheads of molasses, of the value of 138 pounds, 13 shillings, 8 pence, current money of the island of Antigua, 3 barrels and 3 tierces of sugar of the value of 33 pounds, like current money at Antigua, 2 pockets of cotton of the value of 50 shillings, like current money of Antigua, and about 60 weight of indigo of the value of 9 pounds, like current money of Antigua aforesaid, 1 new cable of the value of 50 pounds, sterling money of Great Britain, 19 French or Spanish pistoles, 2 half mortars of gold, 14 French crowns, 1 pair of silver buckles, value 10 shillings, sterling money of Great Britain, and 1 silver watch of the value of 7 pounds, sterling money of Great Britain aforesaid, the goods and chattels of certain persons to the jurors aforesaid unknown, then and there upon the high sea aforesaid, in the aforesaid place called Cape James, alias Cape in Lopez, about 2 miles distant from the shore in the latitude of 39 degrees, or thereabouts, as aforesaid, and within the jurisdiction aforesaid being found in the aforesaid sloop, in the custody and possession of the said Peter Mainwaring and others his mariners of the same sloop, and from their custody and possession then and there, upon the high sea aforesaid, in the place aforesaid, called Cape James, alias Cape Lenopen, as aforesaid, and within the jurisdiction aforesaid against the peace of our now sovereign Lord the King, his crown and dignity. End of footnote. The Clarke. Upon this indictment they have been arraigned. Upon their arraignment they have pleaded not guilty, and for their trial have put themselves upon God and their country, which country you are. Your charge is to inquire whether they or any of them are guilty of the felony and piracy of which they stand indicted, in manner and form as they stand indicted, or not guilty. If you find them or any of them guilty, you shall then inquire what goods or chattels, lands or tenements they or any of them had at the time of the felony or piracy committed, or at any time since. But if you find them not guilty, etc., and hear your evidence. Richard Allen, Attorney General. Footnote. Allen Richard succeeded Nicholas Trott as Chief Justice in 1719. See ante. End of footnote. To the jury. May it please your honors and you gentlemen of the jury, the nature of the crime, piracy, for which the prisoners at the bar are now to be tried, and the statute of the 28th of Henry VIII entitled, For Pirates, has been fully and learnedly laid open and explained by the judge in his charge to the grand jury, of which I am sensible most, if not all of you, were present. Therefore, I shall say but little more on that head, and only remark that it is a crime so odious and horrid in all its circumstances, that those who have treated on that subject have been at a loss for words and terms to stamp a sufficient ignominy upon it. Some calling them sea-wolves, others beasts of prey, and enemies of mankind, with whom neither faith nor treaty is to be kept. And all this is but a faint description of these miscreants. For beasts of prey, though fierce and cruel in their natures, yet, as has been observed of them, they only do it to satisfy their hunger, and are never found to prey upon creatures of the same species with themselves. And here, too, that those wild beasts have neither rational souls, understanding, nor reason to guide their actions, or to distinguish good or evil. But pirates prey upon all mankind, their own species and fellow creatures, without distinction of nations or religions. English, French, Spaniards, and Portuguese, and Moors and Turks are all alike to them. But pirates are not content with taking from the merchants what things they stand in need of, but throw their goods overboard, burn their ships, and sometimes bereave them of their lives for pastime and diversion, as we have had frequent instances of late, and prove destructive to all trade and commerce in general. And if a stop be not put to these depredations, and our trade no better protected, not only Carolina, but all the English plantations in America will be totally ruined in a very short time. The pirates are become very numerous and formidable in these parts. The trade of America is no small advantage to the crown of Great Britain. Jamaica, by relation, is ruined by those pirates already, and other parts of America had suffered most grievously and are like to share in the same fate. I know not what is done at home, therefore I cannot say no care at all has been taken of us. But this I do say, no effectual care has been taken to suppress those pirates, and if a true representation of these matters were laid before His Majesty, we could not but hope for some redress. It is not my business to call in question the conduct of the Spaniards in breaking up the Bay of Campeche. They could not but think that turning away such a number of profligate wretches as were got together must put them on a worse course of life. They have done them more harm since than cutting their logwood, for 9 parts in 10 of them turned pirates, and have lived upon robbing and plundering them and us ever since that time. That and the great expectations which so many had from the Bahama wrecks, where not 1 in 10 proved successful, gave birth and increase to all the pirates in those parts, English, French, and Spaniards. I just now instanced Jamaica as a place that is almost ruined by the pirates, but what occasion have we to look abroad? What a grievous dilemma were we ourselves reduced to in the month of May last, when Thatch, the pirate, came and lay off this harbor with a ship of 40 guns mounted, and 140 men, and as well fitted with warlike stores of all sorts as any 5th-rate ship in the navy, with 3 or 4 pirate sloops under his command. And after having taken Mr. Samuel Bragg, one of the council of this province, bound out from this place to London, and also one Mr. Marks, and several other vessels going out and coming into this harbor, they plundered those vessels going home to England, from hence of about 1,500 pounds sterling, in gold and pieces of 8. And after that, they had the most unheard of impudence to send up one Richards, and 2 or 3 more of the pirates with the said Mr. Marks, with a message to the government to demand a chest of medicines of the value of 300 or 400 pounds, and to send them back with the medicines, without offering any violence to them, or otherwise they would send in the heads of Mr. Ragg and all those prisoners they had on board. And Richards and 2 or 3 more of the pirates walked upon the bay, and in our public streets, to and fro in the face of all the people, waiting for the governor's answer. And the government, for the preservation of the lives of the gentlemen they had taken, were forced to yield to their demands. And some of those very prisoners now at the bar were part of that Thatch's and Bonnet's crew. Afterwards, one Vaughan, another noted pirate, came and lay off our bar, and sent in another insolent message. This roused our spirits, and though reduced to a very low ebb by reason of the calamities of the Indian War, and long and heavy taxes, we could not bear those insults, but sent out a force to suppress them. However, we must own that honorable gentleman, Colonel William Brett, was the chief, if not the first promoter of fitting out 2 sloops to take some of those pirates. The government readily fell in with the measures proposed. Colonel Brett went in person, accompanied by many gentlemen of the town, animated with the same principle of zeal and honor for our public safety and the preservation of our trade. It is probably Vaughan the pirate, before things could be got in readiness, might have some intimation of our design, and made his way off the coast, though all possible care was taken to prevent it. However, Colonel William Brett and the rest of the gentlemen were resolved not to return without doing some service to their country, and therefore, when in quest of a pirate they had heard, lay at Cape Fear. About the latter end of September they came up with and engaged them. The fight lasted about 6 hours, and the pirates were forced to surrender, though the colonel's vessel, running aground, lay under all the disadvantages in the world, as you are all sensible. The piratical crew at the bar, and now to be tried, in the engagement killed 10 or 11 of our men on the spot, and wounded about 18, several of which died since they came on shore here. The pirate sloop was commanded by that noted pirate, Major Stede Bonnet, and formerly called the Revenge, now the Royal James, and was one of those very sloops that lay off the harbor of Charleston about May last, when they took Mr. Ragg prisoner, and sent up their insolent demands to the governor, as I have mentioned before. We must all own that the undertaking and design of fitting out those sloops after these pirates was bold and noble, and carried on with prudence and courage, and crowned with victory and success. And I hope Colonel Red and the rest of the gentlemen that were with him will meet with both thanks and rewards suitable to their great merit, and the credit and reputation they have brought to this province by this gallant action. But see how justice follows those wicked offenders. They are now brought to suffer in that country which they so lately insulted. It is true, Bonnet had not the sole command of his sloop when he lay off the bar, but was turned out some time before by Thatch. But that was not Bonnet's fault. Bonnet's escape out of prison is no small misfortune to us. First, because some will be reproached with conniving at his escape that had no hand in it, and though they be never so innocent. Secondly, by reason of the ill consequence that may happen to many merchants in case Bonnet makes ahead again, and particularly to the merchants of this province. I hope the great reward of £700 offered by the government for taking Bonnet and his master will make the people vigilant in apprehending them. I am sure the government gave frequent and strict charges to the marshal for securing him, and ordering sentinels to be placed early in the evening, and immediately on his escape, set up all night, sending hue and cries and expresses by land and by water throughout the whole province, so that it is to be hoped he will be retaken before the service be over. I am sensible Bonnet has had some assistance in making his escape, and if we can discover the offenders, we shall not fail to bring them to exemplary punishment. And now, gentlemen of the jury, I must remind you of your duty on this occasion. You are bound by your oaths, and are obliged to act according to the dictates of your consciences, to go according to the evidence that shall be produced against the prisoners, without favor or affection, pity or partiality to any of them, if they appear to be guilty of those crimes they are charged with, and you are not allowed a latitude of giving in your verdict according to will and humor. I am sorry to hear some expressions drop from private persons, I hope there is none of them upon the jury, in favor of the pirates, and particularly of Bonnet, that he is a gentleman, a man of honor, a man of fortune, and one that has had a liberal education. Alas, gentlemen, all these qualifications are but several aggravations of his crimes. How can a man be said to be a man of honor that has lost all sense of honor and humanity, that is become an enemy of mankind, and given himself up to plunder and destroy his fellow creatures, a common robber and a pirate? Nay, he was the archer pirata, as it is now taken in the worst sense, or the chief pirate, and one of the first of those that began to commit those depredations upon the seas since the last peace. I have an account in my hand of about 28 vessels taken by him in company with Thatch in the West Indies since the 5th day of April last, and how many before nobody can tell. His estate is still a greater aggravation of his offense, because he was under no temptation of taking up that wicked course of life. His learning and education is still far greater, because that generally softens men's manners, and keeps him from becoming savage and brutish. But when these qualifications are perverted to wicked purposes, and contrary to those ends for which God bestows them upon mankind, they become the worst of men, as we see the present instance, and more dangerous to the Commonwealth. Gentlemen, most of the said Bonnet's crew, and particularly the prisoners at the bar, to wit, Edward Robinson, Robert Tucker, William Scot, Joe Bayley, and Neil Paterson, are old offenders, and were with Thatch and Bonnet at the taking of all, or most of these vessels I have mentioned, and were either with Bonnet or Thatch when they lay off our bar in May last, and sent up that insulting message, and were in the engagement against Colonel Red, so that there is hardly any room left for the least pity or compassion. Who can think of it, when you see your fellow townsmen, some dead, and others daily bleeding and dying before your eyes? But the particular fact or act of piracy for which the prisoners at the bar are now to be tried is set forth in the indictment. For that, they say, the said Edward Robinson Robert Tucker, William Scot, Joe Bayley, and Neil Paterson, the 2nd day of August in the 5th year of His Majesty's reign, by force and arms, upon the high seas, in a certain place called Cape James, alias Cape Lopez, in the latitude of 39 degrees, did periodically and feloniously set upon, board, break, and enter a certain merchant sloop called the Francis, Peter Manwaring, commander, putting the said Manwaring and others in corporal fear of their lives, and then and there periodically and feloniously did take and carry from the said Manwaring out of the said sloop 26 hogsheads and 3 tierces, and 3 barrels of rum, the value of 263 pounds, 6 shillings, 8 pence, and other the goods mentioned in the indictment of the value of 500 pounds. We shall call the evidence and prove the fact fully and clearly upon them. Take notice, gentlemen, that the boarding, breaking, and entry of one, if the rest were present and consenting, is the boarding, breaking, and entry of all the rest. We shall prove that all the prisoners at the bar were at the taking of Manwaring's sloop, that they all bore arms, and that they all shared a few days before they came to Cape Fear. And if so, we doubt not but you will find them guilty, and discharge that duty the country expects from you. Mr. Thomas Hepworth, footnote, Hepworth Thomas, was recorder at the city of Charleston in 1723, as appears by an old record of the minutes of the corporation, and was Chief Justice of the province, as is evident by a writ which I have with his signature, T. Hepworth C.J., dated 11th of May, 1726. In looking over the council records from 1717, which are the earliest records in the office, I find Thomas Hepworth's name mentioned as Chief Justice, but is not in the published list. O'Neill, Bench and Bar of South Carolina, page 8. End of footnote. May it please your honors and you gentlemen of the jury, the crime the prisoners now stand charged with is piracy, which is the worst sort of robbery, both in its nature and its effects, since it disturbs the commerce and friendship betwixt different nations, and if left unpunished, involves them in war and blood. What calamities and ruin they carry along with them, no person can be a stranger to, so that those that bring not much criminals to judgment, when it lies in their power and is their duty to do so, are answerable in a great measure before God and man, for all the fatal consequences of such acquittals, which bring a scandal on the public justice, and are often attended with public calamities. End of section 72. Section 73 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Tucker, Robinson, Paterson, Scot, and Bayley for piracy. Charleston, South Carolina, 1718. It is not, therefore, gentlemen, to be supposed that wise or honest men, and there is none who would willingly be thought otherwise, who love their country and wish its peace and prosperity, would be guilty in that kind. What has been said by the King's attorney or myself upon this unexpected occasion, I hope will be not looked upon as intended to influence any of the jury. I am sure it is far from being so designed. Religion, conscience, honor, common honesty, humanity, and all laws forbid such methods. There is no doubt but the judges as well as the jurymen best discharge their duty when they proceed without favor or affection, hatred or ill will, or any partial respect whatsoever. Malice and favor, two great enemies to justice, are to be excluded all courts of judicature as too partial. Every man ought to be extremely tender of such a person as he has reason to believe is innocent, but it should be considered likewise on the other side that he who brings a notorious pirate or common malefactor to justice contributes to the safety and preservation of the lives of many, both bad and good, of the good by means of the assurance of protection, and of the bad too, by the terror of justice. It was upon this consideration that the Roman emperors, in their edicts, made this piece of service for the public good as meritorious as any act of piety or religious worship. Our own laws demonstrate how much our legislators, and particularly how highly that great prince Henry V and his parliament, thought England concerned in providing for the security of traders, and scouring the seas of rovers and freebooters. Certainly there never was any age wherein our ancestors were not extraordinarily zealous in that affair, looking upon it as it is, and ever will be, the chief support of navigation, trade, wealth, strength, reputation, and glory of the English nation. Gentlemen, our concern, as our trade is, ought in reason to be rather greater than that of our forefathers. We want no manner of inducements, no motives to stir us up, whether we consider our interest or honor. We have not only the sacred word, but also the glorious acts of the best of kings, which sufficiently manifest to us that the good and safety of the English nation is the greatest care of his life. Let every man, therefore, who pretends to anything of a true English spirit, readily and cheerfully follow so good, so great, so excellent an example, by assisting and contributing to the utmost of his power and capacity at all times towards the carrying of his noble and generous designs for the common good, and particularly at this time, by doing all he can, to the end that by the administration of equal justice, the discipline of the seas, on which the good and safety of the English nation and these parts of America more especially entirely depends, may be supported and maintained. The civil law terms the pirates beasts of prey, with whom no communication ought to be kept, neither are oaths or promises made to them binding, and by the law marine, the captors may execute such beasts of prey immediately without any solemnity of condemnation, they not deserving any benefit of the law. I believe, gentlemen, that no greater motives can be urged to spur you on in your duty than to desire you to reflect and consider how long our coast have been infested with pirates, from the name of men they do not deserve, and how many vessels they have taken and pillaged belonging to this place, as well as multitudes of others belonging to diverse parts of his Majesty's dominions, and how many poor men in whose blood they have imbrued their hands with the greatest inhumanity imaginable, and how many poor widows and orphans they have made, and how many families they have ruined, and how long they have gone on in their abominable wickedness. Nay, do but consider how these very pirates lately insulted this government, when they sent for medicines, threatening to destroy our vessels and men in case of refusal. Nay, since these have accepted of certificates from the government of North Carolina, like dogs to their vomits, they have returned to their old detestable way of living. And since taken off these coasts, 13 vessels belonging to British subjects. I believe you cannot forget how long this town has labored under the fatigue of watching them, and what disturbances were lately made with the design to release them, and what arts and practices have been lately made use of, and effected for the escape of Bonnet, their ringleader, the consideration of which shows how necessary it is that the law be speedily executed on them to the terror of others, and for the security of our own lives, which we were apparently in danger of losing in the late disturbance, when under a motion of the honor of Carolina, they threatened to set the town on fire about our ears. We shall now call our witnesses, who will relate to you what enormous and horrid crimes the prisoners at the bar have committed in the prosecution of the fact laid in the indictment. The evidence. The clerk. Call Ignatius Pell, the boatswain. Mr. Hepworth. Do you know the prisoners at the bar? Pell. I know them all very well. Mr. Hepworth, please to give the court an account what vessels were taken after you came from North Carolina. Pell, I shall begin before that time. We came from the Bay of Honduras, and from thence to Providence, after which we took several vessels, and then we came and lay off this bar, where we took 5 vessels. Judge Trott, did all the prisoners come from the Bay of Honduras? Pell, all except Robert Tucker. He came out of a sloop belonging to Bermuda. After that we took a brigantine, out of which we took 14 negroes. After we had discharged the brigantine, we set sail and went to Topsail Inlet at North Carolina, where the ship was run ashore and lost, which Thatch caused to be done. After we had been there some time, Captain Thatch came aboard and demanded all our arms, and took our best hands and all our provision, and all that he had, and left us. The Attorney General, were all these men sent aboard of Major Bonnet immediately, or not? Pell, no, sir. They were put ashore upon an island. Judge Trott, how came they on board the Revenge? Pell, the boat was sent off to fetch them aboard. A prisoner. Major Bonnet came with the boat and told us, as we were on a maroon island, that he was going to St. Thomas's to get a commission from the Emperor to go against the Spaniards a privateering, and we might go with him or continue there. So we, having nothing left, was willing to go with them. The Attorney General, you say all were on shore, and all might have gone up into the country. Pray, what constraints were any of you under? Pell, sir, none. When we left Topsail Inlet, it was with the design to go to St. Thomas's, for the Emperor's commission to go against the Spaniards, but the first vessel we saw we gave chase to and came up with her. Mr. Hepworth, what did you take out of that vessel? Pell, we took some provisions out of her. After we had discharged her, we saw another, which we chased and took. The Attorney General, were all these men aboard and in arms at the same time? Pell, yes, sir, all were in arms. So, after we had taken some provisions out of her, then we discharged her. Next day we saw 2 sloops bound to Bermuda, which we took. The next day we gave chase to another, and about 7 or 8 o'clock we came up with them. Judge Trott, I suppose you were always ready for an engagement, so that they had their arms always in order? Pell, I know nothing to the contrary. Judge Trott, was Tucker there in particular? Pell, he was, to be sure. Judge Trott, go on. Pell, then we gave chase to a ship and we came up with her, in which were some negroes. We left 3 negroes on board and 2 white men, and sent 3 hands from the Revenge. But we seeing 2 sloops more, we stood after them, and the other turned tail, and we never saw them more. So we came up with the sloop, out of which we took 30 barrels of beef, some butter, and other provision. Mr. Hepworth, what did you return in the room of those goods? Pell, some molasses that we had on board Major Bonnet's sloop. After we had discharged these sloops, next day we took a ship and a schooner, which Major Bonnet took with him. Mr. Hepworth, did you take no plunder out of those? Pell, the chief was provisions. Then we sailed in company, and the next day we came to the Capes of Virginia, where we met with 2 vessels bound for Glasgow in Scotland, out of which we took provisions and some tobacco. And after we had discharged them, we sailed for Cape James. And after we had been at anchor some time, we saw a sloop, which was Captain Mainwaring. We let down our dory and sent some hands on board, and in a little time after they came on board the Revenge with Captain Mainwaring. The Attorney General, were all the prisoners on board Mainwaring's sloop, or had they all their arms ready when Mainwaring was taken? Pell, I cannot say that they were all on board, but they had all their arms ready. Judge Trott, did they all appear forward and active? Did none of them show themselves dissatisfied or unwilling to act at that time? Pell, no, I don't know but one was as forward and as willing to act as the other. All of them had their arms ready. Judge Trott: Well, how did you proceed after Captain Manwaring was taken? Pell: Next day we hailed the schooner alongside of Captain Manwaring's sloop, and hoisted out several hogsheads of molasses, and put on board the schooner. Mr. Hepworth: What became of the schooner afterwards? Pell: After we put Reeve's wife on board and Captain Reed's son, we sent them on shore. The Attorney General: How long was Captain Manwaring a prisoner? Pell: About 10 weeks. The Attorney General: Was not there more goods taken out of Manwaring's sloop? What became of them? Did you not share them? Pell: Yes, we shared a little before we came to Cape Fear. The Attorney General: Did all the prisoners at the bar receive their shares? Pell: Yes, sir. I know nothing to the contrary. Judge Trott: They did not refuse their shares, none of them, did they? Pell: No. The Clerk: Have any of you any questions to ask the King's evidence? Robert Tucker: Have you any? Prisoner: No, sir. The Clerk: Edward Robinson: Have you? No, sir. Mr. Hepworth: May it please your honors, we will proceed to call another evidence. The Clerk: Call Captain Thomas Reed. Mr. Hepworth: Captain Reed, please to look upon the prisoners at the bar, if you know them. Reed: I know them all very well. Mr. Hepworth: Please to give an account of the court how you was taken, and also of the taking of Captain Manwaring. Reed: The sloop Revenge was at an anchor, and the schooner lay alongside of her. I was then a prisoner on board the sloop Revenge. In the evening, we saw a sloop coming into the bay, and Major Bonnet sent up 5 hands with the dory, and about an hour after they came on board the Revenge, and brought Captain Manwaring. After they brought him on board, Major Bonnet demanded his papers, and he gave them to him. He asked him from whence he came. He answered, from Antigua, and bound for Boston. He asked him what he had on board. He told him, but it being night, he said but little more to him. Next morning they brought the sloop and hailed alongside the schooner, and I saw them hoist out several hogsheads out of the sloop and put on board the schooner. And I heard Major Bonnet say the next day that there were 21 hogsheads, and that he had ordered pitch and tar to be put on board the sloop. And in the evening they took the foresail and mainsail of the schooner and sailed for Cape Fear. Judge Trott: You look upon all those men as belonging to Major Bonnet, and they were all active in the taking of Manwaring? Reed: I did not see but one acted as the other did. Judge Trott: You did not look upon them to be prisoners like you and your men? Reed: No, sir. Judge Trott: Did you know anything of their sharing? Did they take all their shares? Reed: I know nothing of that, for we were all in the roundhouse, and were not admitted among them at that time. Mr. Dean: Did you see them have their shares, each of them? Reed: I will not say that I saw them have every man his particular share, but they were all together when they did share. The Clerk: Would any of you ask the King's evidence any question? Prisoners: We desired nothing but that he would speak the truth. Mr. Hepworth: May it please your honors, we shall proceed to call another evidence, which is Captain Peter Manwaring. The Clerk: Call Captain Peter Manwaring. Mr. Hepworth: Captain Manwaring, do you know the prisoners at the bar? Manwaring: I know them very well. Mr. Hepworth: Please to give the court an account of your being taken by them. Manwaring: When they came on board us, we were at an anchor. About 8 or 9 o'clock in the evening, we saw the canoe coming. I ordered my man to hail them. He asked from whence they came and what sloops they were. They answered, Captain Thomas Richards from St. Thomas's, and Captain Reed from Philadelphia. So we were glad to hear of it. so hoped all was well. But as soon as they came up the shrouds, they clapped all hands to their cutlasses. Then I saw we were taken, and I said, "Gentlemen, I hope, as you are Englishmen, you will be merciful, for you see we have nothing to defend ourselves." They told us they would if we were civil. So I was ordered on board the Revenge with 2 of their men. So when I came on board, Major Bonnet desired me to come under the awning. He demanded my papers. I gave them to him. So he told me I must lie as well as I could. Next day morning, Robert Tucker came to me and asked me what I had on board, and told me if I did not tell the truth, it should be the worse for me. I told him I had some molasses, sugar, and rum. Then he asked me concerning my passengers what money they had. I told him I never examined passengers what money they had. So then Major Bonnet ordered them to come and lie alongside the schooner. But what was done till then on board my sloop I cannot tell. But then they took out the molasses and the rum and put on board the schooner. The Attorney General. How did they behave themselves with respect to yourself afterwards? Mainwaring. They were civil to me, very civil, but they were all very brisk and merry, and had all things plentiful, and were making punch and drinking. The Clerk. Would any of you, the prisoners, ask the king's evidence any question? No. Mr. Hepworth. Please, your honors, we will proceed to call another evidence. The Clerk. Called James Killing, Captain Mainwaring's mate. Mr. Hepworth. Do you know the prisoners at the bar? Killing. Yes, sir, I know them all very well. Mr. Hepworth. Please to give the court an account of the taking Captain Mainwaring's sloop. Killing. The 31st of July between 9 and 10 of the clock. They are running a strong tide at ebb. We came to an anchor about 14 fathom of water near Cape James. In about half an hour's time, I perceived something like a canoe. So they came nearer. I said, "Here is a canoe a-coming. I wish they be friends." I hailed them and asked from whence they came. They said, "Captain Thomas Richards from St. Thomas's and Captain Thomas Reed from Pennsylvania." They asked me from whence we came. I told them from Antigua. They said, "We were welcome." I said they were welcome as far as I knew. So I ordered the men to hand down a rope to them. So soon as they came on board, they clapped their hands to their cutlasses. And I said, "We are taken." So they cursed and swore for a light. I ordered our people to get a light as soon as possible. So they ordered our captain immediately to go on board the Revenge, and accordingly was sent with 2 of their own hands. And I saw him no more that night. So when they came into the cabin, the first thing they began with was the pine apples, which they cut down with their cutlasses. They asked me if I would not come and eat along with them. I told them I had but little stomach to eat. They asked me why I looked so melancholy. I told them I looked as well as I could. They asked me what liquor I had on board. I told them some rum and sugar. So they made bowls of punch and went to drinking of the Pretender's health, and hoped to see him king of the English nation, then sung a song or 2. Next morning they ordered more hands on board the sloop, and so came and lay alongside the schooner. After that they hoisted out several hogsheads of molasses and several hogsheads of rum, and put on board the schooner, and took several barrels of pitch and tar and put on board the sloop. And I happened to go down into the cabin, and Robert Tucker came to me and told me I had no business there, but was better go forward and work among the rest of the men. So I went forward and asked who that was. They told me that was their father. In the after part of the day, 2 of Bonnet's men were ordered to the mast to be whipped, and I was threatened if I did not confess all I knew. Then Robert Tucker came to me and told me I must go along with them. I told him I was not fit for their turn, neither were my inclinations that way. After that, Major Bonnet himself came to me and told me I must either go on a maroon shore or go along with them, for he designed to take the sloop along with him. That evening between 8 and 9 we were ordered to set sail, but whither I knew not. So we sailed out that night, and I, being weary with the fatigue, went to sleep. And whether it was with the design or not, I cannot tell. But we fell to leeward of the Revenge, and in the morning Major Bonnet took the speaking trumpet, and told us if we did not keep closer, he would fire in upon us and sink us. So then we proceeded on our voyage till we came to Cape Fear. Judge Trot: have you done with your evidence? Killing? Yes. The Clerk: would any of you prisoners ask the king's evidence any question? No. Judge Trot: you, the prisoners at the bar, stand charged with felony and piracy, committed on a certain sloop belonging to Captain Peter Manwaring. The evidences have proved at home upon you. The boatswain tells what old offenders you were, and that you were with Thatch off this bar, and that you were at the taking several vessels after you left Topsail Inlet, and all the evidence proved the same, so that it appears all of you took up with this wicked course of life out of choice. Now what evidence have you to come in on your behalf, or what have you to say in your defense? Now is your time to speak what you have to say. The Clerk: Robert Tucker, what have you to say? Tucker: after Captain Thatch had taken what we had and left us, Major Bonnet came and told us that he was going to St. Thomas's for the Emperor's commission, if there was any to be had. Judge Trot: pray, if you were bound to St. Thomas's, what did you do at Cape of Virginia? What business had you there? Tucker: we had but little provision on board. Judge Trot: so you went and met with some by the way. The Clerk: Edward Robinson, what have you to say? Robinson: when Captain Thatch left us, it was on a maroon island, and Major Bonnet came and told me he was going to St. Thomas's and we might go with him. Judge Trot: was not you one of them that was off this bar with Thatch? Robinson: yes. Judge Trot: why did you not come on shore then? Robinson: I would have come on shore, but Captain Thatch would not give me leave. I was with Mr. Bragg, and I told him I would go on shore if I had liberty. Judge Trot: was you one of the 5 that came up to town? Robinson: no. The Clerk: Neil Paterson, what have you to say in defense of yourself? Paterson: Thatch came on board and carried away 14 of our best hands, and marooned 25 of us on an island, and Major Bonnet came and told us he was minded to go to St. Thomas's, and if there were any commissions from the Emperor, to get one, and go a privateering against the Spaniards, so I was willing to go with him. And when I was on board, he forced me to do what he pleased, for it was against my will. Judge Trot: did not Thatch carry away your money and what you had besides of goods? Paterson: yes. The Attorney General: was you not all ashore when you received the Act of Grace? Paterson: yes, sir. The Attorney General: why had you not continued ashore? Why did you join with Bonnet? Or who forced you to it? Paterson: but, sir, it was in a strange land, and I had no money, nor nothing left, and I was willing to do something to live. But it was against my will to go a-pirating. Judge Trot: if you were forced and took all the provisions, pray how did you come to share so much money and goods afterwards? You say Thatch carried away what you had before. Paterson: I could not hinder the rest from doing what they pleased, but it was contrary to my inclination. The Clerk: William Scot, what have you to say? Scot: when we left Topsail Inlet, it was to go to St. Thomas's, and I asked whether there was provisions on board. They told me there was enough, which was not above 10 or 11 barrels. Judge Trot: so you took it where you could find it, because you had it not of your own. But pray, what did you with so much molasses, which was neither fit to eat or drink? Scot: What I did was to keep me from perishing, but it was not in my power to hinder the rest. The clerk. Joe Bayley, what have you to say? Bayley. When Captain Thomas and Major Bonnet was ready to sail, I went aboard, and I asked whether they had provisions on board. They told me they had, but in a few days it was all spent, and then I was forced to do as the rest did. Judge Trott. But why did you not do as Captain Mainwaring and his men did? You see, they did not act as you did. Bayley. Captain Mainwaring was not taken then. Judge Trott. But how came you to join with them afterwards? And pray what made you fight against Colonel Brett when he came out with lawful authority to you? Bayley. We thought it had been a pirate. Judge Trott. And so one pirate might fight with another. But how could you think it was a pirate when he had King George's colors? The Attorney General. May it please your honors, and you, gentlemen of the jury, the evidence have plainly proved that all the prisoners at the bar were at the taking of Captain Mainwaring's sloop, that they all consented to, and all were active in it, and all received their shares, so that I think it hath been plainly proved home upon them. Judge Trott. Gentlemen of the jury, the prisoners at the bar all stand indicted for felony and piracy, committed on a sloop belonging to Captain Peter Mainwaring, as it is expressed in the indictment. The boatswain tells us what old offenders they were before they went to Topsail Inlet, that they were at the taking of no less than 13 vessels, and that in particular they were at the taking of Captain Mainwaring. Then comes Captain Reed, and he was taken before Captain Mainwaring, and was then a prisoner on board the pirate sloop, and he tells you they all appeared in arms, and that he did not look upon them as prisoners, or under constraint, but of the same company, and he tells you he saw them take Captain Mainwaring, and that he saw them take out the goods, as is mentioned in the indictment, out of Mainwaring's sloop. Then comes Captain Mainwaring himself, and he says all the goods mentioned in the indictment were taken out, and that they shared these goods among themselves. Then comes Killing, the mate, and he proves the same, and particularly Tucker. He was so forward that he told them if they did not tell the truth it should be the worse for them. And Paterson was so active that he was for having them brought to the gun to make them confess, and that all the rest had their arms ready, and all had their shares, so that I think the evidences have fully proved the indictment upon them, and that it is very plain and home against them. They plead, indeed, that they were forced and constrained to go, but give no proof of it. And therefore, what constraint any of them appears to be under, I shall leave to your considerations. Though I think the evidence is very plain and clear, yet I shall not pretend to direct your judgments. I shall only remark to you what the wise man saith, that he that justifieth the wicked, as well as he that condemneth the just, even both are an abomination to the Lord. And about 2 hours after the jury returned and gave in their verdict, the clerk, Gentlemen, answer to your names. Timothy Bellamy, here, etc. The clerk, are you all agreed of your verdict? The jury, yes. The clerk, who shall say for you? The jury, the foreman. The clerk, Robert Tucker, hold up thy hand. How say you? Is he guilty of the piracy whereof he stands indicted, or not guilty? The foreman, guilty. The clerk, what goods and chattels, etc. The foreman, none that we know of. The clerk, then hearken to your verdict as the court hath recorded it. You say that Robert Tucker is guilty of the piracy whereof he stands indicted, and that he had no goods or chattel, etc. The jury, yes. And the jury also found Edward Robinson, Neil Paterson, William Scot, and Joe Bayley guilty. The clerk, Marshal, look to your prisoners. The end of section 73. Section 74 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Smith, Carman, Thomas, Morrison, Livers, Booth, Hewet, and Levit for piracy. Charleston, South Carolina, 1718. October 30th. The court at once proceeded to the trial of John William Smith, Thomas Carman, John Thomas, William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, and John Levit. The indictment was the same as in the last case, viz., the piratically taking the sloop Francis and its cargo. The prisoners pleaded not guilty. The clerk: You, the prisoners at the bar, these good men that were called last and have here appeared, are those that shall pass between our sovereign lord the king and you, upon your lives and your deaths. Therefore, if you or any of you will challenge them, or any of them as they come to the book to be sworn, and before they be sworn you may, and you shall be heard. The jury were sworn, whose names are as followeth: Samuel Prelow, foreman; John Hodgson, Gerrard Van Bilson, Robert Harvey, Joshua Mariner, Thomas Fairchild, Henry Genelac, John Jeffers, Charles March, John Grimble, Benjamin Griffin, Joseph Massey. The evidence. The witnesses against the prisoners were Ignatius Pell, the boatswain, Captain Thomas Reed, Captain Peter Manwaring, and Mr. James Killing, his mate, who all gave the same evidence against these as against the others that were tried before. The clerk: Will any of you prisoners ask the king's evidence any questions? No. Judge Trott: You, the prisoners at the bar, you have heard how fully the witnesses have charged the facts upon you. Now what you have to say in your defense, I shall be ready to hear you. The clerk: John William Smith, if you have anything to say, you had the liberty to speak. Smith: When we left Topsail Inlet, I knew nothing but that we were going to St. Thomas's. But after we were out, they hoisted the bloody flag. But I did before believe we were going to St. Thomas's. The Attorney General: Did you bear arms on board of Major Bonnet? Smith: Yes, sir. The Attorney General: Was you at the taking all those vessels? Smith: Yes, sir, but it was against my will. The clerk: John Carman, what have you to say? Carman: As for what I did on board Captain Thatch, I was forced, but when I came to North Carolina I would not have went on board, but Major Bonnet showed me the act of grace, and when I entered myself on board, it was to get my bread in hopes to have went where I might have had business, for when we left Topsail Inlet, I had not signed the articles. Pell: But you gave the captain your word that you would. Carman: When I was left in the sloop, I endeavored to make my escape with the sloop. Judge Trott: So, I find you wanted a vessel of your own. Carman: No, but to have got one from them, but I could not. The Attorney General: This confirms what the king's evidence proves against them. The clerk: John Thomas, what have you to say? Thomas: We had nothing left us, and we were on a maroon island, and Major Bonnet, he came and told me I might go with him, but it was against my will to bear arms. Judge Trott: Was not you off this bar? Thomas: Yes, but I was forced to it. Mr. Hepworth: And was you not at the taking of Captain Manwaring's sloop? Thomas: Yes. Mr. Hepworth: And had you not your share? Thomas: Yes, sir. Judge Trott: And yet you say you was not willing to go a-pirating. The clerk. William Morrison, what have you to say? Morrison. Captain Thatch had run the sloop ashore, and Major Bonnet went up to the governor for the act of grace. And when he returned, he told me I might go to St. Thomas's. And after that, he said provisions would fall short, and he should go on the coast of Virginia to see for some. Judge Trott. But what was that your manner of going for a commission to take 13 vessels by the way? But was you not at the taking man-wearing sloop, and had you not your share? The clerk. William Livers, alias Evis, what have you to say? Evis. After we came to North Carolina and Captain Thatch had lost the ship, Major Bonnet told me he would give me my passage to St. Thomas's, and he would endeavor to get a ship there, and I might go with him a privateering. But when he came to sea, I found how it was, and I would not consent for a long time, but at last they forced me to it. Judge Trott. But you had your share as well as the rest? Evis. They forced me to do what I did. The clerk. Samuel Booth, what have you to say? Booth. As we came from Topsail Inlet, we met with the sloop Revenge. They boarded us and took us that I was a prisoner 3 weeks before I consented, and then they ordered me to the gun before I would consent. Judge Trott. But you had your share of Captain Man-wearing sloop. Booth. But my inclination was not that way. The clerk. William Hewet, what have you to say? Hewet. I designed to go to St. Thomas's with Major Bonnet, where he told me he was bound thither, so I was willing to go with him. The clerk. John Levit, what have you to say? Nothing. The Attorney General. May it please your honors, the boatswain and all the evidences prove the indictment upon each of the prisoners, that they were all at the taking of Captain Man-wearing sloop, and all had their shares. Judge Trott. Gentlemen of the jury, I think I need say but little on this matter. They all confess the fact of which they stand indicted. Some of them were all defenders, and all of them were proved to be at the taking of Captain Man-wearing sloop, and all took their shares, so that I think the fact is very fully and clearly proved upon them. But I shall leave that to your considerations, and I pray God direct you to give a true verdict. The jury found John William Smith, Thomas Carman, John Thomas, William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, and John Levit guilty. End of section 74. Section 75 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Eddy, Annand, Ross, Dunkin, Nichols, Ridge, King, Perry, and Virgin for piracy. Charleston, South Carolina, 1718. October 31st. Today were arraigned upon the same charges as in the two former cases. William Eddy, alias Nettie, Alexander Annand, George Ross, George Dunkin, Thomas Nichols, John Ridge, Matthew King, Daniel Perry, and Henry Virgin. They pleaded not guilty. The same jury was sworn as in the former case. The evidence: Ignatius Pell, the boatswain, Captain Thomas Reed, Captain Peter Man-wearing, and James Killing, the mate, gave the same evidence as in the former case against all the prisoners except Thomas Nichols. Captain John Stevenson. George Ross, the gunner of the pirate sloop, was for blowing it up, and acknowledged that he would have set fire to the tram if he could. Ignatius Pell. Nichols, after he came to sea, was very much discontented, but Major Bonnet said he would force him to go. He did not join with the rest of the men, but was always separated himself from the company. Captain Reed. Nichols behaved different from the rest and did not join with them. Captain Manwaring. Nichols, when he was aboard my sloop, said he did hope it would be over with him in a little time, for he hoped to get clear of them. He looked melancholy and never joined with the rest in their cabals when they were drinking. When Major Bonnet sent for him, he refused to go and said he would die before he would fight. Nichols, Mr. Killing, did you never hear me say I would lead that course of life? Judge Trott, did you hear him say so? Killing, when he came on board, he said to me he would give the whole world if he had it to be free from them. He refused to go on the Revenge until he was forced, and then told me he would not fight if he did lose his life for it. He was not with them when they shared, and did not join their cabals. Judge Trott, he seems to be under constraint, indeed, and therefore must be taken into consideration. The Clerk, William Eddy, alias Needy, what have you to say? Needy, I never was on board Captain Manwaring's sloop, nor had no hand in it. Judge Trott, you was one of Bonnet's crew. Needy, I never acted in it. Judge Trott, that is no excuse. It is not such or such a one that goes on board only but those that stand ready to assist them, have as great a hand in the fact as the other. For men would not be taken by 2 or 3 if they had no more help, so that the whole crew are equally concerned at such a time. The Clerk, Alexander Annand, what have you to say? Annand, when we were at Topsail Inlet, Major Bonnet told me he would go and get a clearance with the sloop, for he designed to go to St. Thomas's for a commission, and I might go with him. So I expected nothing till we were out at sea, and that I could not help it. Judge Trott, but why did you not declare against it then, and so not join with them? Annand, I was but one man and a stranger, and was afraid I should lost my life. The Clerk, George Ross, what have you to say? Ross, I belonged to a sloop, and we met with Major Bonnet and was taken by him. Next day 2 of the men told me I must go with them. I answered them, no, I did not design to leave the sloop, but they told me I must, and they told me if I would but consent I should have anything, and a little after Captain Manwaring was taken. Judge Trott, and you had your share of Manwaring's goods? Ross, yes. Judge Trott, so, though you were unwilling at first, you was willing afterward, and also fought Colonel Rhett when he came out against you. Ross, they told me it was Captain Thatch. For my part, I did not know who Thatch was. Judge Trott, but pray what authority had you to fight anybody? The Clerk, George Dunkin, you may speak what you have to say. Dunkin, after we were taken at the Capes, Major Bonnet came to me and told me I must go along with him, but I told him I could not lead the vessel. He told me I must. Judge Trott, but why did you join with them afterwards in taking your share of Manwaring's goods? And why did you fight Colonel Rhett and his men? If you had not fought, you might have saved the lives of 12 or 14 men. Dunkin, Major Bonnet declared if anyone refused to fight, he would blow his brains out. The Clerk, John Ridge, what have you to say? Ridge, after we came to Topsail Inlet, and the ship was lost, Major Bonnet came and told me that he would go and accept the Act of Grace, and get a clearing for the sloop, and go to St. Thomas's for a commission, and he expected we would go with him. So when he was gone up to the country, we rigged the sloop. So the quartermaster, the boatswain, and he agreed together. But for my part, I knew nothing what their design was. And so the first vessel we saw they took. But it was my resolution to go away by the first opportunity. The Clerk, Matthew King, what have you to say? King, when we were at Topsail Inlet, Captain Thatch marooned us on an island and left us, and Major Bonnet told us he would go to St. Thomas's, but the first prize we met with, we took, having but little provisions on board. Judge Trott: how could you think of going to St. Thomas's without provisions? The Attorney General: but the boatswain says there were provisions on board, and several barrels of flour and several barrels of beef and pork. Judge Trott: what need had you, then, to go a-pirating? King: I did not know it till we were out. Judge Trott: Bonnet had not about 5 hands, and there were of you 25. Why would you all be commanded by them? You had no need to yield to them. The Clerk: Daniel Perry, what have you to say? Perry: when Captain Thatcher left us, it was on a maroon island, and Major Bonnet came and told us he had the Act of Grace, and so we might go with him. Judge Trott: is that all you have to say? You knew Thatcher and Bonnet were both pirates, and why would you go with them again? The Clerk: Henry Virgin, what have you to say? Virgin: Major Bonnet ordered about 30 hands to be ready, and in a little time we were ordered on board, and when we were about 100 leagues from land, he asked if there were any that would go marooning, and I believe there were 2 or 3 that promised him they would, though I did not. Judge Trott: but had you no opportunity to come from them? Virgin: if we had known anything of the Act of Grace when we were off this bar, we had come ashore. I went to make my escape and leaped into the water, and had like to have been drowned. Judge Trott: how many vessels have you been at the taking and burning up, do you think? Virgin: I believe about 3. Mr. Hepworth: he was with them at the Bay of Honduras and all along. Virgin: but I never gave my consent. The Captain Thatch never asked any of us. Judge Trott: would any of the prisoners say any more? If they will, I am ready to hear them. The Attorney General: may it please your honors and you, gentlemen of the jury, these 3, Nichols, Dunkin, and Ridge, seem to make some defense. As for Nichols, he was with them when Mainwaring was taken, and the mate tells us that he separated himself from the rest of the cabal, and when they shared, he told them they might do as they pleased with his share, for he hoped he should not be with them long. So that it appears that he separated himself from the rest of the company from the very first. These things, therefore, ought to be considered. And as for Duncan, he looked upon himself as a prisoner at first, but the boatswain indeed says he had his shares. And as for Ridge, he said that he resolved to make his escape. For all the rest, they seem to be equally guilty. Judge Trott: gentlemen of the jury, the prisoners at the bar stand indicted for felony and piracy, committed on a sloop belonging to Captain Peter Mainwaring, commander. And not only did they break and board the said Mainwaring sloop, which was an act of piracy, but it hath been proved upon them that they were at the taking of 13 vessels after they left Topsail Inlet. Indeed, there are 3 that have something to say in their defense: Nichols, Ridge, and Duncan. As for Duncan, Pell says he had his share, as the rest had. Captain Reed looked upon him as a prisoner, but Captain Mainwaring did not. As for Ridge, he was at North Carolina and took up with Bonnet to go to St. Thomas's, and it is possible for a man to be deceived. But Pell declares that they were bound to St. Thomas's at first, and Killing, the mate, declared that he told him he would free him himself from that course of life the first opportunity. So I shall leave this to your consideration. But for Nichols, I think it is plain he was under constraint and force. For Pell himself declares that he would have nothing to do with their shares, and he did hope that he should not be long with them. Captain Mainwaring and Mr. Killing, his mate, all confirmed the same, and when he was sent for to come on board Bonnet, to go out to fight Colonel Rhett, he refused to go, and when he was forced to go on board, he said he would die before he would fight, and accordingly went into the hole, and did not fight Colonel Rhett. so that by the whole course of the evidence I think it is very clear that he was under constraint and fear. As to the rest, I think the proof is full against them, but I shall leave them to your consideration. You know that as the innocent must not be condemned, so the guilty ought not to be acquitted. Remember, you have the lives of these persons in your hands, and I pray God direct you to give a true verdict. The jury found William Eddy, alias Needy, Alexander Annand, George Ross, George Dunkin, John Ridge, Matthew King, Daniel Perry, and Henry Virgin guilty, and Thomas Nichols not guilty. End of section 75.
Section 76 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Stacy M. American State Trials, Volume 4, by John D. Lawson. Trial of Robbins, Mullet, Price, Lopez, and Long for piracy. Charleston, South Carolina, 1718, October 31. Upon the same charge as in the last three cases, the following were arraigned and pleaded not guilty: James Robbins, alias Rattle, James Mullet, alias Millet, Thomas Price, and John Lopez. Zachariah Long pleaded guilty. The following jurors were sworn: Samuel Priolo, foreman; John Hodgson, Garrett Van Velsen, Lucas Stoutenborough, Joshua Mariner, Thomas Fairchild, Henry Genelac, John Jeffers, Charles Marsh, John Grimble, Benjamin Griffin, Joseph Massey. The evidence. The witnesses against the prisoners were Ignatius Pell, the boatswain, Captain Thomas Reed, Captain Peter Manwaring, and Mr. James Killing, his mate. All gave the same evidence against these prisoners as against the others that were tried before. The clerk. You, the prisoners at the bar, have heard what the king's evidence have sworn against you. Now is your time to make your defense. James Robbins, what have you to say? Robbins. I was on board the Revenge, and then I was sent on board of Captain Reed's sloop, and was there 4 days, and then was sent on board the Revenge again, for I was about to run away if I had an opportunity. The clerk. James Mullet, what have you to say? Mullet. When we left Topsail Inlet, it was to go to St. Thomas. So Major Bonnet told me, and I being on a maroon shore, I was willing to go with him. The clerk. Thomas Price, what have you to say? Price. Captain Thatch left us on a maroon shore, and had nothing left, and Major Bonnet told me I might go with him to St. Thomas, but I designed not to go a-pirating. Judge Trot. Have you know your share? Price. I was forced to do as I did when I was on board. The clerk. John Lopez, what have you to say? Lopez. I was at the Bay of Honduras, and was taken by Thatch and carried to Topsail Inlet, and there he marooned me on an island, and came away with 5 hands, and carried all away that we had, and left us. And Major Bonnet told me he would go to St. Thomas, and I might go along with him. I told Captain Manwaring I would not go a-pirating, for I did not like it. Judge Trot. Did you not share a little before you came to Cape Fear? Lopez. Yes, but it was against my will. Judge Trot. Captain Manwaring, do you know anything of this man? Captain Manwaring. All as I know, he told me he had a wife and children, and that he did not like that course of life. This is all I can say of him. The clerk. Zachariah Long, what have you to say? Long. When we sailed, I knew nothing but that it was to go to St. Thomas till afterwards, and then I must do as the rest did. The judge summed up the evidence to the jury, which retired and returned into court with the verdict of guilty against Mullet, Price, Lopez, and Long, and a verdict of not guilty as to Robbins, alias Rattles. End of section 76.
Section 77 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials Volume 4 by John D. Lawson. Trial of Robinson, Tucker, Scot, Bayley, Paterson, Smith, Carman, and Thomas for piracy. South Carolina, 1718. November 1st. The court proceeded to arraign Edward Robinson, Robert Tucker, William Scot, Job Bayley, Neil Paterson, John William Smith, Thomas Carman, and John Thomas on an indictment charging them with sporadically seizing a ship called the Fortune, Thomas Reed commander, and taking from it certain goods and chattels, including money. Footnote. The jurors for our sovereign lord the king do upon their oath present that Stede Bonnet, alias Edwards, alias Thomas, late at the island of Barbados, mariner; David Hewet, late of the island of Jamaica, mariner; William Scot, late of Aberdeen, mariner; Job Bayley, late of London, mariner; Edward Robinson, late of Newcastle upon Tyne, mariner; Robert Tucker, late of the island of Jamaica, mariner; Neil Paterson, late of Aberdeen, mariner; John William Smith, later of Charleston, mariner; Thomas Carman, late of Maidstone in Kent, mariner; and John Thomas, late of the island of Jamaica, Maryland. The 31st of August in the 5th year of the reign of our sovereign Lord George, by the grace of God of Great Britain, France, and Ireland, King, Defender of the Faith, etc., by force and arms, etc., upon the high sea, in a certain place called Cape Fear, in the latitude of 34 degrees or thereabouts, and within the jurisdiction of the court of the Vice Admiralty of the province of South Carolina, did piratically and feloniously set upon, board, break, and enter a certain merchant sloop called the Fortune, Thomas Reed commander, then being a sloop of certain persons to the jurors aforesaid unknown, and then and there piratically and feloniously did make an assault in and upon the said Thomas Reed, and other his mariners, whose names to the jurors aforesaid are unknown, in the same sloop, against the peace of God and of our new sovereign, Lord the King, then and there, being piratically and feloniously did put the aforesaid Thomas Reed and others his mariners of the same sloop, in the sloop aforesaid, and being in corporal fear of their lives, then and there in the sloop aforesaid, upon the high sea, in the place aforesaid, called Cape Fear, in the latitude of 34 degrees, or thereabouts aforesaid, in the sloop aforesaid, and within the jurisdiction aforesaid, piratically and feloniously did steal, take, and carry away 6 tierces of bread, of the value of 13 pounds, current money of Pennsylvania; 4 barrels of bread of the value of 4 pounds, like current money of Pennsylvania; 1 barrel of linseed oil, of the value of 7 pounds, like current money of Pennsylvania; 2 tierces of hams, of the value of 20 pounds, like current money of Pennsylvania, and of 20 barrels of flour of the value of 20 pounds, like current money in Pennsylvania; 6 china plates of the value of 3 pounds, like current money of Pennsylvania; 7 iron-bound blocks of the value of 40 shillings, like current money of Pennsylvania; 90 fathoms of rigging of the value of 3 pounds, like current money of Pennsylvania; the said pump with boxes and brakes of the value of 20 shillings, like current money of Pennsylvania; the goods and chattels of certain persons to the juries aforesaid unknown, then and there upon the high sea aforesaid, in the aforesaid place called Cape Fear, in the latitude of 34 degrees or thereabouts, aforesaid, in the sloop aforesaid, and within the jurisdiction aforesaid, being found in the aforesaid sloop in the custody and possession of the said Thomas Reed, and others his mariners in the same sloop, from the said Thomas Reed, and others his mariners of the same sloop, and from their custody and possession then and there, upon the high seas aforesaid, in the place aforesaid, called Cape Fear, in the latitude of 34 degrees or thereabouts, as aforesaid, in the sloop aforesaid, and with the jurisdiction aforesaid, and against the peace of our said now sovereign Lord the King, his crown and dignity, etc. End of footnote. All pleaded not guilty. The jury were sworn as follows: Timothy Bellamy, foreman; George Duckett, John Rivers, William Sheriff, Benjamin Dennis, Hugh Durfee, Thomas Chambers, Daniel Townsend, John Lee, Thomas B., John Barton, Richard Fairchild. The evidence. The clerk. Call Ignatius Pell, the boatswain. Mr. Hepworth, do you know the prisoners at the bar? Pell. Yes, sir. Mr. Hepworth, give the court an account of the taking Captain Thomas Reed and plundering of his sloop. Pell. Captain Reed was in company with 2 vessels more, which we took, but did not share till we came to Cape Fear. Mr. Hepworth, were the goods mentioned in the indictment taken out? Pell. Yes, sir. Judge Trott, did all the prisoners at the bar receive their shares? Pell. Yes. The clerk, will any of you ask the King's evidence any questions? Edward Robinson, will you ask any questions? Robinson. Boatswain, do you not remember when we left Topsail Inlet? It was with the design to go to St. Thomas's? Pell. I do believe you might think we were going to St. Thomas's, but the first vessel we saw we consented to take, and you had your share as well as the rest. The clerk. Robert Tucker, will you ask any question? Tucker. No. Mr. Hepworth, may it please your honors, we will proceed to call another evidence, Captain Peter Mainwaring. Mr. Hepworth, do you know the prisoners at the bar? Mainwaring, I know them all. Mr. Hepworth, please to give the court an account of the sharing of Captain Reed's goods at Cape Fear. Mainwaring, as for taking of Captain Reed, I can say nothing, because he was taken by them before I was taken. But when we came to Cape Fear, they shared what they had. Judge Trott, and had all the prisoners at the bar their shares? Mainwaring, I did not see any of them refuse, and they were amongst the rest when they did share. The clerk, will any of you ask the evidence any questions? The prisoners ask no questions. Mr. Hepworth, we will proceed to call another evidence. Captain Thomas Reed, do you know the prisoners at the bar? Reed, I know them all. Mr. Hepworth, please to give the court an account of your being taken and plundered by them. Reed, after we were taken, Robert Tucker with some others came on board, and then we sailed to Cape Inhopen, where Captain Mainwaring was taken, and after that to Cape Fear. Mr. Hepworth, were those goods taken out, as are mentioned in the indictment? Reed, yes, sir. Judge Trott, did all the prisoners receive their shares? Reed, yes, I did not see but what they did. They were all together when they shared. The clerk, will any of you ask the evidence any questions? Robinson, Captain Reed, when did you see me on board your sloop? Reed, I cannot say I saw you on board, but you were with them when they shared. Judge Trott, if you were not on board the sloop, you was one of the crew. And as I told you before, it is not they only are pirates that go on board of a vessel, but they who stand ready to assist are as much pirates as the other, and are as much concerned in the fact. The clerk, will any of you ask any questions? Prisoners, no. Mr. Hepworth, we will proceed to call another evidence. James Killing, do you know the prisoners at the bar? Killing, yes, sir. Mr. Hepworth, give the court an account of what you know of the taking of Captain Reed. Killing, I can say but little to the matter till we came to Cape Fear, and there they shared the goods. Judge Trott, did you see the goods taken out? Killing, I cannot say I saw them all taken out, but I saw them a sharing of them together. Mr. Hepworth, we will call another evidence. Francis Griffin, Captain Reed's mate. Mr. Hepworth, do you know the prisoners at the bar? Griffin, yes, sir. Mr. Hepworth, please to give an account of the taking of the sloop you belong to. Griffin, after we were taken, Tucker and some more came on board, and Tucker fell to beating and cutting the people with his cutlass, and cut one man's arm. So then we went to Cape James, alias Cape Inlopen, where Captain Mainwaring was taken, and thence we sailed to Cape Fear. Mr. Hepworth, were all these goods mentioned in the indictment taken out? That part of the indictment read. Griffin, yes, sir. Judge Trott, did all the prisoners take their shares? Griffin, I know nothing to the contrary. The clerk, will any of you ask the king's evidence any questions? No questions asked. Judge Trott, you, the prisoners at the bar, what have you to say in your defenses? I am now ready to hear you. The clerk, Edward Robinson, what have you to say? Robinson, I have nothing to say more than what I have said. The clerk, Robert Tucker, what have you to say? Tucker, I knew nothing but we were going to St. Thomas's when I engaged with Major Bonnet. Judge Trott, you was his quartermaster, and you was the person that cut the man with the cutlass and abused people. The clerk, William Scot, what have you to say? Scot, I was never on board, Captain Reed. Judge Trott, you was never on board? What of that? You was one of the crew, and consented to it, and had your share. The clerk, Joe Bayley and Neil Paterson, what have you to say? Prisoners, we have nothing more to say. The clerk, John William Smith, what have you to say? Smith, it was never my design to go a-pirating, and when I was at sea I could not help what others did. Judge Trott, if it was not your design at first, you afterwards consented to it. The clerk, Thomas Carman and John Thomas, what have either of you to say? Prisoners, we have no more to say than what we have said. The Attorney General, may it please your honors, I think the evidence have plainly proved the prisoners at the bar guilty of the fact charged upon them in the indictment, so that they were all equally guilty. Judge Trott, gentlemen of the jury, the prisoners at the bar stand indicted for felony and piracy, committed on a sloop belonging to Captain Thomas Reed. All the evidence has fully proved the fact upon them, that they were all equally guilty, and all shared in the goods and plunder. But Tucker abused the people, cut one man with his cutlass, so that he added barbarity to his other crimes. They all pretend they were under force and constraint, but it is but a suggestion of their own without the least proof. But there is full proof of their consenting. But I shall leave them to your consideration. But the case is so clear that I believe you will not be long before you return with your verdict. The jury, after they had considered of their verdict, returned, and found Edward Robinson, Robert Tucker, William Scott, Joe Bayley, Neil Paterson, John William Smith, Thomas Carman, and John Thomas guilty. End of section 77. Section 78 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Morrison, Livers, Booth, Hewet, Levit, Eddy, Annand, Ross, Dunkin, and Nichols for piracy. South Carolina, 1718. November 1st. The court proceeded to arraign William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, John Levit, William Eddy, alias Neddy, Alexander Annand, George Ross, George Dunkin, and Thomas Nichols upon the indictment in the former trial. All pleaded not guilty, excepting John Levit, who pleaded guilty. The jury were sworn. Thomas Bellamy, foreman, etc. The evidence. Ignatius Pell and the rest of the witnesses in general gave the same evidence against these prisoners as against the former ones, only they were more particularly examined as to Thomas Nichols and George Dunkin. Mr. Hepworth. Pell. Do you know the prisoners at the bar? Pell. Yes, sir, I know them all very well. The Attorney General. Please to give the court an account of the taking and plundering Captain Reed, and begin with Nichols. Pell. Thomas Nichols was very much dissatisfied on board, and did not join with the rest of the company, and would not take the share, and said he hoped he should not continue long with them. The foreman. Do you know anything of Dunkin? How did he behave himself? Pell. I did not see, but he was as active as any of the rest, and took a share as the rest did at Cape Fear. Judge Trott. And had all the prisoners their shares? Pell. Yes, excepting Nichols. Judge Trott. Were the goods mentioned in the indictment taken out of Reed's sloop? Pell. Yes. The clerk. Will any of you ask the king's evidence any questions? No questions asked by the prisoners. Mr. Hepworth. We will proceed to call another evidence. Captain Manwaring. Do you know the prisoners at the bar? Manwaring. I know them all very well. Mr. Hepworth. Please to give the court an account of their share in Captain Reed's goods at Cape Fear, and particularly how Nichols behaved himself. Manwaring. When Nichols was on board my sloop, he said several times he would get clear of them the first opportunity, and he hoped it would not be long first. And when Major Bonnet sent for all hands on board the Revenge, he refused to go till he sent word if he would not come he would make him. And when he went, he said before he would fight he would die. And he always kept himself from the company and from their cabals. Judge Trott. Do you know anything of Dunkin? Manwaring. What I can say is, there was some brown bread upon deck, and he said it was fit for nothing but negroes to eat, and I told him I wished he might never want it. So they went and brought some white out of the hole. Mr. Hepworth. How did he behave himself? Manwaring. I saw nothing but he was as the rest were. Mr. Hepworth. Would any of you ask the king's evidence any questions? No questions asked by the prisoners. Mr. Hepworth. Please, your honors, we proceed to call another evidence. James Killing. Mr. Hepworth. Do you know the prisoners at the bar? Killing. I know them all very well. Mr. Hepworth. Please to give the court an account of what you know of their taking and plundering Captain Reed, and first begin with Nichols. Killing. I remember when he was on board our sloop and Major Bonnet sent for him. When he went off, he said he hoped to get clear of them, and he would die before he would fight. Judge Trott. Pell. Do you know whether he did fight Colonel Rhett or not? Pell. He did not fight, and if one that Major Bonnet loved very well had not been shot down by his side, he had blowed his brains out, for he had his pistol ready. Mr. Hepworth. How did Dunkin behave himself? Pell. I can say nothing for any of the rest, but that they were all as one, and had all their shares. The clerk. Would any of you ask the king's evidence any questions? No questions asked by the prisoners. Mr. Hepworth. We will proceed to call another evidence. Captain Thomas Reed. Do you know the prisoners at the bar? Reed. I know them all very well. Mr. Hepworth. Please to give the court an account of what goods were taken from you and how the prisoners behaved themselves, and first of Nichols. Reed. The most of the time he was on board Captain Manwaring's sloop. I heard him say he did not like that course of life, and the last words I heard Major Bonnet say to him was that he would force no man to go against his will. Judge Trott, can you say anything of Dunkin? Reed, as for Dunkin, I did not see, but he acted as the rest did. Dunkin, Captain Reed, it was against my will. Mr. Hepworth, Captain Reed, were these goods taken out of you, as you mentioned at the indictment? That part of the indictment read, were all these goods taken out? Reed, yes. The clerk, will any of you ask any questions? George Dunkin, will you ask any questions? Dunkin, Captain Reed, when did you see me as active as any of the rest? Reed, before Captain Mainwaring was taken, I thought you had been a prisoner, but afterwards I saw no difference. Judge Trott, you was one of Bonnet's crew, one of that company. Mr. Hepworth, we proceed to call another evidence, Francis Griffin, Captain Reed's mate. Mr. Hepworth, do you know the prisoners at the bar? Griffin, I know them all well. Mr. Hepworth, give an account of what you know of Nichols and the rest of the prisoners. Griffin, as for Nichols, he was a man I know nothing of, he being on board of Mainwaring's sloop. Mr. Hepworth, what do you know of Dunkin? Griffin, I knew nothing of him till we would come to Cape Fear, and I saw no difference, but he shared among the rest. Mr. Hepworth, were those goods taken out of the sloop the goods mentioned in the indictment? Griffin, yes, sir. Judge Trott, now, you prisoners, what you have to say in your defense I shall be ready to hear. The clerk, William Morrison, what have you to say? Morrison, I have no more to say than I have already said. The clerk, William Livers, alias Evis, what have you to say? Evis, nothing more. The clerk, Samuel Booth. Booth, when I went on board Major Bonnet, it was to go to St. Thomas's with him. Judge Trott, why had you not continued at North Carolina since you could not continue here? Booth, I thought to have had better business there. The clerk, John Levit, William Eddy, alias Neddy, Alexander Annand. Prisoners, we were forced to go and did not know what they would do. The Attorney General, but did you not know what you did when you shared? You knew that did not belong to you, did you not? The clerk, George Ross, George Dunkin, Thomas Nichols asked no questions. Only Dunkin delivered in a paper, which was read in court and contained a testimony of his former behavior, one in Scotland. The Attorney General, please, your honors, and you, gentlemen of the jury, I think it appears from the evidence that Nichols was under constraint and forced. As for Dunkin and the rest, they all took their shares at Cape Fear. Judge Trott, gentlemen of the jury, the prisoners stand indicted for felony and piracy committed on a sloop belonging to Captain Thomas Reed. As for Nichols, Pell says that he was not joined to the company and said, as for his share, they might do what they pleased, for he hoped he should not be with them long. And when Major Bonnet sent for him on board, he refused to fight Colonel Brett, and if another had not been killed, Major Bonnet had blown his brains out. Captain Mainwaring says he refused his share and kept himself from the company and from their cabals, and he said, when sent for on board, that he would die before he would fight. And Captain Reed says that Major Bonnet said that he would put him ashore, but he would force no man against his will. And Killing says that he told him that he would not fight Colonel Brett when Major Bonnet sent for him on board the Revenge, so that I think it plainly appears he was under constraint. But for Dunkin, he says of himself indeed that he was a prisoner and under constraint, but Pell says he was not, and that he took his share and was as the rest were. And Captain Mainwaring says that he complained of the bread that was fit for none but Negroes. So I shall leave you to consider that. As for the rest, they have but little to say in their defense, and I think the evidence have proved the fact fully upon them. But I shall leave this to your consideration. And remember, you have the lives of these persons in your hands. The jury, After they had considered of their verdict, returned and found William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, William Eddy, alias Nettie, Alexander Annand, George Ross, and George Dunkin, guilty, and Thomas Nichols, not guilty. November 3rd. Today the court proceeded to arraign John Ridge, Matthew King, Daniel Perry, Henry Virgin, James Robbins, alias Rattle, James Mullet, alias Millet, Thomas Price, James Wilson, John Lopez, and Zachariah Long, upon a similar indictment for taking Captain Reed in the ship. Ridge, King, Virgin, Robbins, alias Rattle, Mullet, alias Millet, Price, Lopez, and Long pleaded not guilty. Daniel Perry and James Wilson pleaded guilty. The jury: Samuel Prolo, foreman; John Hodgson, Garrett Van Villen, Lucas Stoutenborough, Joshua Mariner, Thomas Fairchild, Henry Ganalack, Benjamin Griffin, Charles March, John Grimble, Nicholas Stevens, William Harvey. The witnesses against the prisoner were the same as in the former cases, and the jury found them all guilty. End of section 78. Section 79 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Brierly, Boyd, Sharp, Clarke, and Gerrard for piracy. South Carolina, 1718, Part 1. November 3rd. The grand jury returned an indictment against John Brierly, alias Timberhead, Robert Boyd, Roland Sharp, Jonathan Clarke, and Thomas Gerrard, for feloniously and piratically entering the sloop Francis, belonging to Captain Peter Manwaring, the commander, and taking certain goods out of the same at Cape Fear. And another indictment against the same persons for feloniously and piratically entering the sloop Fortune, belonging to Captain Thomas Reed, commander, and taking certain goods out of the same at Cape Fear. Then the court proceeded to arraign the said John Brierly, alias Timberhead, Robert Boyd, Roland Sharp, Jonathan Clarke, and Thomas Gerrard, upon the first indictment, to which indictment they all pleaded not guilty. The following jurors were sworn: Timothy Bellamy, foreman; George Duckett, John Rivers, William Sharif, Benjamin Dennis, Hugh Durfee, Thomas Chambers, Thomas Townsend, John Lee, Thomas B., John Barton, and Richard Fairchild. The evidence: the clerk, Carl Ignatius Pell. Mr. Hepworth: Pell, do you know the prisoners at the bar? Pell: I know them all very well. Mr. Hepworth: please to give an account of what you know of their behavior at Cape Fear. Pell: John Brierly and Robert Boyd came on board 3 or 4 days after we came to Cape Fear. Judge Trott: you took them first, did you not? Pell: yes, we sent off our dory and took them. Judge Trott: from whence did they come? Pell: from North Carolina. The Attorney General: how long after they came on board did they join themselves to the company? Pell: Brierly did very soon, but Boyd did not so soon, though he did afterwards. And for Sharp, I do not know that ever he was joined to the company. Judge Trott: and how did Clarke behave himself? Pell: Jonathan Clarke and one came in from South Carolina. They went away from the sloop, and then after some days Clarke returned again, but it was with hunger, though he said then it was not. The Attorney General: were there any goods taken out of Captain Reed's sloop after he had joined himself a second time? Pell: I cannot say that certainly. Judge Trott: nor you cannot say positively there were? Pell: no. Mr. Hepworth: what do you know of Gerrard? Pell: I can see nothing to him. The clerk, will any of you ask the evidence any questions? John Brierly, will you ask any questions? Brierly, Pell, you know I often said I would not bear arms, and I desired no share. Pell, but John, you know you had your arms ready as well as the rest, and that you had your share. The clerk, Robert Boyd, will you ask any questions? Boyd, no, sir. The clerk, Roland Sharp, will you? Sharp, no, sir. The clerk, Jonathan Clarke, will you ask any questions? Clarke, Pell, do not you remember that I was abaft, and one of the negroes came and damned me, and asked me what I did there, why I did not go and work amongst the rest, and told me I should be used as a negro? Pell, I do remember it was so. Mr. Hepworth, we proceed to call another evidence, Captain Thomas Reed. The Attorney General, Captain Reed, please to begin with Brierly. Reed, Brierly came on board one morning very early and helped to take out several goods. Mr. Hepworth, do you know what goods? Reed, some rum and sugar. Judge Trott, do you know those goods to be taken out? Reed, yes. Judge Trott, how did he behave himself when Major Bonnet sent for him aboard to fight Colonel Brett? Reed, I cannot tell. Mr. Hepworth, how did Boyd behave himself? Reed, I took him to be a prisoner like myself at first, till he was sent for on board the Revenge by Major Bonnet to fight Colonel Brett. The Attorney General, what made you think he was a prisoner? Reed, because he was not employed in any business as the rest were. Judge Trott, that day they engaged Colonel Brett. Was he on board your sloop? Reed, yes, and Major Bonnet sent for all hands on board the Revenge. The Attorney General, what do you say of Sharp? Reed, I can say nothing of him. The Attorney General, what have you to say of Clarke? Reed, he ran away for a time and then he returned again after some days. The Attorney General, was there any goods taken out after he returned? Reed, yes, sir. Judge Trott, did Clarke himself take out those goods? Reed, that I cannot tell. As for Gerrard, he belonged to Captain Manwaring as the captain and I was together. He came and told us how they used him, but he was sorry for what he had done, and was resolved to make his escape the first opportunity he had to get away. The clerk, have any of you any questions to ask the king's evidence? The prisoners ask no questions. Mr. Hepworth, we proceed to call another evidence, Francis Griffin. Mr. Hepworth, look upon the prisoners. Do you know them? Griffin, I know them all. Mr. Hepworth, begin with John Brierly. Griffin, he was on board of us some time when we were at Cape Fear, and he was as the rest of the company was, and he said he hoped when Major Bonnet should go to the northward to be revenged on some of the whore-kills for some offense they had given him there. Judge Trott, you looked upon him as one of the crew? Griffin, yes. Judge Trott, would you know a Boyd? Griffin, he was on board of us some time, and when Major Bonnet sent for all hands aboard the Revenge, he went with them. But as for Sharp, I can say nothing of him, nor of Clarke, only he run away, and in some days he returned again. Mr. Hepworth, we shall call another evidence, Captain Peter Manwaring. Mr. Hepworth, Captain Manwaring, do you know the prisoners at the bar? Manwaring, I know them all very well. Mr. Hepworth, please to give the court an account of what you know of them, and begin with Brierly. Manwaring, Brierly, the 12th day of August he came on board, and a little after he was on board I did not see, but he acted as the rest did, and he hoped to come up with some at the whore-kills. But as for Boyd, he was on board Captain Reed's sloop. Judge Trott, what have you to say of Sharp? Manwaring, some time after he came to Cape Fear, and Major Bonnet sent for him on board the Revenge. He said he would go on shore if he had an opportunity, and I never saw him among the rest of the company. Judge Trott, What have you to say of Jonathan Clarke? Man-wearing. After we had been at Cape Fear some days, Jonathan Clarke and one Dalton came in, and Major Bonnet sent the dory and brought them on board. And after some days, Clarke and went away and was gone some days, and then returned again. And then he was ordered to work among the Negroes. As for my man Gerrard, he came and told me he was not able to bear any longer, but was forced to comply with them. But they told him they would have no regard for the color, but would make a slave of him. But he did not receive any of their goods, and when he was at home he had the character of an honest man, and fought for his king and country. Mr. Hepworth, we will call another evidence James Killing. Mr. Hepworth, do you know the prisoners at the bar? Killing, I know them all very well. Mr. Hepworth, give the court an account of what you know of their sharing at Cape Fear. Killing, Brierly was put on board our sloop there to work at his trade, and would often say he had a quarrel against some of the Horkills. He hoped to revenge himself upon them. Judge Trot, why, what had they done to him? Killing, he was in debt, and therefore he owed them a grudge, but for the rest I can say nothing. Judge Trot, you the prisoners, what have you to say in your defense? I shall now be ready to hear. The clerk, John Brierly, what have you to say? Brierly, Mr. Boyd and I was in a leaky canoe, and we were afraid she would sink, and so we were obliged to keep along shore. And I stood up and thought I saw a vessel or two, and he bid me look again, and then I saw it was a vessel, and sent off their dory and asked if we could consent to go with them, and we said no, but they said they would break the canoe and we might go where we pleased. So they made me consent to go on board the Revenge, but I never joined myself while I was on board, and then I was ordered on board Captain Manwaring, and there I worked, but I never bore arms, nor did fight Colonel Red. The clerk, Roland Sharp, what have you to say? Sharp, after I was taken, I went on shore and traveled 4 days in the woods without eating or drinking, and could find the way to no plantation, and so was forced to return again. And I refused to sign the articles, and one of the men came and told me I was to be shot, and I had the liberty to choose the 4 men that should do it. And the boatswain went about to get hands to beg me off, but I was resolved to make my escape the first opportunity. The clerk, Jonathan Clarke, what have you to say? Clarke, the 12th of August, coming into Cape Fear with Mr. Dalton. He thought he saw the mast of a vessel, and I desired him to take the helm that I might see. For if there was any vessel, it was pirates, but Dalton said it was nothing but an old tree. But when we came farther in, we saw 3 sloops, and they sent off their dory and took us, and carried us aboard the Revenge. And Major Bonnet asked us from whence we came, and I told him. He asked me where we were going, and we told him. The next day he asked if I did not design to do as they did. I told him no. Then I went away with the design to get clear of them, but with hunger was forced to return again, and they asked me if I would sign the articles then, and I refused. And one of the Negroes came and damned me, and asked me why I did not go to the pump, and told me that that was my business. And Major Bonnet told me if I did not, he would make me governor of the first island he came to, where he would put me ashore and leave me there. The clerk, Thomas Gerrard, what have you to say? Gerrard, some time after we were taken, one of the men came and asked if I would join with them. I told him no, but said I was but like a Negro, and they made slaves of us all of that color if they did not join. So I did it with the design to get clear of them the first opportunity, and I never shared any of their goods. Footnote, he was a mulatto. End of footnote. Judge Trot, Pell, did he never share? Pell, he never did share. Judge Trot, and did they threaten to make a slave of him if he did not join? Pell, yes. The Attorney General, May it please your honors, and you, the gentlemen of the jury, as for Brierly and Boyd, it appears from the evidence that they came to Cape Fear 3 or 4 days after Bonnet. Brierly took up very soon, and Boyd some time after, and that there were several goods taken out of Captain Mainwaring's sloop, and particularly rum and sugar. And as for Sharp, there is no evidence proves anything fully on him, and therefore I think he may be looked upon as under constraint and force. As for Gerrard, I think the same, for though he signed the articles, yet no evidence proves that he did share any of the goods. Nay, the boatswain says he did not share, and if they did not comply with them, they would make a slave of him all the days of his life. And Captain Mainwaring says he had the character of an honest man at home, and that he fought for his king and country. Judge Trott, gentlemen of the jury, the prisoners at the bar stand charged with piracy, committed on a sloop belonging to Captain Mainwaring, and the evidence had proved it fully upon Brierly and Boyd, and particularly that there was rum and sugar taken out. Brierly took up very soon with them and had his share, and that he hoped to revenge himself on some of the whore kills. Boyd did not take up so soon, but he did afterward. As for Sharp, he would have made his escape, but could not, and Major Bonnet told him he should die, and bid him choose 4 men to shoot him, and though he signed the articles, he never shared, as Pell proves. As for Clarke, he says he was forced to do it, that he went away, and hunger forced him to return again, and the negroes insulted over him. And Major Bonnet told him he would make him governor of an island, and leave him there, and none of the evidence proves that he shared any of the goods. And as for Gerrard, he was threatened to be made a slave of, though indeed he had been better made a slave than go a-pirating. But Captain Mainwaring says he had the report of an honest man in his country, and that he was faithful to his king and country. So I shall leave those to your consideration. And if you think they were under force and constraint, as indeed it appears to me, by the whole course of the evidence, that they were, then you ought to acquit them. The jury, after they had considered of their verdict, returned, found John Brierly, alias Timberhead, and Robert Boyd guilty, Roland Sharp, Jonathan Clarke, and Thomas Gerrard not guilty. November 4th, the court proceeded to arraign the said John Brierly, alias Timberhead, Robert Boyd, Roland Sharp, Jonathan Clarke, and Thomas Gerrard upon the second indictment. All pleaded not guilty. Then the court proceeded upon their trial. The jurors were sworn, whose names are as follows: Samuel Prolo, foreman; John Hodgson, Garrett Van Villen, Lucas Stoutenborough, Joshua Mariner, Thomas Fairchild, Henry Ganalack, John Pellantine, Charles March, John Grimble, Nicholas Stevens, William Harvey. The evidence. The clerk. Call Ignatius Pell. Mr. Hepworth. Pell. Given an account first of Brierly and Boyd. Pell. As for Brierly, he soon united himself to the company, and when we engaged Colonel Rhett, he was as active as any of the rest. But for Boyd, he was sent on board Captain Reed's sloop, and was there till Major Bonnet sent for him on board the Revenge to fight Colonel Rhett. Judge Trott. And did he fight? Pell. He was wounded with one of the first shots, and so was carried down into the hole, so that he never did fight. Mr. Dean. Why was he put on board the sloop? Pell. To look after the sloop, I suppose. The Attorney General. Had he his arms ready when you engaged Colonel Rhett? Pell. Yes, sir. So we all had in general, but I did not see him use them. As for the other 3, I thought them to be under constraint, and they did not fight Colonel Rhett. The clerk. Will any of you ask the king's evidence any questions? No questions asked by the prisoners. Mr. Hepworth, we proceed to call another evidence, Captain Peter Mainwaring. Mr. Hepworth. Captain Mainwaring, give an account of the prisoners of their fighting Colonel Rhett, and begin with Brierly and Boyd. Mainwaring. They came on board, and Brierly soon became one of the company, and hoped to revenge himself on some of the horde kills, and acted as the rest when they engaged Colonel Rhett. But as for Boyd, I took him to be a prisoner for some time. Captain Mainwaring's evidence concerning Sharp, Clarke, and Gerrard was the same as in the former trial. Mr. Hepworth, will any of you ask the King's evidence any questions? No questions asked by the prisoners. Mr. Hepworth, we will call another evidence, James killing. Mr. Hepworth, give an account of the prisoners at the bar, and first to Brierly and Boyd. Killing. As for Boyd, he was on board Captain Reed after we came to Cape Fear, till they were sent for to fight Colonel Rhett, and I thought he had been a prisoner till then, and I talked very free to him. And as for Brierly, he was as the rest of the company. The Attorney General, were there any goods taken out after Brierly came on board? Killing. Yes. Mr. Hepworth, do you know what goods? Killing. I cannot remember every particular sort. His evidence against the other three was the same as in the former trial. The clerk, will any of you ask the King's evidence any questions? No questions asked by the prisoners. Mr. Hepworth, we will call another evidence, Captain Thomas Reed. Mr. Hepworth, Captain Reed, please to give an account of the prisoners at the bar, and first Brierly and Boyd. Reed, as for Brierly, I did not see, but he acted as all the rest of the company did. Judge Trott, what have you to say of Boyd? Reed, I thought him to be a prisoner, and discoursed freely with him, which if he had discovered, it had done me an injury. For I heard him wish we might meet with the 30-gun ship, and I told him I would be glad of it as well as he. Foreman, what did he wish to meet with the 30-gun ship for? Reed, to free us from the pirates. His evidence against the other three was the same as before. The clerk, will any of you ask the King's evidence any questions? None of the prisoners asked any questions. Judge Trott, you, the prisoners, may now speak what you have to say. The clerk, what have you to say, John Brierly? Brierly, when Mr. Boyd and I came in at Cape Fear, we saw 3 sloops, and then came off a dory with some hands, and hailed us, and then carried us on board, but we did not know that they were marooners. But Mr. Boyd trembled and shook like a leaf, and I told him not to be afraid, so they carried us on board. Judge Trott, and so you united yourself with them to make up the company? Brierly, I was forced to do what I did. The clerk, Robert Boyd, what have you to say? Boyd, after we came to Cape Fear, was taken by Bonnet's men. I was on board the Revenge for some time, and they asked me to sign the articles, for which I refused, and Major Bonnet told me if I did not, he would maroon me on an island and leave me. And after I was sent on board Captain Reed's sloop, I had nothing but the provisions I lived on. I never had anything more. And when Major Bonnet sent for all on board to fight Colonel Rhett, it would have been present death for any to refuse, and I was wounded with one of the first shot. The other 3 prisoners made it appear they were innocent, as in the other indictment. The Attorney General, may it please your honors, and you, the gentlemen of the jury, the evidence proves the facts fully on Brierly, that he soon engaged with Bonnet after he was taken, and that he acted as the rest of the company did, and that he hoped to be revenged on some of the horde kills. As for Boyd, though he was on board the pirate sloop, he never took part with them, and he wished for a 30-gun ship, that they might be set at liberty, and Captain Reed took him for a prisoner till he was sent for on board the Revenge, and then the boatswain said he did not fight. As for the other 3, I think it appears they were under constraint and force. Judge Trott, gentlemen of the jury, the prisoners at the bar stand indicted for piratically taking Captain Reed in the sloop Fortune. As for Brierly, the evidence proves it very plain and fully upon him that he took it very soon with them, and did hope to revenge himself upon some other war kills, and that he engaged against Colonel Rhett. As for Boyd, Captain Reed looked upon him as a prisoner, and that he had such discourse with him, that if he had disclosed it to Bonnet's crew, it had done him much hurt. And the boatswain said he did not fight Colonel Brett. And as for the other three, I think it hath been fully proved they were under constraint, but I shall leave it to your consideration. After they had considered of their verdict, the jury returned, and found John Brierly, alias Timberhead, guilty. Robert Boyd, Roland Sharp, Jonathan Clarke, and Thomas Gerrard, not guilty. End of section 79. Section 80 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Brierly, Boyd, Sharp, Clarke, and Gerrard for piracy. South Carolina, 1718, Part 2. The sentences of the pirates. November 5th. Robert Tucker, Edward Robinson, Neil Paterson, William Scot, Joe Bayley, John William Smith, Thomas Carman, John Thomas, William Morrison, William Livers, alias Evers, Samuel Booth, William Hewet, John Levit, William Eddy, alias Nettie, Alexander Annand, George Ross, George Dunkin, John Ridge, Matthew King, Daniel Perry, Henry Virgin, James Robbins, James Mullet, alias Millet, Thomas Price, John Lopez, Zachariah Long, James Wilson, John Brierly, alias Timberhead, and Robert Boyd, who stood convicted of piracies, were brought to the bar and were severally asked what they could say why judgment of death should not pass upon them. And they, having nothing to allege in arrest of judgment, proclamation for silence was made, while the judge of the Court of Vice Admiralty pronounced sentence of death upon the prisoners. Judge Trott, you, the prisoners at the bar, Robert Tucker, Edward Robinson, Neil Paterson, William Scott, Joe Bayley, John William Smith, Thomas Carman, John Thomas, William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, John Levit, William Eddy, alias Nettie, Alexander Annand, George Ross, George Dunkin, John Ridge, Matthew King, Daniel Perry, Henry Virgin, James Robbins, James Mullet, alias Millet, Thomas Price, John Lopez, Zachariah Long, James Wilson, John Brierly, and Robert Boyd stand here convicted of piracy. You have been indicted but for 2 acts of piracy, but you know upon the trials it was fully proved against most of you that you piratically took 13 vessels since you joined Major Bonnet and sailed from Topsail Inlet in North Carolina, so that many of you might have been convicted on 11 more indictments of piracy. Besides, several of you were proved to be pirates before that time, as belonged to Thatcher's crew, and so were guilty of the several piracies committed while you belonged to him. You cannot but acknowledge that you have all of you had a fair and indifferent trial. You were fully heard, not only as to all you could pretend to say in your own defenses, but also as to what you allege in mitigation of your crimes. And indeed, when you saw that the facts laid in the indictment were so fully proved against you, though most of you pleaded not guilty for form's sake, yet in the open court upon your trials, most of you acknowledge the facts charged upon you. Therefore, no one can think but that you were all of you justly found guilty, and your consciences will oblige you to acknowledge the same, so that there is not any hope you can complain of any hardships at your trial. As to the crime that you are convicted of, which is piracy, the evil and wickedness of it is evident to the reason of all men, so that it needs no words to aggravate the same. It is so destructive of all trade and commerce between nation and nation, that pirates are called enemies to mankind, with whom no faith nor oath ought to be kept, and they are termed in our law brutes and beasts of prey, and therefore it is the interest as well as duty of all governments to bring such offenders to punishment, though the greatness of your crime is such that no one can think but that the sentence of death which will now be passed upon you is justly due to you for the same. Yet as pity and compassion, even to the worst of criminals, when brought to punishment, are natural to all men who have not flung off all sense of humanity, but much more firmly engrafted in the hearts of Christians. Therefore, surely it cannot but be a very melancholy spectacle to see so many persons in the prime of their years, in perfect health and strength, dropping into the grave, and which is a more sorrowful consideration, that they are in the height of their sins, and therefore without the infinite mercies of God, through the satisfaction of Christ, must necessarily sink into the dwellings of everlasting misery. And indeed, most sad and deplorable is the condition you have brought yourselves to be adjudged by the laws of your country unworthy any longer to live, and to tread the earth or breathe the air, and that no further good or benefit can be expected from you, but by the example of your deaths, and to stand like marks or fatal rocks and sands, to warn others from the same shipwreck and ruin for the future. As most of you have been mariners by profession, and every one of you have several times been at sea, so I cannot but wonder that being so often at sea, you should not consider the great power of God in creating the same, and his providence preserving those who pass upon it, and consequently that such thoughts should not cause in you a dread of his power, and a love of his goodness. The consideration of God's power in making the sea, and setting bounds to the raging waters thereof, is used as an argument by God himself, why men should fear him, for thus God expresses it by the prophet Jeremiah. Fear ye not me, saith the Lord. Will ye not tremble at my presence, which have placed the sand for the bound of the sea by a perpetual decree, that it cannot pass it, and though the waves thereof toss themselves, yet can they not prevail. Though they fear, yet can they not pass over it. Jeremiah, verse 22. Or as it is expressed in the book of Job, hitherto shalt thou come, but no farther, and here shall thy proud waves be stayed. Job 37, verse 11. The psalmist saith that they that go down to the sea in ships that do business in great waters, they see the works of the Lord and his wonders in the deep. For he commandeth and raiseth the stormy wind, which lifteth up the waves thereof. They mount up to the heaven, they go down again to the depths. Their soul is melted because of trouble. They reel to and fro, and stagger like a drunken man, and are at their wits' end. Then they cry unto the Lord in their trouble, and he bringeth them out of their distress. He maketh the storm so calm, so that the waves thereof are still. Then they are glad because they be quiet, so he bringeth them unto their desired haven. But the practical inference that he draws from these is that men should praise the Lord for his goodness and for his wonderful works to the children of men. Psalm 107, verse 23, 24, 25, 26, 27, 28, 29, 30, 31. But instead of having a sense of God's power and goodness, and preserving you and others upon the sea, your frequent preservations hardened you into contempt of the danger you were in, and you thereby slighted your deliverances. And though you could not but see the many natural dangers that attend the seas, and those who had occasion to go upon the same, yet you were resolved that you would contribute what in you lay to the hazards thereof, by the frequent rapines and murders which you committed, so that what the prophet saith of the pride of the Tyrians may be applied to you, that you caused your terror to be on all that haunt the sea. Ezekiel 26, verse 17. Although it may be, while you were in your seeming prosperity, and went on in your committing spoils and robberies without control, you might make a mock at your sins. Proverb 14, verse 9, and chapter 10, verse 23. And say in your hearts, God hath forgotten. He hideth his face. He will never see it. Psalm 10, verse 11, 94, verse 7, 64, verse 5, and Job 22, verse 13. Yet now that you see that God's hand hath reached you, and his power hath brought you to public justice, I hope your present unhappy condition hath had a good effect upon you, that it hath raised in you more serious thoughts, and that you are now sensible of the greatness of your sins, and that you will sincerely repent you of the same. As to the great evil and sinfulness of the facts you have committed, surely you cannot but know that it is one of the express commandments of God. Thou shalt not steal. Exodus 20, verse 15. And the Apostle St. Paul expressly affirms that thieves shall not inherit the kingdom of God. 1 Corinthians 6, verse 10. But then remember that to theft you have added the sin of murder in destroying those persons who were sent by lawful authority to suppress you, and to put a stop to your wicked actions, for you being no way authorized to use the sword or to fight anyone. Every one of those persons who fell by your hands were murdered, and their blood now cries for vengeance against you. For it is the voice of nature as well as the revealed law of God that, whoso sheddeth man's blood, by man shall his blood be shed. Genesis 9, verse 6. It is the commandment of God, thou shalt do no murder. Exodus 20, verse 13. And the apostle, enumerating several of the works of the flesh, amongst the rest reckons murders, and then concludes with these remarkable words, of which I tell you before, as I have told you in the past, that they which do such things shall not inherit the kingdom of God. Galatians 5, verse 21. And murderers are threatened to have their part in the lake which burneth with fire and brimstone, which is the second death. 2 Revelations 21, verse 8. See chapter 22, verse 15. Words that carry terror with them, that considering your circumstances and your guilt, surely the sound of them must make you tremble, for you can dwell with everlasting burnings. Isaiah 33, verse 14. I suppose you all know that you must appear before the tribunal of Christ, from whose infinite knowledge none of your actions can be hid, and from whose infinite power no one can rescue you or protect you, and from whom, without a true and unfeigned repentance for all your sins past, you can expect no other than that dreadful sentence of condemnation. Depart from me, ye cursed, into everlasting fire, prepared for the devil and his angels. Matthew 25, 41. I do not speak this to overwhelm you with sorrow, much less to drive you into despair of God's mercy, which is one of the worst of sins, and which I hope you will not add to your other offenses against God. But I mention this to you to make you sensible of the great danger of your condition, without true and unfeigned repentance. For seeing I can give you no hopes of pardon from man, I hope you will improve the short time you have now left you, to make your peace with God and to obtain pardon from him. And I wish that what I now say to you in this your deplorable conditions may make you all sensible of the greatness of your offenses, that so you may become truly penitent, which if you are, you may yet hope for mercy from God. But through your sins be as scarlet, even dyed in blood, yet he can make them white as snow. Isaiah 1, verse 18. Therefore, if you will now turn unto God by a true and unfeigned repentance, he will not refuse you, nor reject you, even now in your great distress. For the threatenings declared by God in the Scriptures against sinners must always be understood against impenitent sinners. For God hath declared himself to be merciful and gracious. Exodus 34, verse 6. And that he hath no pleasure in the death of the wicked, but that the wicked turn from his way and live. Ezekiel 33, verse 11. Chapter 17, verse 23. And hath promised that when he doth so, he shall save his soul alive. Verse 27. But be sure to remember that you must go to God in and through the alone merits and intercession of his Son Jesus Christ, who hath made satisfaction to the justice of God for us. For he is our advocate with the Father, and he is the propitiation for our sins. John 2, verse 1, 2. For his blood cleanseth us from all sins. Chapter 1, verse 7. Know, therefore, that there is none other name under heaven given among men whereby we must be saved, but only by the name of the Lord Jesus. Acts 4, verse 12. But then consider how he invites all them that labor and are heavy laden with their sins to come unto him, and he will give them rest. Matthew 11, verse 28. He will not break the bruised reed, nor quench the smoking flax. Isaiah 42, verse 3, compared with Matthew 12, verse 20. The apostle tells us that Christ Jesus came into the world to save sinners. 1 Timothy 1, verse 15. And he himself assures us that he came to seek and save that which was lost. Luke 19, verse 10. Matthew 17, verse 11. And hath promised that he that cometh unto him he will in no wise cast out. John 6, 37. Doubt not, therefore, but that if you will now sincerely turn to God, he will accept you and pardon and forgive you your sins. But know that the condition of these and other, the promises of God, made to sinners is faith and repentance. And great sins, such as yours are, must have great repentance. You must earnestly cry unto God for pardon and remission of your sins, and particularly that he would deliver you from blood guiltiness. Psalm 51, verse 14. And do not mistake the nature of repentance to be only barely a sorrow for your sins, by reason of the evil and punishment which they now have brought upon you. But your sorrow for your sins must arise from the consideration of your having offended a gracious and merciful God, to which should be added a sincere resolution and an actual amendment for the future. Indeed, such is your unhappy circumstances, that you cannot give any actual proof of the amendment of your lives. But remember that God knows the heart. Time will not permit me to enlarge upon the nature of repentance, and of the many mistakes that men make in that great duty. Neither indeed will I so far presume to meddle out of my own profession. You may have those matters better explained to you by some of the ministers of this province, whom you may desire to attend you, and fit you for death, and from them you may expect more full and particular directions. For the priest's lips shall keep knowledge, and you shall seek the law at their mouths, for they are the messengers of the Lord. Malachi 2, verse 7. And the ambassadors of Christ, and to them is committed the word, or doctrine of reconciliation. 2 Corinthians, verse 19, 20. Thus having discharged my duty to you as a Christian, exhorting you to an unfeigned repentance for your crimes and faith in Christ, by whose merits alone you must hope for pardon and salvation, I must now do my office as a judge. The sentence that the law hath appointed to pass upon you for your offenses, and for which this court doth therefore award, is that you, the said Robert Tucker, Edward Robinson, Neil Paterson, William Scot, Joe Bayley, John William Smith, Thomas Carman, John Thomas, William Morrison, William Livers, alias Evis, Samuel Booth, William Hewet, John Levit, William Eddy, alias Neddy, Alexander Annand, George Ross, George Dunkin, John Ridge, Matthew King, Daniel Perry, Henry Virgin, James Robbins, James Mullet, alias Mullet, Thomas Price, John Lopez, Zachariah Long, James Wilson, John Brierly, and Robert Boyd, shall go from hence to the place from whence you came, and from thence to the place of execution, where you shall be severally hanged by the neck till you are severally dead. And the God of infinite mercy be merciful to every one of your souls. After the condemnation of the above-mentioned persons, Thomas Nichols, Roland Sharp, Jonathan Clarke, and Thomas Gerrard, who were found not guilty, were discharged. The executions, November 8th. Today, Robert Tucker, Edward Robinson, Neil Paterson, William Scot, Joe Bayley, John William Smith, John Thomas, William Morrison, Samuel Booth, William Hewet, William Eddy, alias Nettie, Alexander Annand, George Ross, George Dunkin, Matthew King, Daniel Perry, Henry Virgin, James Robbins, James Mullet, alias Millet, Thomas Price, John Lopez, and Zachariah Long were executed at the White Point near Charlestown, according to their sentence. End of section 80. Section 81 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Major Stede Bonnet for piracy. South Carolina, 1718, Part 1. November 10th. The court proceeded to arraign Stede Bonnet, alias Edwards, alias Thomas, who had escaped but was retaken November 6th for feloniously and piratically taking the sloop Francis with her goods, Captain Peter Manwaring, commander, and the sloop Fortune with her goods, Captain Thomas Reed, commander, upon 2 indictments, to both which indictments he pleaded not guilty. Judge Trott, you are to come upon your trial this day upon the first indictment, and you have pleaded not guilty, so that what evidence you have must be ready. Bonnet, my pleading not guilty is because I may have something to offer in my defense, and therefore I hope none of the bench will take it amiss. The court proceeded upon his trial on the first indictment for piratically taking the sloop Francis, Captain Peter Manwaring, commander. The following jurors were sworn: Timothy Bellamy, foreman; George Duckett, William Sharif, Benjamin Dennis, Jonathan Main, John Lee, Thomas B., James Mazik, Thomas Lamball, Henry Beaton, Moses Wilson, Klaus Ure. Mr. Hepworth, may it please your honors, and you, gentlemen of the jury, the prisoner who now stands arraigned at the bar has been guilty of many piracies, committed many robberies, ruined many families, and been the occasion of many most cruel and inhuman murders, and all that within a very short time past. Should I have descended into all the particulars, I shall take up too much of your time. You know, all of ye, I believe, after what manner he lately fled from justice. Nay, he was not satisfied with his own escape, but he must tamper with the king's evidence to avoid others being prosecuted, and prevailed with the master Harriet to run away with him, who has been since killed. And I believe the prisoner at the bar cannot, upon reflection, but think himself answerable for that man's death. Nay, some people took particular notice of the prisoner's behavior at the time, when that, having got command from him, he began to reflect upon his past course of life, and was then filled with such horror that he was perfectly confounded with shame at the many detestable crimes he had been guilty of, and said he would gladly leave off that way of living, being fully tired, and having got considerably by it. But he should be ashamed ever to see the face of an Englishman. Therefore, if he could not get to Spain or Portugal, where he might be undiscovered, he would live and die in the same course of life, viz., in piracy and robbery. The trial of this man ought to be the more considerable, as he was the great ringleader of them, who has seduced many poor ignorant men to follow his course of living, and ruined many poor wretches, some of whom lately suffered, with who, Their last breath expressed a great satisfaction at the prisoners being apprehended, and charged the ruin of themselves and loss of their lives entirely upon him. The evidence. Mr. Hepworth. Pell, begin with the first indictment, and when you was first acquainted with Major Bonnet. Pell. It was at the Bay of Honduras, but Captain Thatch was Commander-in-Chief. The Attorney General. This, I observe, was before they went to Topsail Inlet at North Carolina. Pell. Yes, sir. But when we came to Topsail Inlet, Robert Tucker was chose quartermaster, and we went out to go to St. Thomas's for a commission to go a privateering against the Spaniards, but the first vessel we saw we took. Mr. Hepworth. What did you take out of her? Pell. We took some provisions. The Attorney General. Had you no provisions on board the Revenge? Pell. Yes, sir. Some beef, pork, and flour. Mr. Hepworth. What was the next vessel you took? Pell. A sloop belonging to Bermudas. After we had discharged her, we took another in which were 8 negroes. We took out 2 and left 3 men and 2 women, and sent 3 hands more, which made 8. And the next day we gave chase to 2 ships belonging to Glasgow in Scotland. And in the evening we came up with them, and the other turned tail, and we never saw them more after that. And after we had taken some tobacco and other goods, we discharged them. We took, as I remember, 2 vessels belonging to Bristol, when Captain Reed was taken. The Attorney General. What do you know of Captain Mainwaring? Pell. We were at anchor near Cape James, alias Cape Linloven, and a little before night we saw a sloop come to anchor at the mouth of the river, and we sent out the dory with 5 hands. And a little time they returned with Captain Mainwaring, and the next day we hailed the sloop alongside the schooner, which we had taken before, and hoisted out several hogsheads of molasses and rum, and put them on board the canoe, and put some pitch and tar on board the sloop. The Attorney General. Who gave you orders for the doing of that? Pell. I cannot tell, sir. The Attorney General. Did you see Major Bonnet on board Mainwaring's sloop? Pell. I cannot say he was, neither do I know certainly that he was not. Judge Trott. Was he not your commander? Pell. He was called our captain, to be sure. The Clerk. Have you any questions to ask the King's evidence? Bonnet. Do not you believe in your conscience that when we left Topsail Inlet it was to go to St. Thomas's? And there were near 40 hands, and they concluded to a marooning. Pell. I did believe it was so till after we were out. Judge Trott. That was what they accused you for on their trials, that you deceived them under a pretense of going to St. Thomas's. Bonnet. I am sorry that they should take the opportunity of my absence to accuse me of that, which I was free from. Mr. Dean. If there were 40 hands on board, it cannot be thought that he had power to command them. Judge Trott. But he was commander-in-chief among them, and that was after they went a-pirating. Was it not so, Dawson? Pell. He went by that name, but the quartermaster had more power than he. Judge Trott. What do you mean by your evasion? Was he commander-in-chief, or was he not? Pell. He was. Judge Trott. Then who had the greatest power? The Attorney General. Do you know if he received his share of Captain Mainwaring's goods, or did any receive it for him? Pell. Sir, it was the quartermaster took care of that. Judge Trott. He was commander-in-chief, and therefore I suppose he had a double share. Pell. I did never inquire whether he had or not. Judge Trott. Boatswain, tell the truth. Had he his share, or had he not? Pell. He had it. Bonnet. Boatswain, did you ever hear me force any man to go? Pell. No, Major, I cannot say I did. Bonnet. Do you not remember that when we left Topsail Inlet, and they began to quarrel about provision, that I said I would leave the sloop? Pell, I do remember you said so. Judge Trot, but if you did take some for provision, would no less than 13 vessels satisfy you? Bonnet, it was contrary to my inclination. Mr. Hepworth, we proceed to call another evidence, Captain Peter Manwaring. Mr. Hepworth, Captain Manwaring, look upon the prisoner at the bar. Do you know him? Manwaring, I know him very well. Mr. Hepworth, give the court an account of your being taken by him. Manwaring, I arrived at Cape James, Ely's Cape in Lopez, the 31st of July, and after being at an anchor some time, we saw a dory coming, and I said before, so I was ordered on board the Revenge. Judge Trot, and before whom was you brought? Manwaring, before the man at the bar. Captain Thomas he was called then, and so I gave him my papers, and it being night, he said but little more that night. Next morning they hauled the sloop alongside the schooner, and hoisted out the rum and molasses out of the sloop, and put on board the schooner, and the 1st of August we sailed in company to Cape Fear. But indeed the gentleman was very civil to me. The Attorney General, did you ever hear him give orders to take out any goods? Manwaring, he was on board the sloop himself when it was done. Mr. Hepworth, do you remember any particular goods taken out? Manwaring, yes, sir. The clerk, will you ask the king's evidence any questions? Bonnet, I beg to leave to ask whether you ever saw me share among the rest. Manwaring, you was in the round house and a bundle and some pieces was brought, and I saw you take it, and give it to the negro boy to put into the closet. Bonnet, there were several that I kept their shares for, but it was not mine. Manwaring, it was put away by your orders. Bonnet, did you ever hear me order anything out of the sloop? Manwaring, Major Bonnet, I am sorry you should ask me that question, for you know you did, which was all that I had in the world, so that I do not know but my wife and children are now perishing for want of bread in New England. Had it been only myself, I had not mattered it so much, but my poor family grieves me. The clerk, will you ask any more questions? Bonnet, no, sir. Mr. Hepworth, we will call another evidence, James Killing. Mr. Hepworth, give the court an account of your being taken and what goods were taken out of you. The witness gave the same evidence as in the former trials, and added that Major Bonnet ordered him to go and show which was the rum and which was the molasses. Mr. Hepworth, do you remember in particular what goods were taken out? Killing, yes, sir. Mr. Hepworth, were the 21 hogsheads of molasses and the rum taken out? Killing, yes, sir. The Attorney General, and all by Major Bonnet's order? Killing, Major Bonnet gave orders for it to be done. Judge Trot, what need had you of so much molasses? Bonnet, I did not carry it away, and it was contrary to my inclination. Judge Trot, you gave orders for it to be done, and yet it was contrary to your inclinations. The clerk, will you ask the king's evidence any questions? Bonnet, no, sir. Mr. Hepworth, we will call another evidence, Captain Thomas Reed. Mr. Hepworth, please to give the court an account of Captain Manwaring's being taken. Reed, after we came to Cape James, we saw a sloop come to an anchor, and Major Bonnet ordered the dory with 5 hands to go off, and in about half an hour they came on board with Captain Manwaring. The Attorney General, was you on board the Revenge when the dory was sent off? Reed, yes, sir. The Attorney General, and Major Bonnet gave orders to take out those goods? Reed, yes, sir. Judge Trot, was he on board himself? Reed, yes, and ordered the several goods to be taken out. The Attorney General, do you know if the Major received his share? Reed, The captain was in the roundhouse when they shared. They brought in several pieces of cloth and a bag of money. Mr. Hepworth, who brought that to him? Read, I do not know which of the men. The Attorney General, and did the captain receive his share? Read, he ordered it to be put in the chest by the boy. The clerk, will you ask any questions? Bonnet, no, sir. Judge Trott, you now stand on your defense. What have you to say? I shall be ready to hear. Bonnet, may it please your honors, there is a young man come from North Carolina that will say something in my defense. Judge Trott, James King, what do you know of the prisoner at the bar? King, when Major Bonnet took out his clearance at North Carolina, the sloop was cleared to St. Thomas's for a commission to go against the Spaniards for privateering. Mr. Dean, do you certainly know it was so? King, it was reported to be so by the governor. The Attorney General, did you hear the governor declare this? King, no, but Colonel Bryce's son told me so. Judge Trott, Colonel Bryce lives 50 miles in the country. How did he come to inform you of this? King, he came down out of the country. Judge Trott, if this be all the evidence you have, I do not see this will be of much use to you. But if you have anything further to say, I shall be ready to hear you. Bonnet, I should be glad to go through both indictments at once. Judge Trott, we shall go through but one indictment now. Therefore you must prepare to speak to that singly. Bonnet, may it please your honors and the rest of you gentlemen, though I must confess myself a sinner, and the greatest of sinners, yet I am not guilty of what I am charged with. As for what the boatswain says, relating to several vessels, I am altogether free, for I never gave my consent to any such actions, for I often told them, if they did not leave off committing such robberies, I would leave the sloop, and desired them to put me on shore. And as for taking Captain Mainwaring, I assure your honors it was contrary to my inclination, and when I cleared my vessel at North Carolina, it was for St. Thomas's, and I had no other end or design in view but to go there for a commission. But when we came to sea, and saw our vessel, the quartermaster, and some of the rest, held a consultation to take it. But I opposed it and told them again I would leave the sloop, and let them go where they pleased. For, as the young man said, Colonel Bryce's son can testify that I had clearance for St. Thomas's. Judge Trott, was Colonel Bryce's son there when you cleared for St. Thomas's? Bonnet, yes, and Colonel Bryce's son knew I was designed for St. Thomas's. Judge Trott, but pray, what business had you at St. Thomas's? Surely, after you had contracted so much guilt upon your conscience by your former piracies and robberies, you might have been contented to have lived a retired life in North Carolina, reflected on your former wicked course of living, and repented of the same, and not engaged in new actions. Bonnet, I never took a vessel but with Captain Thatch. Judge Trott, did you not take Captain Mainwaring's sloop? Bonnet, it was contrary to my inclinations, and I told them several times that they would not leave off that course of life. I would leave the sloop, and when Captain Mainwaring was taken, I was asleep. Judge Trott, how came you to order the jury to be sent off with 5 hands to take him? And Captain Reed swears it was your order. The Attorney General, may it please your honors and the gentlemen of the jury, the prisoner at the bar hath pleaded not guilty to the indictment, but the boatswain, though he seems to bear a very great affection to him, it tells you that he was commander-in-chief among them at the time when Captain Mainwaring was taken. Captain Mainwaring tells you, when he was brought on board the Revenge, he was brought before him, and no other, and that he delivered his papers to him, and he saw his share brought to him in the roundhouse, and put into the chest. Then Captain Mainwaring's mate says Major Bonnet was on board the sloop, and ordered him to show which was the molasses, and which was the rum. And then Captain Reed, it says, Major Bonnet was commander-in-chief, and that he ordered the jury to be sent off with 5 hands to take Captain Mainwaring. Indeed, the prisoner pleads he was under constraint from his men, and that it was contrary to his inclinations. But I think it not common for one thing that is forced to have such command. And as for what James King says in behalf of the prisoner, that he had his clearance for St. Thomas's, and what he was accused of before, that he deceived his men with the notion of his going there for a commission. Judge Trott, gentlemen of the jury, the prisoner at the bar stands indicted for felony and piracy, committed on a sloop belonging to Captain Peter Mainwaring, for breaking and boarding the said sloop. The first evidence, Ignatius Pell, through the great affection he seemed to have for him, was unwilling to speak the truth. Yet he cannot deny that he was at the taking of 13 vessels, and particularly Captain Mainwaring's, and that he had his share. Then comes Captain Mainwaring, and he says Captain Bonnet was commander-in-chief, and that he was brought before him, and he gave his papers to him, and by his order it was that the goods were taken out, and then killing the mate. He says Bonnet was on board when the goods were taken out. Then comes Captain Reed, and he says the jury was sent off at Major Bonnet's order, and that his share was brought into the roundhouse to him. As for his pretense, that his men forced him against his will, it appears by the evidence he did not act like a person under constraint, and in the former trial several of you remember that his men generally said that he deceived them under pretense of his going to St. Thomas's, and that he forced them, so that I think the evidence have proved the fact upon him, but I shall leave this to your consideration. The jury, after they had considered of their verdict, returned and found the above said Stede Bonnet, alias Edwards, alias Thomas, guilty. November 11th, the court proceeded on the trial of Stede Bonnet, alias Edwards, alias Thomas, upon the second indictment for feloniously and piratically taking the sloop Fortune, with her goods, Captain Reed, commander, to which indictment upon his arraignment he pleaded not guilty, but now desired leave to withdraw his plea, and pleaded guilty. End of section 81. Section 82 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Major Stede Bonnet for piracy. South Carolina, 1718, Part 2. The sentence, November 12th. Stede Bonnet, alias Edwards, alias Thomas, who stood convicted of piracies, being brought to the bar, and being asked what he had to say why judgment of death should not pass upon him, and he, having nothing to allege in arrest of judgment, then proclamation for silence was made, while the judge of the Court of Vice Admiralty pronounced sentence of death upon the prisoner. Judge Trott, Major Stede Bonnet, you stand here convicted upon 2 indictments of piracy, one by the verdict of the jury and the other by your own confession. Although you were indicted but for 2 facts, yet you know at your trial was fully proved, even by an unwilling witness, that you piratically took and rifled no less than 13 vessels since you sailed from North Carolina, so that you might have been indicted and convicted of 11 more acts of piracy, since you took the benefit of the King's Act of Grace, and pretended to leave off that wicked course of life, not to mention the many acts of piracy you committed before, for which, if your pardon from man was never so authentic, yet you must expect to answer for them before God. You know that the crimes you have committed are evil in themselves, and contrary to the light and law of nature, as well as the law of God, by which you are commanded that you should not steal. Exodus chapter 20, verse 15. And the Apostle St. Paul expressly affirms that thieves shall not inherit the kingdom of God. 1 Corinthians chapter 6, verse 10. But to theft you have added greater sin, which is murder. How many you have killed of those that resisted you in the committing of your former piracies? I know not. But this we all know, that besides the wounded, you killed no less than 18 persons out of those that were sent by lawful authority to suppress you, and to put a stop to those rapines that you daily acted. And however you may fancy that was killing men fairly in open fight, yet this know, that the power of the sword not being committed into your hands by any lawful authority, you were not empowered to use any force or to fight anyone, and therefore those persons that fell in that action, in doing their duty to their king and country, were murdered, and their blood now cries out for vengeance and justice against you. For it is the voice of nature, confirmed by the law of God, that whoso sheddeth man's blood, by man shall his blood be shed. Genesis chapter 9, verse 6. And consider that death is not the only punishment due to murderers, but they are threatened to have their part in the lake which burneth with fire and brimstone, which is the second death. Revelations chapter 21, verse 8. See chapter 22, verse 15. Words which carry that terror with them, that considering your circumstances and your guilt, surely the sound of them must make you tremble. But who can dwell with everlasting burnings? Chapter 33, verse 14. As the testimony of your conscience must convince you of the great and many evils you have committed, by which you have highly offended God, and provoked most justly his wrath and indignation against you, so I suppose I need not tell you that the only way of obtaining pardon and remission of your sins from God is by a true and unfeigned repentance and faith in Christ, by whose meritorious death and passion you can only hope for salvation. You, being a gentleman that have had the advantage of a liberal education, and being generally esteemed a man of letters, I believe it will be needless for me to explain to you the nature of repentance and faith in Christ, they being so fully and so often mentioned in the Scriptures that you cannot but know them. And therefore, perhaps, for that reason, it might be thought by some improper for me to have said so much to you, as I have already upon this occasion. Neither should I have done it, but that considering the course of your life and actions, I have just reason to fear that the principles of religion that have been instilled into you by your education have been at least corrupted, if not entirely defaced, by the skepticism and infidelity of this wicked age, and that what time you allowed for study was rather applied to the polite literature and the vain philosophy of the times than a serious search after the law and will of God, as revealed to us in the Holy Scriptures. For, had your delight been in the law of the Lord, and you had meditated therein day and night, Psalm chapter 1, verse 2, you would then have found that God's word was a lamp unto your feet and a light to your path. Psalms 119, verse 105. And that you will account all other knowledge but loss in comparison of the excellency of the knowledge of Christ Jesus. Philippians chapter 3, verse 8. Who to them that are called is the power of God and the wisdom of God. 1 Corinthians chapter 1, verse 24. Even the hidden wisdom which God ordained before the world. Chapters 2, verse 7. You would then have esteemed the Scriptures as the great charter of heaven, and which delivered to us not only the most perfect laws and rules of life, but also discovered to us those acts of pardon from God, wherein we have offended those righteous laws, for in them only is to be found the great mystery of fallen man's redemption, which the angels desire to look into. 1 Peter chapter 1, verse 12. And they would have taught you that sin is the debasing of human nature, as being a deviation from that purity, rectitude, and holiness, in which God created us, and that virtue and religion and walking by the laws of God were altogether preferable to the ways of sin and Satan, for that the ways of virtue are ways of pleasantness, and all her paths of peace. Proverbs chapter 3, verse 17. But what you could not learn from God's word by reason of your carelessly, or by superficially considering the same, I hope the course of his providence and the present afflictions that he hath laid upon you hath now convinced you of the same. For however in your seeming prosperity you might make a mock of your sins, Proverbs chapter 3, verse 17, yet now that you see God's hand hath reached you and brought you to public justice, I hope your present unhappy circumstances hath made you seriously reflect upon your past actions and course of life, and that you are now sensible of the greatness of your sins, and that you find the burden of them is intolerable, and that therefore being thus laboring and heavy laden with sin, Matthew chapter 11, verse 28, you will esteem that as the most valuable knowledge, which can show you how you can be reconciled to the supreme God, whom you have so highly offended, and which can reveal to you who is not only the powerful advocate with the Father for you, 1 John chapter 2, verse 1, but also who hath paid that debt that is due for your sins by his own death upon the cross for you, and thereby made full satisfaction to the justice of God. And this is to be found nowhere but in God's word, which discovers to us that Lamb of God which taketh away the sins of the world, John chapter 1, verse 29, which is Christ the Son of God. For this know and be assured that there is none other name under heaven given among men, whereby we must be saved. Acts 4, verse 12, but only by the name of the Lord Jesus. But then consider how he invites all sinners to come unto him, and that he will give them rest. Matthew chapter 11, verse 28, for he assures us that he came to seek and to save that which was lost. Luke chapter 19, verse 10, Matthew chapter 18, verse 11, and hath promised that he that cometh unto him, he will in no wise cast out. John chapter 6, verse 37. So that if now you will sincerely turn to him, though late, even at the 11th hour, Matthew chapter 20, verse 6, verse 9, he will receive you. But surely I need not tell you that the terms of his mercy is faith and repentance, and do not mistake the nature of repentance to be only a bare sorrow for your sins, arising from the consideration of the evil and punishment they have now brought upon you. But your sorrow must arise from the consideration of your having offended a gracious and merciful God. But I shall not pretend to give you any particular directions as to the nature of repentance. I consider that I speak to a person whose offenses have proceeded not so much from his not knowing as his slighting and neglecting his duty. Neither is it proper for me to give advice out of the way of my own profession. You may have that better delivered to you by those who have made divinity their particular study, and who by their knowledge as well as their office, as being the ambassadors of Christ. 2 Corinthians, verse 20, are best qualified to give you instructions therein. I only heartily wish that what, in compassion to your soul, I have now said to you upon this sad and solemn occasion, by exhorting you in general to faith and repentance, may have that due effect upon you, that thereby you may become a true penitent. And therefore, having now discharged my duty to you as a Christian, by giving you the best counsel I can with respect to the salvation of your soul, I must now do my duty as a judge. The sentence that the law hath appointed to pass upon you for your offenses, and which this court doth therefore award, is that you, the said Stede Bonnet, shall go from hence to the place from which you came, and from thence to the place of execution, where you shall be hanged by the neck till you are dead. and the God of infinite mercy be merciful to your soul. The execution, December 10th. On this day, Major Stede Bonnet was executed at the White Point near Charleston, according to the above sentence. End of section 82.
Section 83 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jeremy Lindsay. American State Trials, Volume 4, by John D. Lawson, Section 83. The Trial of John and Sarah Robinson for Kidnapping, Boston, Massachusetts, 1837. The narrative. In the year 1836, Mr. Henry Bright, a native of Massachusetts, and his wife, who was born in Connecticut, returned from Alabama, where they had lived for a number of years. They had selected Cambridge as their permanent home. They had owned slaves in the South, and with them came a Negro child, whose mother had been owned by them, but had died a short time before. They had been settled in Cambridge only a few months when the child suddenly disappeared. Mr. Bright made a search and soon learned that it had been taken away by Sarah Robinson, and on demanding its return, found that it was in the hands of a number of abolitionists. To a prominent representative of that party, he declared that the child was not a slave, but was treated most kindly by Miss Bright, who was much attached to it, and who desired to educate it, and that they had no thought of going back to the South, or sending the child there. He offered to give a bond to secure its not being removed from the state, adding that he and his wife were as much opposed to slavery as anyone in the North. Then he went to court and had himself appointed guardian of the child, and with an officer of the court made a demand on Sarah and her husband John, who were both Negroes, to produce the girl. They refused, whereupon he had them indicted for kidnapping. On the trial, the judge charged the jury very strongly regarding the high-handed conduct of the prisoners, and the jury convicted them, and they were sentenced to a fine and imprisonment. The trial in the municipal court of the city of Boston, December 1837. Honorable Peter O. Thatcher, Judge, December 19th. The grand jury had returned an indictment against John Robinson and Sarah Sophia Robinson, his wife. The indictment had 3 counts. The first charged that the prisoners on the 17th September 1837 at Cambridge seized and confined and imprisoned a certain female child of tender years, to wit, of 5 years of age, and inveigled and kidnapped said child with intent to cause her to be secretly confined and imprisoned in this state against her will, and that they, after seizing the child, took, confined, held, carried, and brought her from Cambridge into Boston. The second count charged that they seized the child with intent to hold her to service against her will. The third count charged that the prisoners seized the child with the intent that she should be carried out of the state against her will. Both of the prisoners pleaded not guilty. Mr. Parker for the Commonwealth, Benjamin R. Curtis for the prisoners. The witnesses for the Commonwealth. Henry Bright. Reside in Cambridge since May last. 2 years ago I lived in Mobile. Had there a female slave, a very excellent woman, who died leaving a female infant, whom my wife has since taken care of as her own. This child was removed to Cambridge with my family and was a member of it in September last. On the 17th of that month, she was missing, and I have not since seen her. Made inquiries and learned she had been taken to Boston in a carriage by Miss Robinson. Went to some leading abolitionists in Boston, as I supposed the persons who had taken the child must have done so under a mistaken notion. Called on Samuel E. Sewell, Esquire, with my wife. We stated to him the facts respecting the child, that her mother died with us, and that we had brought the child here to educate, that we had left Mobile with a view to reside here permanently, that the child was very much attached to Miss Bright, and she to the child, that we supposed she had been taken from us by the abolitionists under the impression that she was a slave, and that we were ready to give them entire satisfaction that such was not the fact, that we were willing to give security to any amount that she should never be made a slave, and that we were only actuated by desire for the good of the child. Mr. Sewell advised us to draw up a paper setting forth the last mentioned facts. At my request, he drew up one. I signed it and left it with him. Next morning, I called on him again. He told me he had seen Mr. Snowden, the colored clergyman, that the latter could probably find the child, but as the colored people were jealous of those who came from the South, he should like to have a bond from me that the child should never be carried into a slave-holding state. At my suggestion, he drew a bond, that the penalty of which was $500. I called the next morning, did not see Mr. Sewell, but the young man in the office, said the colored people would not give up the child, went to Mr. Ellis Gray Loring's office, knowing that he was an influential abolitionist. He said Mr. Sewell had spoken to him on the subject, and that he was satisfied that the child ought to be given up. He said some colored people had called on him, that he would send for them, and let me know the result. Called the next morning on Mr. Loring. After some private conversation between Mr. Loring, Mr. Sewell, and Mr. Hanson, the latter expressed a desire that the child should be given up and directed us to call on Miss Robinson. Messrs. Sewell and Loring gave me a letter to Miss Robinson, the substance of which was that they thought the child ought to be given up, as they did not suppose she would ever be made a slave. Called on Miss Robinson with my wife. Her husband was present a part of the time, gave her the letter, and stated to her the particulars respecting the child, our views respecting it, and that we held it as a free child. She said that she took the child from Cambridge, that she had requested a Mr. Lewis, an aged colored man at Cambridge, to bring the child to Boston, but he refused to do so, but that he was at my house for a trunk the morning the child left, and sent the child into the street. That she then took the child and brought it to Boston, that she did not take it on her own account, but at the request of two white ladies, that she did not keep the child an hour, but delivered it up to the white ladies, that she was perfectly willing to restore the child if they were. Asked who the ladies were, she replied she did not feel at liberty to tell, as they had requested her not to tell. We requested her to call on them and get permission to deliver the child to us. She said she would go in the course of the day, and that probably those ladies would bring the child out to my house in the afternoon, in their carriage. If they did not, she would tell us the next day the result of her interview with them. Next morning we called again on Miss Robinson. She said she had seen the ladies and directed us to call on the two Mrs. Parker in Hayward Place. We called on them. They expressed surprise that Miss Robinson had used their names in the manner that led us to suppose they knew of the child before it was taken from Cambridge. They said they knew nothing of the little girl till the evening before, when Miss Robinson told them of her, that Miss Robinson had called on them that morning and requested permission to bring the child to their house, that they gave her permission, that they requested Miss Robinson to ask us to call on them, as they should like to talk with us. We stated to them the facts respecting the child. They said immediately that the child should be restored, and one of them went with me to Miss Robinson. We found Mr. Snowden at Miss Robinson's house. Mr. Robinson came in soon. Miss Parker advised them to give up the child. Mr. Robinson said he was perfectly willing to do what those benevolent ladies advised. Mr. Snowden remarked, after some conversation, that some of the colored people thought the bond was not sufficient, that he had nothing to do with it, but he thought that if the bond was made larger, it would be satisfactory. I answered that I would make the penalty of the bond as large as was deemed reasonable and proper, and that my only desire was the good of the child. Miss Robinson still hesitated about giving up the child. She said some other persons had taken an interest in the child, and she did not like to give it up without consulting them. That if we would call at Mr. Ellis Gray Loring's office in the afternoon, we should have a final answer, and that the child would probably be there. We called there and found Mr. and Miss Robinson, with several other colored persons there, with Mr. Loring. The child was not there. Miss Robinson said that, notwithstanding the white people wished them to give up the child, the colored people thought differently, and were determined not to give her up unless there was some law to compel them. Something was said in regard to treatment of the child while in our possession. We answered them she was treated with uncommon kindness, and if they would inquire of our neighbors or domestics, they would be satisfied of this fact. I also said that I was a native of Massachusetts, and my wife of Connecticut, and that our sympathies with northern people were as strong as theirs. Till this time I had pursued the business with patience, supposing their motives were good. I now became excited. Next applied to Charles G. Loring, Esquire, for counsel. By his advice, I took out letters of guardianship in Middlesex County. Before this, I think Mr. Loring sent for these parties. Afterwards, I called on the defendants with an officer, and after reading to them the letters of guardianship, I demanded of them the child. At first, Mr. Robinson said he presumed we could have the satisfaction we wished. When his wife came in, she said she would not give up the child, but would stand a suit, or words to that effect. We had some conversation with a colored woman present, who said she believed the child was out of town. I then applied to Chief Justice Shaw for a writ of habeas corpus, but got no relief there. I then brought a civil action as guardian for the child against the defendants. Damages were laid at $1,000, and property was attached. This did not have the effect to produce the child, as I supposed it would. I then complained to the grand jury. Samuel E. Sewell. I signed a note with Mr. Ellis Gray Loring, directed, I think, to Miss Robinson. In the note, we stated that we did not think Mr. Bright had any intention of carrying the child into slavery. There was a meeting afterwards at my office, at which there were several colored people. I think Miss Robinson was there. Cross-examined. Have known Mr. Robinson for a year or two. Never heard anything against him, but my acquaintance with him is slight. Ellis Gray Loring. Defendants, with Mr. Bright and wife, were at my office with others to consult about this affair. There was much discussion among them about slavery. The colored people expressed an entire distrust of Mr. and Miss Bright's sincerity, as they were slaveholders. There was much talk as to whether the child ought to be restored. The colored people expressed themselves generally that they could not restore the child if they would. Some of the colored people said the child was ill used at Mr. Bright's, that there were the marks of a bruise on its head, and that her hair had not, from appearance, been combed for a long time. Cross-examined. Have no doubt that I then urged the colored people to give up the child. They assigned 2 reasons for not doing it. They were not sure that they could restore the child, and another suggestion was that the slaveholders, with their smooth tongues, could deceive Mr. Sewell and myself, but could not deceive the colored people. The colored people were very much excited, and so were Mr. and Miss Bright. I was consulted by Robinson and wife as counsel. Previously, another colored person had told me that there was a child at Cambridge who was held by a slaveholder and would arrive soon and be carried into slavery. Was told that the child was permitted to go out of doors. Told the person that if the child was not restrained of her liberty, I doubted if anyone could consciously take the oath on which to found a writ of habeas corpus. They asked what remedy there was. I told them that it was for the child to take its own liberty, that by a late decision in the state, this was the proper course. Was asked by these defendants if they assisted the child to escape, whether they would be liable. Told them they might lawfully receive the child, but had best return its clothing. I think these defendants were some of the people to whom I gave this advice. This was before the child left Mr. Bright. Was told that the child was 7 or 8 years old. If I had known its real age, 5 years, I should have hesitated at giving the advice I did give. Never suppose Mr. and Miss Robinson intended any injury to the child. William Snowden. Saw Mr. Bright at Robinson's house. Told Mr. Bright that the colored people thought the bond for $500 too low, that the child might be sold for that sum, and Mr. Bright would not be the loser if he forfeited the bond. Have known defendants several years. Their characters stand high. The following paper, in the handwriting of Mr. Sewell, was then read by the county attorney. Boston, September 18th, 1837. To whom it may concern. A colored child named Elizabeth, aged about 5 years, having been taken from me on suspicion of being a slave, I think it proper to declare that I do not claim her as a slave, that when she was brought here, it was with the intention of having her free, and so brought up. And though I intend to go to the South and spend this winter, I have no design of taking her back. Miss Bright is attached to the child, and wishes to bring her up to be a useful woman. I hereby promise never to claim the said Elizabeth as a slave, or to carry or send her to the slaveholding states as one. It may be proper to add that Miss Bright is an immediate abolitionist. Henry Bright. On the back of this instrument was endorsed the following. Boston, September 19th, 1837. I further agree and promise Samuel E. Sewell to pay him the sum of $500 on demand in case the said Elizabeth is carried into any one of the slaveholding states by me or through my agency or permission, consideration of his exerting himself to find and restore the said Elizabeth to my protection. The above sum, if forfeited, I agree that said Sewell may apply for the anti-slavery cause. Henry Bright, Boston, September 19th, 1837. For the consideration aforesaid, we guarantee the performance of the above contract. N.F. Cunningham and Company. Mary S. Parker. Miss Robinson applied to me to procure a place for a child whom she supposed to be a slave. Told her I would procure a place. Did procure one, and informed her of the fact. It was understood that she was to send the child to our house at No. 5 Hayward Place. The child was not sent to us. Next saw Miss Robinson at her house in consequence of an interview with Mr. Bright. Assured Miss Robinson that I felt a degree of confidence that the child would not be carried into slavery if returned to Mr. Bright. Cross-examined. Have known Miss Robinson several years. Her character is good. Eliza Parker confirmed the testimony of her sister. End of section 83. Section 84 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jeremy Lindsay, American State Trials, Volume 4, by John D. Lawson. Trial of John and Sarah Robinson for kidnapping, Boston, Massachusetts, 1837, Part 2. The witnesses for the defense. Mr. Parker admitted that the character of the defendants stood high in the community. Mr. Curtis admitted that Miss Robinson took the child out of the street in Cambridge and with her husband and children brought her to Boston in a carriage on the Sunday forenoon in question. Mary Ann Whiting. Am a sister of Miss Robinson. The child remained at Robinson's till Monday morning, when, after Mr. and Miss Robinson had gone to their clothes store in Brattle Street, some 5 or 6 colored people came to Robinson's house and rang the bell. I ran up from the kitchen, and the child followed me. Upon opening the door, one of the men asked me if there was a slave child in the house. I said there was. They then asked if the child by my side was the one, and I said it was. The colored people then put on its bonnet and took her off. I tried to hold the child back, but all the others laid hold of the child and pulled her away. Have not seen the child since, but have heard that she was in Salem and attended a school there. All the colored people were entire strangers to me. Stephen Burt. I was formerly Mr. Bright's slave, but was emancipated by him on the day of the death of the child's mother. She gave her to a colored fellow servant by the name of Eleanor. Mr. Parker stated he was prepared to prove by 10 witnesses the affectionate manner in which the child was treated in Mr. Bright's family. The counsel for the defense said that he did not mean to question that fact. Mr. Parker stated that Messrs. Sewell and Loring, Dr. Wainwright, Mr. Curtis, and himself had urged the defendants to restore the child, but that they had uniformly declared that the child was removed from their control and that they did not know where she was. Thatcher J. to the jury. By the revised statutes of this Commonwealth, C. 125, S. 20, and 21, it is declared that no person shall, without lawful authority, forcibly or secretly confine or imprison any other person within this state against his will, or forcibly carry or send such person out of this state, or forcibly seize and confine, or inveigle or kidnap any other person with intent either to cause such person to be secretly confined or imprisoned in this state against his will, or to cause such person to be sent out of the state against his will, or to be sold as a slave, or in any way held to service against his will. Every such offense may be tried either in the county in which the same may have been committed, or in any county in or to which the person shall be carried. And upon the trial, the consent of the person so taken shall not be a defense, unless it shall be made satisfactorily to appear to the jury that such consent was not obtained by fraud, nor extorted by duress or by threats. Elizabeth Bright, the person alleged to have been seized and confined, was born a slave in the state of Alabama. Her mother belonged to Henry Bright of Mobile, and since her death, the wife of Mr. Bright has taken the special care of the child as her own, and she was living in the family of Mr. Bright at Cambridge on the day of the abduction complained of. Having been brought into the state by her master, she ceased to be a slave, and gained her freedom to all intents, it being established law that the moment that the master carries his slave into a country where domestic slavery is not permitted, he becomes free. This child was as free in respect of legal rights as the child of any inhabitant of the state, and was entitled to the protection of the law. This right has been most deliberately settled by the Supreme Judicial Court of the Commonwealth. They have solemnly decided that a citizen of any one of the United States, where Negro slavery is established by law, who comes into the state for any temporary purpose of business or pleasure, staying some time, but not acquiring a domicile here, who brings a slave with him as a personal attendant, cannot restrain such slave of his liberty during his continuance here, nor convey him out of this state on his return against his consent. That tribunal have also decided that if a child who was born a slave in is about to be carried out of the state and subjected to a state of servitude, they will grant a writ of habeas corpus to bring such minor before them, and require surety in its favor, or even put it under the custody of a new guardian. They have gone to the utmost verge of law and right to withhold such a person from slavery. I shall not enter into the grounds of the decision, nor attempt to scan it according to the rules of the Constitution, but shall consider it as the law of the land and binding on this court. Hence you see that Elizabeth Bright, the child whom the defendants are charged to have abducted by force and against her will, was free at the time and under the highest legal protection, and that she could not be unlawfully imprisoned within the state, nor carried out of it against her will, either by Mr. Bright, who once claimed her as his slave, or by the defendants at the bar. It has been proved by the evidence in this case, and in fact it is admitted and avowed in argument, that on the 17th day of September last, the defendants went to Cambridge, and there, without the knowledge or consent of Mr. Bright, and without any legal authority, took this child and brought her to their house in the city. on the same day, and you are to judge from the evidence whether it does not appear that they, together with certain other persons whose names are not known, have secreted and kept this child confined from her natural friends from that day to the present. The nurture and education of this child had, by a high natural and moral obligation, devolved on Mr. Henry Bright and his wife, and they had assumed and were exercising the responsible trust, nor does it appear that they had treated it other than with kindness or that they were disposed to do so. If the child had been treated with inhumanity, any citizen might have complained in its behalf, and the voice of the law would have responded to the claim of humanity and granted instant protection and redress. But it is evident that the child was happy and contented with its natural protectors on the day of its abduction. The measures taken by Mr. Bright to recover the child prove that he acted with humanity and that he felt a deep interest in its welfare. His statement is confirmed in every material fact by the testimony of Samuel E. Sewell and E. G. Loring, Esquire, Reverend Mr. Snowden, and the Mrs. Parker. Mr. Loring states some additional facts, from which it would seem that a plan was deliberately laid by the defendants and others to get this child into their possession, that they deceived even him as to the age of the child. The advice which Mr. Loring gave to them is no apology nor justification in law for the abduction. It appears, then, that they got the child into their possession, and that on the next day persons came to the house in their absence and took it away. Now it does not appear that the defendants expressed surprise at this fact, or were dissatisfied with it, or that they took any pains to recover the child. And in no subsequent interview with Mr. Bright did they pretend, or have they ever pretended, that they were ignorant where it was. Hence, if this abduction was the effect of a conspiracy, and the defendants were conspirators or accomplices in the act, they are accountable for the offense. If they took this child and carried it away and have kept it in secret, they are responsible for it in law. If they did the act deliberately, the legal presumption is that they intended to confine it against its will. Having inveigled the child into their possession, they are bound to account for the act, and to show that it was for an honest and lawful purpose. For the act of seizing a person and detaining him is prima facie unlawful, and the burden is on the party accused and proved to have taken and detained him, to satisfy the jury that he had right so to do, and that the person was not confined against his will. To show that the defendants were free from an evil intent, and that they acted on the high principles of humanity and benevolence, witnesses have been called to prove that the defendants have borne a good character. Now, gentlemen, if the deed is satisfactorily proved to have been committed by these defendants, their former good character is not to avail for their acquittal, although it may speak much in mitigation of their punishment, especially if, by hastening to restore the child, they should acknowledge their fault. For it would be contrary to all the maxims of law that because a man has once borne a good character, he should not be answerable for a deliberate offense. Besides, it should be recollected that all evil examples, especially the worst, proceed from the good, and are for that cause so much the more dangerous. You are to judge of the act done, and of the intent of the actors. It is admitted that the defendants carried off the child on the 7th day September last from its natural protectors. They have kept it in secret confinement to this day, and they have refused, in this court, to account for it to you, their legal and equitable judges, or to produce it and place it under the protection of the law. Is it alive or dead? Is it in sickness or health? Is it in the hands of the humane, or exposed to neglect, to want, and in the road to moral ruin, and to an early grave? I am free to instruct you that I consider that the defendants are bound in law to produce this child, and to place it under the protection of the law. Hitherto they have set their own will above the law. It is for you to say, on your responsibility, whether they are guilty or innocent of this offense. It is your province to decide from the act done, and the manner in which it was done, with what intent this child was abducted by the defendants, whether to confine it secretly in this state, or to subject it to service, or to send it out of the state against her will. You may be of opinion that it was done innocently, and without an unlawful intent, in which case you will acquit the defendants. From the fact, from the time the child was taken to the present moment, it has been kept in secret confinement away from its natural friends and protectors, and without their knowledge, and that the defendants now refuse to put it under the protection of the law. You must judge of the act done, and of the intent of the actors at the time. You are constituted the judges both of the law and fact, and you must decide whether the abduction of the child and its subsequent secret detention were or not a violation of the law on which the indictment was found. The verdict and sentence. The jury returned a verdict that both prisoners were guilty on the first and second counts and not guilty on the other. Judge Thatcher sentenced them to imprisonment for 4 months in the common jail and to pay a fine of $200 and costs. An appeal was taken to the Supreme Court, but upon request of Henry Bright, the prosecutor, and upon payment of cost, the child having been returned to Bright, and the expenses of the civil suit having been large, the Commonwealth's attorney entered a noli prosequi. End of section 84.
Section 85 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 1. The narrative. For many weeks in the small town of Dawson, Georgia, situated in the cotton belt of that state, the coming of the show had been extensively advertised by flaming posters and newspapers. The whole country for miles around was on tiptoe with excitement, as every rural population is under such circumstances. The day came at last, and black and white, old and young, comprising almost the entire population for many miles around, assembled to witness the wonderful performance of Colonel C.J. Ames' Great New Orleans Circus and Menagerie. All went merry as a marriage bell for a short time. The big circus was opened. Crowds of fun-seekers thronged around the ticket wagon. A small canvas called a sideshow or museum stood to the east of the big circus campus, but directly in the rear of and in full view of the ticket wagon, and contained a wonderful ox, 2 albino women, monkeys, and other wonders, all to be seen for only 25 cents. About 2 o'clock, while persons were passing in and out of this sideshow, and while the whole place upon which the show was held was filled with people in hurry and excitement, going to the wagon to purchase tickets, and from thence into one or the other of the shows, or from one show to the other, and to and fro generally, a difficulty commenced at the door of the sideshow. William R. Russell, with his wife and children and his brother-in-law, Oxford, had bought tickets, and as the party passed into the tent, the doorkeeper said there were not tickets enough for the lot, and a dispute ensued. About the same time, John Kelly, who was also going in with another party, asked the doorkeeper to let him pass in for a moment to see a man who was in the tent. The doorkeeper refused. High words ensued. There was pushing and jostling and excitement in the crowd, few of whom knew at all what the commotion was about. Soon pistols were drawn by the ticket seller and by John Kelly and his brother Charles. Colonel Ames, being in the ticket wagon in full view of the door of the sideshow, got out of the wagon and went to the scene to suppress the row. Soon after he reached the door, a pistol was fired, which was soon followed by other shots in quick succession, until, according to the testimony of witnesses, some 8 or 10 shots were fired. Ames and the showman attempted to get away from their assailants by going under the canvas of the sideshow, on which was painted a picture of the big ox to be seen inside. The pistol shots created great excitement all over the grounds. Women and children who had not yet entered either show fled panic-stricken to the nearest place that promised them shelter and security. Men also ran in every direction. The performance in the big circus had only just commenced, about 500 persons being inside. They could not see what was the matter, but they heard the shots. Many left. Some fled in such terror from the place as to leave the conveyances in which they came behind them. Some remained in the big show, and the performance went on. David Oxford, as he scrambled out of the tent of the sideshow with Mrs. Russell and some of the children, was struck by a bullet and died in a few minutes. Colonel Ames was mortally wounded as he and associates tried to get into the tent for shelter. The body of David Oxford was carried to town. The mother of the 2 albino women and another spectator who were wounded were taken to the hotel, where they could receive surgical aid. But Ames remained at his post for several hours, superintending and directing his affairs, when he was taken to an adjoining house and the best surgical attention given him, but he died from the effects of his wound the next day. John Kelly, his brother Charles, and Russell were indicted for the murder of Colonel Ames. John was tried first and acquitted, largely on account of the failure of the Ames family to assist in the prosecution. Failure to obtain their assistance on the trial of Charles forced the state to abandon this prosecution, as well as the indictment against Russell. Charles and after him, John Kelly, were then indicted and tried for the murder of Oxford, and a verdict of guilty of voluntary manslaughter was returned. But the same night and before he was sentenced, both John and his brother Charles, who had previously been convicted, made their escape from the jail and succeeded in getting safely out of the state. The trial. Footnote: Bibliography. The Ames tragedy, comprising the brief of evidence, together with the speeches of counsel for plaintiff and defendant, the charge of the judge to the jury, and the verdict of the same, with an appendix, compiled and published by Weston Combs, Dawson, Georgia. Macon, Georgia, J.W. Burke and Company. Stationers, Printers and Binders, 1871. End of footnote. In the Superior Court of Terrell County, Dawson, Georgia, May 1871. Honorable D.B. Harrell, Judge. Footnote. Harrell, David Bronson, born 1830 in Washington County, Georgia. Educated privately and studied law in Novice. Located in Luniskin until 1854, when he removed to Webster County. Treasurer of Stewart County, 1856. Solicitor General at Patolic Circuit until 1858, when he retired from practice and settled on a farm. In 1861, joined the Army of Northern Virginia as captain in 17th Georgia Regiment, Toombs Brigade. Elected Judge of Patolic Circuit, 1868. Representative for Webster County in State Legislature, President Bank of Richland. End of footnote. May 25th. The prisoner, John R. Kelly, with Charles A. Kelly, had been indicted by the grand jury for the murder of David W. Oxford. Footnote. Charles A. Kelly was tried on March 9th and convicted of voluntary manslaughter. End of footnote. He pleaded not guilty. The following jurors were chosen: William D. Murray, W. W. Lee, J. E. Harris, George Whitaker, A. H. Adams, Leroy Brown, W. B. Christie, John A. Fulton, Span Reagan, M. Worsham, G. W. Holman, O. B. Stevens, Samuel D. Irvin, Solicitor General for the state. Footnote. Irvin Samuel D., 1823 to 1890, born Todd County, Kentucky. While young, located in Albany, Georgia, where he studied law, was admitted to the bar and practiced. At outbreak of the Civil War, he organized a company of the 18th Volunteer Georgia Infantry, continued in command until late in 1862, when illness compelled him to retire, moved to Macon, Georgia in 1866, and there obtained much distinction in his profession, was a leading mason. End of footnote. C.B. Wooten, F.M. Harper, Henry Morgan, Levi C. Hoyle, R.F. Simmons for the prisoner. Footnote. Wooten, C.B., pioneer lawyer of Albany, Dougherty County, Georgia. End of footnote. The evidence for the state. David J. Young. On 2nd November last was at Captain Tom Hart's shop at my daily avocation. Went to my residence for dinner. After getting to my house, asked my wife where Sonny George was. She said he went out to the show. Eat my dinner and went in search of him. Met some little boys and asked if they had seen George. They said he was in the sideshow or museum. Remarked to a shopmate of mine who was boarding with me, "We will wait till I see Sonny." Was standing in front of sideshow and saw Mr. Russell and a lady I supposed his wife. Advanced to the doorkeeper and started in. They had 2 or 3 children. Heard Mr. Russell remark to the doorkeeper not to insult his wife. Doorkeeper said he was passing in more than he had paid for, that if he had tended to an insult, he begged his pardon and offered him his right hand in token of friendship. Next saw a pistol in the hands of Mr. Russell in the face of the doorkeeper. Mr. Russell said to him if he said another word he would blow his brains out. Doorkeeper then deserted his post and run round on the east side of the circus. For a few minutes the entrance of the sideshow was vacant of a doorkeeper. Immediately after saw a man advancing from the outside with a brass instrument in his hand to the entrance of the sideshow. Shortly after I discovered a man coming from the inside of the show and pushing or forcing Mr. John Kelly out, saying at the same time, "Get out of here. It is no place to raise a row amidst women and children." Recognized a man I supposed to be a showman, from his dress coming from the outside into the gangway of the sideshow. He met Mr. John Kelly and the other showman in the gangway, removed a pistol from his back pocket to the side pocket of his pants. It could not have been more than a minute before they were outside of the gangway. The showman remarked to Mr. John Kelly to put up his pistol, that he had the advantage of him, that he had a derringer, and would blow hell through him. At same time, heard a discharge from Mr. John Kelly's pistol in the air. Second shot was immediately in the earth, and right directly down. Third shot was in the direction to the left of the fly of the tent on the east. Stepped off some 5 or 8 feet and recognized my wife at my fence, waving her handkerchief at me. Started to her, and after I passed about the space of the canvas, then stooped down to pick up the little child that was then to my right. Carried it up to my fence and remarked to some of them to come and take the child, that there was a man dead out there. Turned round and started back. Met Mr. Solomon and Mr. Calloway. They said to me, "Are you shot?" Blood being on my coat from handling the child. Said no, but there is a man dead around here. Turned round and went into my own yard, and did not go out for some time. The showground was in Dawson on Main Street, running by the Methodist Church. Lived on the south side of said lot. Was 8 feet from the Messrs. Kellys. The first smoke that I saw was from John Kelly's pistol. He fired the second and third shots. I started home then. It was not over 50 yards from where I was standing to my house. Started immediately in the direction of my house. Did not go directly to it, but turned to the right. Then went and picked up a little girl. She was folded in the arms of a dying man, then weltering in his blood, lying on his face. The child was crying and trying to get out. Caught the child and pulled her out. Did not examine the child at the time. I took the child to my fence and remarked to some of the ladies to come and take the child. The dead man was Oxford. My first position was on the rail. Saw only 3 shots fired. Think there were but 8 shots. There might have been more. Saw but 3 shots. Cross-examined. It was a very few minutes after Mr. Russell entered the door before the showman came pushing Kelly out. He came from the inside of the show. The man with the brass instrument came up from the outside, before Kelly was pushed out. The man thrusting Kelly out was not the man who had deserted his post. That man was a thick, heavy-set man. His mustache was a light auburn color. The man that thrust Kelly out was a tall man, had on an India rubber overcoat. When they got to the door of the entrance before that, the man from the ticket wagon meets them. He came up pretty briskly and met Mr. Kelly in the gangway. Just about that time, the man shifted his pistol from the back of his pants to the front, in his pocket, and I remarked to Mr. Calloway, "That man is going to shoot somebody." He looked like a man that would. John Kelly had not shot up to this time, and was still being pushed along. Do not remember what was said. Thought that the man pushed was declining a difficulty. Do not remember the exact words used. The man who changed pistols when they got outside remarked to John Kelly, "Put up your pistol or I'll blow hell through you." John Kelly's first shot went up in the air. The second went into the earthen fence. The first shot could have hit no one. The second, I judge from the smoke, hit no one. At the third shot, he was facing towards the east. This shot went between the main tent and the fly. I am satisfied that the last shot could not have hit a man on the inside or on the south side of the main tent. About the time I heard the third shot, my wife called me, and I started immediately. These were the only 3 shots I saw fired. When I started home, I saw the little girl just as soon as I turned the back of the tent, about 20 steps. The man was lying where I first discovered the little child, from the small tent about 35 feet. If the man shot was in the campus or on the south side of it at the time I saw the 3 shots fired, don't think he could have been hit by either one of them. He was not in the range. Think there were 5 other shots fired, but do not know who fired them. I formed the acquaintance of the doorkeeper afterwards. His name was Monroe. Re-examined. The showman who shoved out John Kelly was a tall man in an Indian rubber overcoat. John Kelly did not have anything in his hand then. It was after they got outside that he said, "Put up your pistol." Mr. Kelly was doing nothing with his pistol. He was holding it up. Did not see anyone holding his arm. When I first saw the man shoving out Mr. Kelly, they were about halfway the gangway entrance. Do not know whether there was any words passed between them directly or not. Heard words but do not recollect them. Did not hear Mr. Kelly make any reply to the remark, "Put up your pistol." The showman was before Mr. Kelly at the time I saw him remove his pistol. Saw his pistol before I saw Mr. Kelly's. Mr. John Kelly was facing southwest in the gangway. The man putting him out had his face directly to Kelly's. After the showman passed on from the outside, Mr. Charles Kelly advanced to Mr. John Kelly and caught hold of him. There was some loud talking. Mr. John and Charles and several parties were talking loud. Charles Kelly came up and tried to stop the difficulty, as though to take him away. Did not see Charles Kelly with any pistol first or last. Milton Gamache was at the showground the day Ames Circus was here. Cannot tell the beginning of the difficulty. There was a little fuss started on the outside of the show. Couldn't tell who was engaged in that. There was a little show, not the main show. There was a pistol, a gun fired, which I did not see. That drew my attention, and I turned round to look, and there was then a pistol fired up in the air overhead by Mr. John Kelly. The firing continued with several shots. Saw Mr. John Kelly and Mr. Charles Kelly fire. They fired probably 6 or 8 shots. Don't know who they were firing at. They were firing in the direction of the outside tent. There were 3 men between them and the tent. Did not know them. Their backs were to me. They were getting out of the way of the firing. They went under the canvas, Saw John Kelly fire one shot before Charles Kelly fired. Can't say whether he fired first or last. The 3 men had gone onto the campus about the time the firing ceased. Did not see anyone else fire a pistol that day. The men went onto the campus to the left of the door. The Kellys had their backs to me. Was acquainted with David Oxford. Do not recollect that I saw David Oxford that day, until after he was dead. He was the first I saw outside of the campus, not many minutes after the firing. Do not know how far he was lying from the little tent. Did not go up to them. Cross-examined. Was 30 or 40 feet from the door of the little tent when I heard the first shot. Don't know who fired the first shot. Was not looking in the direction at that time. When I did look around, there was considerable confusion in the crowd. John Kelly's back was to me, and he fired his pistol overhead. Do not know how many shots John Kelly fired. The firing was in the direction of the 3 men. Did not know the 3 men. Neither of them was David Oxford. Their backs were to me. Don't recollect seeing Oxford until after he was dead. Remember the fly with the big ox on it. There was a door to walk in. John Kelly and the 3 men were standing close together, and the 3 men were moving off towards the campus and went under it. Can't state positively how many shots were fired. James Clarke, on 2nd November last, was in the town of Dawson, was in the sideshow of Ames Circus. Heard loud talking at the door. Saw Charles Kelly come in. Went up to him and shook hands with him. The excitement seemed to increase at the door, and he went back out of the campus. Thought there was likely to be a difficulty, and went to the opposite side of the tent and raised the campus and went out. Hurried to the left and went in the direction of the street. When I got about even with the extreme edge of the tent next to the street, heard a pistol fire. There were 2 mules and a wagon on the opposite side of the ditch. Ran and got behind the wagon. In going to the wagon, there were 2 other pistol shots fired. The last ball passing between me and the mule. Passed around in front of the mules and went to the back of the wagon. Saw 2 men coming from round the fly. One down on his left side, on his hip and elbow, the other one holding him by his right arm and helping him along. Saw John and Charles Kelly coming round the end of the fly and shooting in the direction of the retreating men. These 2 men disappeared onto the campus and the shooting ceased about the same time. A few minutes afterwards, somebody said a man was killed, and I went to the place where there was a crowd and found Mr. Oxford there. Was inside the sideshow a few minutes. There was an ox with 3 eyes, some monkeys in a cage, and the albino sisters, and a Negro grinding an organ, etc. Mr. Charles Kelly came in the side door alone. Don't think I saw John Kelly until after the firing began. Loud talking first attracted my attention at the door. Can't remember a word that was said at the door. From the talk it seemed that there was a fuss brewing at the door. Thought it likely some shooting might be done, and therefore went out at the back of the tent to take care of myself. Am not certain how many shots were fired. Somewhere between 7 and 8. The firing was very rapid. There were only 2 men went onto the campus. The Kellys were firing in the direction of the men going onto the campus. I saw no one else fire besides the Messrs. Kelly. Think I saw all the shots I heard after I got behind the wagon. If there were any others, they did not attract my attention. The men going onto the campus had their backs to me and to the Kellys. Think the pistols they had were ordinary Colt's repeaters. The firing was very rapid. It continued not over a minute. The shots were not in succession. A man could not have gone more than 40 feet while the shooting went on. The Kellys were pursuing the 2 men. They were getting out of the way. Cross-examined. Saw Charles Kelly inside the campus first. The loud talking was going on at the time. Met him when I got on the line at the east side of the tent. Heard a pistol, but do not know who fired it, and do not know who fired the 2 next. Know nothing of the commencement of the difficulty. The shot that came between me and the mules could not have passed through the south side of the tent. Saw two men coming round to the end of the fly. About 3 feet from the end of the fly, they went under the canvas. One of the men was on his left side. The other man was helping him along, stooping over. I could not say there was not other firing inside the tent, but I heard no other. William B. Oxford. On 2nd November last was in town here, at the show ground. In the evening, went to the ticket office to purchase some tickets to go in the show. While standing there, heard loud talking going on at my back. I turned to see who it was and saw John Kelly was talking loud with some of the showmen. Very soon I saw the smoke and heard the report of a pistol in the hands of John R. Kelly. After the first fire, the firing continued pretty much all the time till it ceased. Was standing in a northwest direction from the firing. The ticket office was on wheels. It was a short distance from the difficulty. I was 6 or 10 feet from the wagon. Was standing on the old circus ring, which was elevated above the surface of the ground. John Kelly, when the first shot fired, was standing with his back to the canvas, his face rather to the town. When the second shot fired, he was turned more to the east. The first shot went off before the pistol was brought to a level. My impression is the first 2 shots were fired before the pistol was brought to a level. Charles Kelly commenced firing about the time. John Kelly fired the third shot, if they were 5 shooters. I think there were 10 shots. If one was a 5 and the other a 6 shooter, there were 11. There seemed to be 3 or 4 men they were firing at. These showmen, after the second shot, commenced retreating. The shots were fired in the direction of the canvas. The men were very close, not more than 3 or 4 feet at the time of the first firing. The men retreated round the east side of the canvas. The Kellys did not move much, but kept pretty much to the same position. Saw no one else fire but the Kellys. Think I heard about 10 or 12 shots. Did not see the men go under the canvas. They passed out of my sight. The fly was a strip of cloth that run out 3 or 4 feet high. Am not positive whether it came to the ground or not. Saw the Kellys all the time till the firing ceased. From the first shot till the last, not more than 2 minutes elapsed. The firing was as rapid as men could shoot. The pistols were repeaters. Don't know whether they were 5 or 6 shooters. Don't know whether they were self-clockers or not. They fired as fast as men can shoot. I do not recollect anything either of the Kellys said immediately after firing. Saw David Oxford previous to the difficulty. The last time I saw him, he was in the door of the little canvas about 5 or 10 minutes before the firing began. He was talking to Russell in the canvas. The next I saw of him, he was dead. He was lying on his breast on the right side of his face. Cross-examined. John Kelly's 2 first shots, I think, went up in the air. The Kellys and showmen were standing together 15 or 20 feet from the entrance of the little canvas. During the firing, the showmen moved out round the fly and tent ropes, down the side of the canvas. They passed the corner of the fly before they got down. The Kellys stood pretty much at the same place all the time. When the men moved off, it was pretty much in a southerly direction, down the side of the canvas, and with one of the 3 men moving off was David Oxford. Oxford and Russell went into the show together. That was the last I saw of them until after the shooting. Reuben Geiss. On 2nd November was at the showground and went to the ticket office to get some tickets. Kept my family on the sidewalk. As I turned back with the tickets, heard loud talking. Saw John Kelly back a little, raise his pistol and shoot, advancing towards 2 men. They ran back away from him. He shot 2 or 3 times. Then saw Charles Kelly commence shooting. They were both advancing towards the men. The men fell over a rope. They both fired until they had no more loads in their pistols. The firing was as fast as they could fire. Charles Kelly was to my left and John to my right. No one else fired a pistol as I saw. Could not tell how many persons were there. A large crowd of people. whites and blacks, women and children, all sorts. Cross-examined. Did not go into the show afterwards. The show went on as usual. Heard loud talking, harsh words. That first drew my attention. Saw John Kelly. Saw one man at that time, right in front of him. Saw two trying to get under the canvas. John Kelly advanced towards the canvas. John Kelly's first fire was in the air. The next was towards the men. The men going under the canvas fell over rope and were trying to crawl under the canvas. Suppose it was their aim to shoot down, but whether all their shots went that way, I don't know. When the firing ceased, John Kelly had advanced 2 or 3 steps from where he was when it began. Mrs. Mary S. Halsey. On 2nd November, on the day Ames's circus was in Dawson, I was on my way to the circus. My sister, Mrs. Geis, and her children, and Mrs. Lewis and a few servants. My sister had 5 and I had 3 children. Saw a disturbance. It was the report of a pistol that first excited me. Told Mrs. Geis there was going to be a row and we had better leave. But my sister said, "No, let's wait for Mr. Geis." At the report of the first pistol, I took my children and ran. Was to the left of the man who was firing. He was firing towards the sideshow. Ran into a house nearby. James Miller. Saw a difficulty. About the time a man and his wife were entering the sideshow, and as I was turning to come out, met Mr. Russell and the doorkeeper. Mr. Russell appeared to have hold of him with his left hand. His wife held Russell's right arm and his pistol in his hand, and about that time he let the showman loose and passed outside of the door. A new doorkeeper took his place and the show went on. John Kelly came to the door and wanted to see a friend in there. The showman said he could see him for a bit. He replied that he did not want to see the show but a friend. He passed into the show and stayed a minute and came out. And then a difficulty commenced between him and the second doorkeeper. The second doorkeeper had a pistol in his hand, and then a dispute was between them. Kelly backed in the direction of the ticket wagon. Kelly fired in the direction of his right arm towards the big canvas top. By that time, 2 other showmen came in from between me and the ticket wagon, and Big Show, and then all 3 showmen and Kelly were together, and a good many others came around. The 3 fell over or stooped to get under the canvas. The next firing I saw was in the direction of the sideshow, just back of the apron that the ox was on. Don't know anyone that ran up to John Kelly. John Kelly remarked that he did not want friends, that all he wanted was for some friend to give him a loaded pistol. Do not know what was the difficulty between Mr. Russell and the showman. When I saw Mr. Russell, he was pounding him near the shoulder with the muzzle of his pistol. The showman was offering him his hand for friendship. The showman said he had rather let 50 men in than to have ill will to anyone. Saw Mr. Russell and a woman with him and some children, some girls. Russell passed into the show and came out. Can't say how many minutes it was before John Kelly came up to the entrance, but it was a short time. Saw John Kelly fire 4 shots. Men went under the canvas near the apron. Can't tell any words passed between John Kelly and the showman. John came out of canvas and repeated an oath, but can't say what it was. Can't say what showman said to him. Saw a large pistol in the hands of the showman. Cannot say the showman did anything with the pistol. Did not see Charles Kelly during the difficulty. Cross-examined. Do not know what the showman said to Kelly before Kelly was cursing. Mr. Kelly was backed out of entrance. The showman had a very long pistol. Did not understand the showman to say he had a pistol that would shoot 15 times. Kelly was backing out to give himself room. He had room enough to have shot when he first met the man. The first shot was in the air. The pistol was above his head. Did not see but 5 shots. The men came from towards the ticket wagon. They were tangled up together. About the time the 3rd shot was fired, they tumbled onto the canvas. John Kelly shot all of the shots. If anyone else fired, I did not see them. The showman fell down or got down and went under the canvas. 2 shots were fired in the air, the other 2 in the canvas about waist high. He shot apparently over where the men fell over the rope. James H. Price, am a physician, was called professionally to examine David Oxford. He came to his death by a pistol-shot wound. The ball passed through his chest obliquely about an inch below the shoulder blade, to the left of the spine, and went about an inch or 2 below the left nipple. The ball was about 30 to 100-inch caliber. Oxford must have been in a stooping position. The ball passed entirely through the left lung. The wound might cause internal and external hemorrhage. Don't think deceased could have kept on his feet more than a minute, probably not so long. The lungs could not have been inflated fully after such a wound. It must have caused death in a very short time from loss of blood. Oxford was lying full length on the ground, on his face. There was a great deal of blood on the ground. I heard several pistol shots that day. Heard 2 or 3 balls strike the large canvas. Was sitting on the top seat on the west side from the entrance in the big show. Had my little son with me. At the time of the firing, there did not seem to be any excitement. Afterwards, there was excitement. Saw a man lying on the ground, and standing near him was a little girl, very bloody. George Young saw David Oxford the day he was shot. When I first saw him, he was coming out of the south side of the canvas. He raised the canvas. There was a little girl in his arms. He went sort of round to the left, was about 5 steps from Father's fence. He came out about half bent, and did not straighten at all. He stumped his toe against the shafts of the wagon and fell. He was coming right towards me. He did not get up any more. I saw those 2 albinos come out soon after Oxford. Heard some pistols fire. They were fired before Oxford came out of the tent. Cross-examined. Heard 7 or 8 shots that day. Saw Mr. Oxford fall. My father was around in front of canvas when shooting commenced. Next saw Father coming around the canvas towards the fence. Did not see him while the shooting was going on. Did not see him before I saw Mr. Oxford at all. Was watching Mr. Oxford to see where he was going. Looked at him to see the blood running out of his breast, and what he was going to do. My father took the little girl out of Oxford's arms and put her in our yard. Did not see Dr. Price go there at all. Was right smartly scared. Dr. John R. James. Ames's Circus paid taxes to me when it performed in this place. $25 was paid to the council and $25 to the county. Dr. Clement A. Cheatham. On the day of Ames's Circus, was caused to see a lady at the pavilion. When I first saw her, she was about getting into a buggy near the street, near the canvas nearest to the street. She told me she was the mother of the albino children on exhibition. The wound was a flesh one in one of the thighs. It was inflicted with a ball from a pistol or gun. Was also called to see Colonel Ames. There were 3 gunshot wounds on his person, one a very serious one of the right thigh. The ball passed behind the bone. The ball was extracted, a conical-shaped ball, little larger than a buckshot. That caused the death of Colonel Ames. The other wound was in the same thigh about the commencement of the superior third, a slight flesh wound. The wounds must have been received from behind, or more to the right than behind. End of section 85. Section 86 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 2. The evidence for the defense. James B. Avant Was at the circus in Dawson on 2nd November. Heard some loud talking at the mouth of the little canvas. Was on the wheel of the ticket wagon. There were 2 gentlemen in the wagon. One I did not know. The other was the agent. Think his name was Breeze. The other one started to pull out the drawer and asked the agent to move his leg. Breeze asked him what he wanted. He replied, "I want that pistol." He drew out a drawer and got a small pistol 3 or 4 inches long and told Captain Breeze, "Damn 'em, I'll stop the fuss." About when he had time to reach the little door, I heard the report of a pistol. The ball of the pistol whizzed past my ears. Saw the smoke rising about the mouth of the little canvas door. About that time, Charles Kelly turned loose John Kelly. Saw Charles throw up his hand and a pistol fired, and saw the smoke rising to his right side. About that time, John Kelly threw up his hand and fired in the air twice. There were several pistols fired. There were 3 men who seemed to be locked up together who began to retreat around the little canvas, some 10 or 12 feet, and all went under the canvas together. That is all I saw of the fray. This was near 2 o'clock. Cannot tell who fired the first pistol. It was not either one of the Kellys. The Kellys were standing between me and the little canvas, with their backs to me. There were 30 or 40 men about the mouth of the little canvas entrance. Cannot say how many men in the gangway. About half dozen, I suppose. Next thing I saw after the smoke of the first pistol was Charles Kelly shoving John back. Can't say how he had hold of him. Looked like he was trying to keep him out of difficulty. I saw John Kelly when he pulled out his pistol. If he had out his pistol previously, he had it down by his side. Can't say who fired the second pistol. If I had not seen Charles Kelly draw his pistol, I would have thought he fired the second shot. John Kelly did not fire the second pistol. About the time the second pistol fired, John Kelly drew his pistol and fired up in the air. Charles then drew his pistol and turned John loose, so Charles threw his hand down. The movement of the hand was such as a man would see in knocking off a pistol. Thought the smoke of the second pistol went towards the ground. After Charles turned John loose, they both drew their pistols and went to shooting. The first 2 fires of John were up in the air, towards the big canvas. Afterwards, they turned more towards the east of the little canvas. As the party retreated, they fired more to the left of the little canvas. Seemed to me there were 10 or 20 shots. Stayed there until the row was suppressed. Found 11 bullet holes in the little canvas and 7 in the animal wagon. Cross-examined. Went to the ticket wagon to get some tickets for some ladies. People sometimes get on the wheel when they go to buy tickets, and there is a crowd. Had just got up on the wheel when the row began. Heard cursing and loud talk. Don't remember the words. Did not distinguish any of the voices then. The man got pistol out of drawer on the side of the wagon next to me. He got out of the wagon on the west side opposite to me. Saw the man till he got 4 or 5 feet of wagon, going in the direction of little canvas. John Kelly's back was towards me when I saw him the first time. The smoke I first saw was right at the mouth of the entrance to the little canvas. The firing was about half over before the men went under canvas. Charles Kelly shot 3 times. John Kelly shot 5 times. The holes run in the canvas were from the top to the bottom. There were 11 distinct holes in the canvas. There were 7 in the monkey wagon. First thing I tried to do after firing ceased was to arrest John and Charles Kelly. I did not succeed from the fact there were so many men around them with knives and pistols, swearing they would riddle me if I laid hand on them. Went into the little canvas and inquired who started the difficulty. Was acting in the capacity of a policeman that day. Met Dr. Lassiter, who asked me if I had a pistol. Said no, and he told me to come to town and get one. Met Cozart, and after I got my arms went back. Went into the little canvas. There was not a soul there. Saw the gentleman who got out of the wagon with the pistol. Rode up the street in a buggy after the difficulty. One shot lodged in Colonel Ames. Did not see John Kelly's pistol fired the third time. Could not swear that John Kelly had no pistol in his hand when I first saw his, because he had one hand in front of him. Can swear that Charles Kelly did not have his pistol at the time. First saw him draw it from his pants behind or from his side. About the time John Kelly fired the first time, Charles drew his pistol. Can't tell who fired the second shot. I don't know which way the bullets went. Can't tell how many people were on the ground that day. There were a good many. Saw a great many running. Can't tell how John Kelly was dressed that day. My recollection is that he had a beard. Can't tell how Charles was dressed. The men they were firing at, don't know how they were dressed. David Oxford was not one of the men. The men were all strangers to me. As they were retreating, the Kellys bore around the campus to keep in range. They did not turn far enough to turn their sides to me. When the first firing commenced, could not see the pistol. When they commenced firing, they were very near together, after which Charles Kelly bore to the left and got at farthest 5 feet apart. Charles Milton was at circus on 2nd November. Me and John Kelly and his wife went together. His wife and myself stopped outside. Charles had walked in the sideshow, and John asked the doorkeeper to tell that man to step back there. I want to see him a moment. The showman said, I shan't do it. There is always some damn man fixing up a plot to get in here without pay. The doorkeeper ran back in the sideshow. One large man came walking out with a pistol in his breeches pocket and his hand on it, and him and Mr. Kelly got to jowering about something or other. Don't know what. And he says, leave here, or I'll blow hell through you. And he shot twice about on a level at Mr. Kelly, and then Mr. Kelly out with his pistol and shot twice in the air. I broke and run and left. That is all I saw. Did not go inside show. John Kelly and his wife went with me. His wife and myself stopped about 10 or 12 feet from the door. Was standing at the same place when the altercation between the showmen first took place. They were standing right in front of door, about 6 or 7 feet from me. There were lots of men standing round besides John Kelly and the showman. If Charles Kelly was there, never saw him. Saw Charles Kelly towards the last of the fracas. Charles Kelly sort of took hold of John by the shoulder and said, come, let's go. It was after the shooting that Charles took hold of him. Charles was not there trying to get John off before the shooting, not that I saw. It was a minute or two from the altercation till the firing took place. The big showman said, leave here, or I'll blow hell through him. There were 2 more showmen. Charles Kelly did not come until about the time the last pistol was fired, and caught hold of John and said, let's leave here, and have no difficulty. Somebody presented a pistol behind John Kelly's head. It was a showman. The showman cursed a good deal at John Kelly. The man that did the shooting was about the size of Mr. Wooten with a broad brim hat on. He was a very red-faced man. He had shot once, and then Mr. Kelly went to getting out his pistol. Do not know what Mr. Kelly was doing at the time. Think he was giving back a little. Charles, when he came, sort of caught round John and said, let's leave and have no difficulty. John had already shot in the air when Charles caught hold of him. Cross-examined. Came to Dawson that day with my brother George. Did not swear on the other trial. I came to Dawson with John Kelly. My father lived about a mile from John Kelly. Did not see his wife take hold of him and tried to keep him from having a difficulty. Was behind John Kelly and the doorkeeper. John Kelly and the doorkeeper were near the fly, outside of the entrance. The showmen were facing the ticket wagon. Believed John cursed some. After John Kelly shot his last shot, saw Charles Kelly. Saw John shoot 2 shots. Did not see Charles Kelly shoot. Saw him draw a pistol. There was right smart of folks getting away from there. I was scared. Right smart. The man that put the pistol behind the head of John Kelly was sort of to his side, and that got round sort of behind him. Never took particular notice of him. He had been standing there ever since the big showman had been there. They all three came out of the little show. Never noticed his hat. Can't say what sort of coat he had on. Don't know where Charlie came from. Mrs. Kelly broke and ran as soon as the difficulty began, when they first commenced throwing the dams. Don't know what John Kelly and the showman commenced quarreling about. I don't know how John Kelly shot. Did not see Charles Kelly shoot. I broke and run and did not see Charlie till I got to the corner of the fence. Have seen Milton Garmish. Did not see him at the time of fuss. Did not see David Young that I know of. Did not see James Clarke. Think John Kelly had a repeater. Don't know how he came to shoot in the air. Dudley Kitchens. John Kelly had his wife and her cousin, and when he got near the show he told the ladies to stop, and he went up to the door and asked where the doorkeeper was. A man with a large pistol came and told him, God damn him, leave the ground, that they were not to be bluffed off that way, and that if he did not leave there, he would blow hell through him. He caught him on the collar with his hand and cursed him. Two other men took hold of him by the coat collar. They all talked very loud to him and cursed, and a large man with a derringer up his sleeve gathered him by the waist and stuck his pistol to the back of his head and told him to look here. I've got the advantage of you. I'll blow hell through you if you don't leave the ground. Kelly pulled out his pistol with his left hand as soon as he saw the derringer. As soon as the man saw the pistol in Kelly's hand, he backed off about 8 steps and told him, God damn him, put up that pistol. Kelly told him to put up his, that when he had done so, he would put up his. He said he would not shoot him till he, the showman, shot him. The showman says, well, God damn you. If you won't put it up, I'll make you, and shot at him. The large man with the 15-shooter shot at him too, and there was very little distinction between the shots. The third shot was Mr. Kelly's first. From this they kept up the firing until it got so thick I ran. After I ran, I never heard another gunshot. That's all. His wife's cousin, Martha Reynolds, went with us, was standing 8 or 10 steps from the door right in front of it. When they came up, John Kelly's wife stood there and hallooed and screamed. Saw Charles Kelly when the difficulty arose. At that time he was standing right by his brother. Saw Charles Kelly shoot once. The showman's face was towards the canvas, and they had Mr. Kelly backed up against it. They shot west. The Kellys shot a little in the direction of the Tanyard. Cross-examined. Was standing in about 8 or 10 steps of little show. The showman was shooting across the canvas. The Kellys a little toward the Tanyard. I am in my 14th year. Was not with John Kelly and wife when they came. Charlie Melton and myself were standing not far apart when they came. Had been there about half an hour. Was about 5 steps from Mrs. Kelly when the difficulty began. Saw a quarrel between Mr. Russell and the doorkeeper. When the lady and the 2 girls went in, the doorkeeper probably held off the lady and jerked her out. And the showman said, give me a better dollar. No gentleman would take any such money. Mr. Russell said, give it to me. I am a gentleman. And I took it. Then he took the lady and went away up the street. 15 minutes before John Kelly came up, there were lots of men standing around, and he asked, gentlemen, do any of you know where the showman is? There was no reply that I heard except that the showman jumped up and grabbed him right on the collar. That was the first thing the man done. He said, God damn you, leave the ground. We are not to be bluffed off in this way. Mr. Kelly said nothing. 3 or 4 were gathered hold of John Kelly. Can't describe the 2 men. They seemed to be all large men. One came from inside, one from the other side, and one from the ticket wagon. They all took hold of Mr. Kelly. John Kelly did not have his pistol out at first, and never drew it till one of them stuck a pistol to the back of his head and told him he would blow hell through him. John Kelly got his pistol out from a case he had belted around him under his coat. The men all had hold of him. Mr. Kelly did not draw his pistol till that man stuck his pistol to the back of his head. Charles Kelly walked up there by his brother's side. Charles never did anything till they commenced firing on his brother. By this time they had jammed John Kelly up against the canvas, and when he drew his pistol, backed about 8 or 10 steps and said, "Damn you, put up that pistol." Did not see Charles Kelly take hold of his brother. Never saw Charlie Kelly draw his pistol. Saw him shoot but once. Recollect the picture of the big ox. Did not see any of the showmen go round it. Some of the men went into the show, some under the canvas at one side, some at another. The Kellys started off just as they quit firing. I ran on ahead of them. They came right straight to town. Did not hear Mr. John Kelly ask for another pistol. No, Mr. Avant, but did not see him then. Charlie Melton was a little ahead of me. Charlie came on to town just ahead of me. Did not see him standing at the palings aside. Am certain the Kellys were firing towards the tan yard, and the showmen towards the canvas. Am certain John Kelly did not go inside the little show. Am certain the big man jumped out and caught him by the collar. Saw the 15-shooter. It was about 18 inches long, a very large pistol. It was not mounted with brass or silver. It was a common, plain pistol. The man had hold of Kelly's collar with his left hand, waving it about with his right and swearing what he would do, and saying he could not be bluffed off that way. The showman had a pistol apiece. One of the pistols was a Smith & Wesson, the other was a Colt's repeater. Don't know whether the pistol was cocked or not. Can't describe the man. He was a large man. I disremember whether he had on a beard or not. The other man had a Colt's repeater. It was the man with the Derringer who fired first at John Kelly. He said, "God damn you, I'll make you put up your pistol," and fired. The man with the 15-shooter also fired. The man with the Smith & Wesson, after 3 or 4 shots, commenced firing too. The man with the 15-shooter shot next after the Derringer. Mr. Kelly shot next. The 3rd shot was Kelly's first. Am certain the man with the Derringer shot towards the canvas. One of the showmen shot the 4th shot. The man with the Smith & Wesson and the man with the Colt's repeater both shot. S.A. Whitten. On 2nd November, I was at the show when the fracas took place. Was about 5 feet from the door of the sideshow. I was there when Mr. Russell came up and was passing his family in, and the showman caught his wife by the shoulder and jerked her round and ordered her out. And then they settled it, and Mr. Russell and Mrs. David Oxford passed in the show. About 4 minutes after, John Kelly came up and inquired for the doorkeeper, who had disappeared. Some 2 or 3 of the showmen came up and cursed, as though they were trying to raise a fuss with Mr. Kelly. Somebody called out for Colonel Ames and his gunmen. One came in front of him with his pistol in his hand. One came up behind, and having presented a pistol in his hand, said nothing, as I heard. The other one in front was cursing him, telling him he had the advantage, telling him he would blow hell through him. Kelly walked back, saying he wanted no fuss, and he kept following after him. I turned and walked off, and then heard a pistol shot and looked back. 2 pistols fired before I saw anyone. Mr. Kelly's pistol fired in the air. Heard John do nothing to produce the difficulty. Heard him only say, "Where is the doorkeeper?" When he caught him by the coat, heard the showman say, "You are trying to push in the show." They said something else. I did not understand what. He then called for Colonel Ames and his gunmen. He pushed Mr. Kelly back. Mr. Kelly remarked, "Don't crowd me." Can't tell who shot the first fire. Mr. John Kelly had his pistol in his hand, but I did not see him shoot. Saw Charles Kelly come up to John Kelly. They had hold of John when he came up and tried to crush the fuss, and then turned and went back about 6 or 7 steps and was there the whole time the shooting was going on. There were 12 or 15 shots fired. Did not count them. They were so fast. Cross-examined. Did not see the showman when John Kelly came up to inquire for the doorkeeper. Heard the remark very distinctly. It was in the usual tone of voice. Mr. Kelly did not have his pistol in his hands at that time. Do not know who Mr. Kelly addressed his remark to. Did not hear Kelly say anything else before the showman came and took hold of him. The showman was a good-sized man and had on light clothes. Don't remember his hat. He had a small pistol in his hand, 4 or 5 inches long. He called it a derringer. Did not hear him say to Mr. Kelly, "Put up your pistol. This is no place to have a row." Mr. John Kelly was stepping back and saying, "Don't crowd me." Did not see John Kelly draw his pistol. Saw the pistol presented at the breast of Kelly. Do not know whether it was cocked or not. Don't know where Charles Kelly was, nor where he came from. Don't know who fired the first and second shots. John Kelly fired the third. Am not related to Mr. Kelly. Heard several persons screaming. Saw several persons running. Did not see Charlie Melton. Was not acquainted with him or Dudley Kitchens. No Milton Gamache. Do not recollect seeing him. And positive Mr. Russell went into the show when the difficulty was settled between him and the doorkeeper, and that Mr. Oxford went with him. William R. Russell. On 2nd November, went to the show with my family. Went up to the doorkeeper and asked him what he charged for admittance. He said 50 cents for me and my wife and a quarter for the children, except the least, which went in free. Paid him the money and he told me to pass in. Spoke to my wife and children and told them to pass in. He remarked there were 7 gone in. I said there were only 4. You're charged 4. He said 7. I said he was mistaken. There are only 4. He jumped down off a box on which he was standing and caught hold of my wife and jerked her back with an oath. "Come out of here. You shan't none of you go in there without you pay for the other 3. My wife would have fallen to the ground, but she fell against me and dropped the child to the ground. Had a child on my right arm. As he jerked her back, I threw my hand on his coat and caught him by the collar and shoved him back and said, "If you want to impose upon anybody, impose upon me and not upon my wife in that manner." My wife, Mr. Kindale, and Mr. Oxford came and took hold of me and said, "Have no difficulty. Let's go into the show." Turned him loose then, and my wife took hold of my arm then with Mr. Oxford. After we got in and was looking at the ox, my little girl said, "Look, Pa, what is that in yonder?" It was some monkeys in a wagon. Heard some loud talking at the door, said to Mr. Oxford, "I believe there is going to be a difficulty at the door." Heard a pistol fire. In 2 or 3 seconds there were 2 fired right as fast as possible. Soon ran across the campus with one of my children. Told the rest to follow me. When I got across, I set my child down and raised the curtains, and let the curtains rest on my shoulders with my head inside. And as my children came, I would catch them and push them from under the canvas. My wife came up, took her by the dress, and shoved her out too. After they all got out, missed my little boy and looked back for him, and saw Mr. Oxford go to my right side. Saw a man standing right in the door where it empties in the canvas, with a pistol in his hand. The pistol slightly lowered and extended. He was looking right round where we were, and I saw the smoke rising from his pistol as though he had just fired, and was letting down the pistol. Dropped the canvas and got out on the outside. When I got outside, Mr. Oxford was just to my right. My wife and children were just before me. Saw on Mr. Oxford's beard where blood had run out on his whiskers. He turned his head over his left shoulder and said, "Lord have mercy." The blood flew out of his mouth on my child's dress and also on my wife's dress. My wife spoke to me and said, "Let's get away from here." Took my family and children and went in a southeast direction. We went on to a house where I learned Mr. Young lived. My wife was a good deal excited. The doorkeeper was a tolerable large, heavy-built man. Was the same man I saw with the pistol in his hand. Heard balls strike, I think, Oxford. It was a very short time after I heard the ball strike before Oxford said, "Oh, Lord." The ball struck Oxford as he stooped to go under the canvas. It was a 5-inch barrel Colt's repeater in the man's hand. It was not over 5 seconds after I heard the shot before I saw blood gush from Oxford's mouth. There was no settlement of mine in the doorkeeper's difficulty before we went in. Was standing in a stooping position looking back when I saw the man, Oxford, pass out, touching me as he passed out. Cross-examined. My wife, Mr. Oxford, and 4 children were with me. Had one in my arms and she had one. The little children were not to be charged for. He charged me $1.50, 50 cents each for myself and wife. Had a child on my right arm. The showman said, "Pass in." When I had paid the money, my wife went in front. Mr. David Oxford was just before me. The doorkeeper was standing on a box to my left. Got out the money with my left hand. Can't use my right hand. The doorkeeper ran in and jerked my wife back. She had got into the far end of the gangway. The other 2 children were just in front in a bunch together. Oxford was just before me and my wife 2 or 3 steps ahead. Oxford and myself both stopped when the doorkeeper said, "There are 7 gone in." I quietly replied, "You are mistaken." He walked in and jerked her back so violently that the child fell to the ground. She would have fallen herself if she had not fallen against me. We were about middle way of the entrance at the time. Had no pistol in my hands. I presented no pistol to the showman. Mr. Oxford, my wife, and Mr. Ken Dale said, "Let's have no difficulty and either go in or out." I remarked, "I have paid my money and we will go in." The showman urged no objection to the money I handed him. There was no difficulty about that. The showman did not say to me that was a bad dollar and that no gentleman would take it. I did not say to him that I was a gentleman and that I had taken it. There was nothing said about the money at all. When I passed on into the door, I left the doorkeeper not quite in the middle of the entrance. He had some money in his hand. I saw the 3-eyed ox the first thing. He had 2 horns. He was a medium-sized ox. I saw the monkey wagon, then say 2 small albinos and a large one. The first thing I did was to look at the ox. The next thing I looked at the monkeys. Heard the first pistol fired just as I started to the monkey wagon. When the first shot fired, said to Mr. Oxford and my wife, "Let's get out of here before we get hurt." Oxford said, "Yes, we had better get away from here." When the second shot fired, we had started across the canvas to go out. Did not see who was shooting. It was outside of the door. Put my right shoulder under it. Had the child and put it down and then raised the canvas. There was pretty rapid fire going on the outside. Mr. Oxford was about the last one went out. He passed out at my right side. He passed out immediately after my wife and children. About the time I straightened up, Oxford looked at me and said, with the blood gushing out of his mouth, "Lord have mercy." Heard that my wife's brother was killed while we were at Mr. Young's. Did not see David Oxford fall. Did not go to where he was lying. Did not tell anybody he was hurt that I recollect of. When I left Mr. Young's house, I went back to look for my little son. He got separated from me at the door of Little Show. Went to Dr. Chetham's office from there. Looked at deceased a moment and then went to Mr. Knott's. I left Mrs. Russell at Mr. Young's. Next saw her at Dr. Chetham's. Did not try to go back to have a difficulty. If I had out my pistol at Dr. Chetham's, do not recollect it. May 26th. Mattie Reynolds was here on 2nd November last when Ames Circus was here. Came with Mr. John Kelly and his wife. He carried us down to the circus and got tickets to carry us into the sideshow and circus. And there was a gentleman in the sideshow he wanted to see, and he asked the doorkeeper to let him go in one moment to see him. The doorkeeper wouldn't let him go in, and John Kelly asked him to call him out. He told him no, he would not do it, but there was always someone fixing some damn plot to see what he had for nothing. When he told that, John Kelly walked off among some gentlemen, and when he walked back there was a showman out with a pistol up his sleeve. He drew his pistol up and ordered John Kelly to leave the ground, and if he did not, he would blow hell through him. John Kelly took out his pistol, and the showman ordered him to put it up. John said if showman would put up his, he would, and the showman shot at him. And then there was a gentleman came out and said he would scatter them, that he had a 15-shooter. The gentleman with the 15-shooter shot, and then John Kelly fired. John Kelly's was the third shot fired. The 15-shooter shot once more and won. 3 more showmen came out and shot. John Kelly was through shooting then. Mrs. Kelly and myself stood about 10 or 12 feet from entrance to sideshow. Charles Melton went down then with John Kelly. He was standing somewhere else. John Kelly only went to the door. He spoke kind to him. Doorkeeper spoke rough. Mr. Russell was having a fuss with the doorkeeper, and he ran, and John Kelly stepped off a short distance. Another doorkeeper came to the place. He was a large man. He had on a fur hat and a short coat. Don't know the color. When John Kelly came back, there was a tall gentleman there with a pistol. He said it was a derringer up his sleeve, and he said for him to leave there or he would blow hell through him. There were 2 shots before John Kelly fired. His wife screamed twice. She was frightened. Charles Kelly tried to get John out of the fuss. Cross-examined. Did not see John Kelly go back into his house that morning to get pistol. John Kelly bought 6 tickets that morning. We did not go in at once. Don't know why. Mr. Russell was a quarreling when I got there. Mr. Russell had a pistol in his hand and threatened to shoot the doorkeeper, and he ran. The children were standing in the doorway with their mother. Mr. Russell had a baby in his arms a part of the time. Mrs. Russell and the children ran off when the doorkeeper did. Russell stayed there. Mr. Kelly then walked back. Mr. Russell was standing there. Mr. Russell ran up and shot twice at the showman and ran. The showman was a short distance from the door when the showman came out and shot at John Kelly. Mrs. Kelly took hold of his arm. That man with the derringer came out from between the little show and the canvas. John Kelly fired 5 shots. One showman fired once, one twice. Can't tell how many shots exactly. Saw 5 showmen there. I did not see Charles Kelly fire but 2 shots. He and John were about 2 feet apart. The showmen fired as fast as they could. Mrs. Amanda J. Russell was at Ames show. Went into the small sideshow. Me and Mr. Russell and the children. And Brother Dave and his child went in together. After we got in a minute, the doorkeeper of the small sideshow came in and jerked me round like he was mad and ordered me out, saying, "You have not paid your way in yet." Mr. Russell followed on and caught him by the collar and told him not to impose upon me, that I was his wife, and that he had paid my way in there. Took hold of Mr. Russell, and so did Brother Dave, and told him not to have any fuss, and that the showman would do right. Thought we had got the difficulty stopped. Then Mr. Russell, myself, children, and Brother Dave Oxford went into the show together. Soon heard a fuss outside, and 2 or 3 pistols fired. Brother Dave and Mr. Russell both said, "Let's get out of here." We went out of the south side of the campus, not out of the door. Mr. Russell held up the canvas and told us to go out. He passed out the children and myself. Brother Dave was to the right of Mr. Russell. As we got out of the circus, I discovered that Brother Dave was wounded. The blood fell on my clothes and on my little girl's clothes. Was scared, looking to be shot every moment. We went on to Young's house. Cross-examined. Am the wife of William R. Russell. Had been inside the show before the showman pushed me back. Had looked at nothing. Believe Mr. Russell went in first. Brother Dave ahead of both of us. Both little girls and little boy along, who ran back and did not go in at all. Do not recollect that the showman asked Mr. Russell's pardon. Did not see Mr. Russell have a pistol out. Myself and the little girl did say, "Oh, Pa, don't do so. Don't have a difficulty." Did see the showman with a pistol. Mr. Russell did not seem to be much excited. I do not know whether Mr. Russell was drinking or not. If he was drinking any there, I could not tell it on him. Kept Mr. Russell at Mr. Young's a half hour. He wanted to go and hunt up Brother Dave. Mr. Russell did not find our little boy for 2 hours. Did not see any of the shooting. I think I heard or saw a bullet make a hole in the canvas right in front of me. As I went out of the canvas, heard as many as 3 shots before we started. The firing was heaviest just as we went out. End of section 86. Section 87 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 3. In rebuttal, Richard C. Peoples. I heard Mr. Russell in the trial of Charles Kelly describe how he stood when he went out of the small show, was then a juror in the case. Mr. Russell then said that, as he started out, he stooped and held the canvas on his left shoulder, and as he went out he looked back, turning his head to the right over his right shoulder. He said he was in stooping position, looking back on his right at the showman with the pistol. He said he went to the left of the street into Mr. Young's house. Cross-examined. My recollection is that Mr. Russell said he had the canvas on his left shoulder. Don't think I can be mistaken. Tim Sullivan. Was at the showground the day Ames Circus was here. Saw Mr. Kelly and the showman standing at the door having some words. Don't know exactly what the words were. At first the showman said he might scare some people, but he could not scare him. Then the showman was standing at the door, pulled out his pistol and held it at his side. Mr. Kelly stepped round and shot his pistol off in the air. He shot his pistol the second time in the ground. Saw 2 shots fired. Then I moved off towards the fence. I saw the showman fire. Don't know what sort of a pistol the showman had. Saw no difficulty between Mr. Russell and showman. Cross-examined. The showman had a pistol in his hand to his side. Mr. Kelly was about 5 feet from him and was not advancing, but retreating from the showman. Jacob L. Solomon. Was at the showground the day Colonel Ames was here. I was at the sideshow. Went down to get some change, and whilst I was there Mr. Clarke came up and told the doorkeeper to take out pay for 2, and I remarked, for 3. I think it was John Clarke, and he said, all right, come in with me. Mr. Russell was standing there at the time, and he asked the doorkeeper what was the price of tickets. He told 25 cents apiece. Mr. Russell remarked that was too much for children. The doorkeeper said, fetch up your children and let me see them. Mr. David B. Oxford had a child in his arms and remarked, do you charge for this child? And he said, no, sir, I do not. If he was larger, I would not. Remarked, you have a $5 bill of mine, and he said, yes, and I will give you your change in a moment. Went inside of the tent. By the time I got to where the big ox was, I heard a screaming of women and children, immediately turned and ran out of the tent, and as I got to the door, I saw Mr. Russell make a pass at the doorkeeper. A blow. His wife and children had hold of him and were hallooing and screaming, saying, oh, don't. The doorkeeper broke and ran, went round to the right of the tent into the big tent. In a few minutes, Colonel Ames came up with 2 other men from the big tent, or from that direction. They went into the door of the small tent and got into a conversation with Russell, and told him not to create a disturbance, that they could scare the women and children, but could not scare them. Colonel Ames was talking to Russell, and Russell started to draw a pistol, and Ames drew a small derringer and said, "Put up your pistol. I have the advantage of you." One of the showmen, a large man, ran up and drew a pistol, and Charles Kelly said, "God damn you, put up that pistol." The showman put up the pistol. Just about that time, the two Kellys fired, and Mr. Russell also, and then the showman fired 2 shots, and then he and Colonel Ames and a Negro broke and ran, and rolled themselves right onto the tent. The two Kellys continued firing until they had exhausted their pistols, and John Kelly remarked, if he had a friend, that he would furnish him a pistol until they could clean out the Yankees, or the show. Don't know which. There was no firing after this was said. Charles Kelly told the showman who had drawn his pistol, "God damn you, put up your pistol," and the showman did so. About this time the firing commenced by John and Charles Kelly and Russell. 3 shots appeared to be fired simultaneously. Don't know the name of the showman that fired. He was a large man and fired in the direction of John Kelly. The showman fired 2 shots and broke and ran. They turned up the fly of the tent and rolled into the tent. John and Charles Kelly fired in there until they disappeared into the tent, fired in the direction of them as they went under the tent. Cross-examined. Am quite hard of hearing. It is probable a good many things were said that I did not hear. Russell was drawing his pistol and had it at a level at his side when Ames came up. Ames said, "I have the advantage of you." Did not heard him say that he would blow hell through him. It was a large showman that shot. Only one showman shot. Charles Kelly came up side of Russell and John sort of following. The large man with light suit had what I judged to be a Colt's repeater. Charles Kelly, previous to his fire, told him to put up his pistol. Saw no showman except this one and Colonel Ames have pistols. Charles Kelly seemed to come up from the left of me, rather back of me. John came from towards the big tent, did not see them come together. The showman broke and ran backwards, all in a body together, and rolled right under the tent to the left door. James Miller. I saw Russell after the firing, was to the left of the body of men who had huddled together, coming from the direction of left of sideshow. It was not a great many minutes. John Kelly was then arming a crowd of his friends. Don't know where Russell went. As I came away, don't recollect that any person was with Russell. Next time I saw Russell, he was just below Dr. Chetham's store. He was wanting to go back down to the show. Kin Dale was holding and talking to him to keep him from going back. He did not struggle much, but wanted Dale to go with him. The speeches of counsel. Opening argument for the state. Mr. Irvin. Gentlemen of the jury, at length, after over 2 days of calm and patient investigation, the testimony has been delivered from the stand. The witnesses, upon whose statement of the facts you have to be controlled in making up your verdict, have performed their parts upon the stage, and have retired behind the scenes. Yourselves, my brethren of the bar, who represent the prisoner, myself, and the court, are left the sole actors in this unfortunate drama. One by one we shall pass away, until you alone are left, the sole arbiters between the state and the accused. And when you shall have played your part, the curtain will drop upon the entire performance, leaving to the calm judgment of the future, when the feelings and prejudices of the hour shall have passed away, all our acts for approval or disapproval. The right of trial by jury is one of the most sacred rights known to our laws. It has cost many drops of precious human blood and millions of treasure, but it is only of value when the duties of jurors, in cases like the one at bar, are conscientiously performed in the fear of God and with an eye single to the best interests of society. You, gentlemen, have been selected on account of your supposed impartiality between the state and the accused. Our legislators, looking to an impartial administration of justice, have framed a series of the most sifting questions to be propounded to every juror, the sole object being to get men who are free from bias or prejudice, either for or against a person accused of crime. No man is to be prejudged. All men are by the law presumed to be innocent until the contrary is manifestly made to appear by legal and competent evidence. The theory of the law, therefore, is that your minds, when sworn as jurors, were like this piece of paper, without a spot or stain of passion, sympathy, or prejudice. Your judgment is to be made up from the evidence and the law, and must truly, if you give a righteous verdict, reflect and give expression to that evidence and the law in a written verdict, like one or the other of these. Footnote: Mr. Irvin held up before the jury 2 pieces of white paper, upon one of which was written guilty, upon the other the words not guilty. End of footnote. Within the recollection of your speaker and most of you, gentlemen of the jury, there was a wonderful discovery made of an art, by which the image of the human face divine could be reflected, and so perfectly and durably impressed upon a plate of polished metal, that any friend or person who knew the original would at once recognize the likeness, and without any effort of the mind, be able to name the friend or acquaintance who had sat for the picture. I would compare the trial by jury to the process discovered by Daguerre, and impress upon your minds the striking analogy existing between that process and a fair trial in a case of this kind. First, a plate was burnished until there was not left upon its surface a single spot, or speck of any kind, to mar its beauty, or detract from its perfect similitude to the object sought to be impressed upon it. If the least spot, undetected by the operator, was left upon the plate, the beauty of the picture was marred, the likeness imperfect and worthless, and a new plate, free from the blemishes of the first, had to be prepared and substituted before a perfect likeness could be impressed upon it. So if there is left upon your mind the least spot or speck of passion, sympathy for, or prejudice against the accused, you are not impartial jurors, according to the intendment of the law. The beauty and symmetry of your finding will be marred. Your verdict will not properly reflect the evidence of the witnesses, or the law applicable to the case. Injustice will either be done to the accused, or a violated law will go unvindicated, and those of intelligence like yourselves, who witnessed the trial, will be unable in your verdict to recognize the true outlines, features, and expressions of the case as made before you by the evidence and the law. But there is another analogy to which I wish to direct your attention. In the process of which I have been speaking, the whole form and features of the sitter had to be placed fully before the camera ere the operation commenced, which was to transfer the likeness of that form and those features to the polished plate. The nose or the mouth or the eye or the forehead could not be separately taken, and then all blended together into one harmonious whole, and a perfect picture or likeness produced. So if you should attempt to make up a judgment by piecemeal, you would not succeed in coming to a just and righteous conclusion. The evidence of the witnesses must first be heard, and the argument of counsel on both sides, who view the evidence from different standpoints. And I bespeak in advance for my brethren who appear for the defense a patient hearing. You have already heard the facts from the witnesses as detailed from the stand. Those facts, from your standpoint, the jury box, have doubtless made certain impressions upon your mind. Hear those facts again from counsel for the defense, from another standpoint, and see what change that may produce in your minds, or note the difference in the impression upon their minds and your own. Then listen to those same facts as I shall detail them in conclusion. See which of us is right, which wrong, or where either of us and yourselves agree or disagree. Weigh all the facts well. Hear our version, then compare ours with your own. Prove all things. Hold fast that which is good. We are searching for truth. The object of all our labor in this investigation has been to arrive at truth and to avoid error. Truth crushed to earth shall rise again. The eternal years of God are hers. But error, wounded, lies in pain, and dies amid her worshippers. If your verdict speaks the truth, it will speak what the law intends, and what justice requires, and our labor will not be in vain, whatever may be the result. Having heard argument of counsel, then hear the charge of the court. The legislature, in kindness and in the interests of humanity, has invested one with power to speak for the law, to explain to you what the law is. And while it is true that in criminal cases the jury are the judges both of the law and the facts, it is the veriest nonsense to say that 12 men, taken from the common walks of life, however intelligent and however honest, can become full-fledged lawyers in the course of a single trial of this kind, so as to be capable of judging what is law and what is not law. If you, in your blind judgment, should determine that to be law, which is not law, how fearful is your responsibility? Then the safest and best way is to take the law from the court. If he gives it to you wrong, there is a tribunal to correct him. If you set yourselves up as judges of the law in opposition to him, your will may be regarded as supreme. Gross injustice may be done, and there is no power to correct you. Then, after all is done, after the court gives you the law in charge, and you retire to your room, the preparation for a just verdict is complete. The sitter is before the camera. The plate rightly prepared is ready for the impression to be made upon it. The picture will be a true picture, and the likeness and similitude of the evidence and the law applicable to the case. Anyone who heard them and knows them will at once recognize the result is true. Your consciences will be at rest, and you will receive a just reward in the commendation. And who would ask a greater? Well done, good and faithful servants. Your attention is requested while I, as briefly as possible, attempt to put before you the law applicable to this case. I am bound to give counsel for the defense notice of the law upon which I rely, and this is right. No advantage, even in argument, should be of him who is upon trial for his life. I beg leave first to call your attention to an act of the legislature of Georgia, approved October 18, 1870, entitled, An Act to Preserve the Peace and Harmony of the People of the State and for Other Purposes. Section 1st provides that from and immediately after the passage of this act, no person in said state of Georgia shall be permitted or allowed to carry about his or her person any dirk, bowie knife, pistol, or revolver, or any kind of deadly weapon to any court of justice, or any election ground or precinct, or any place of public worship, or any other public gathering in this state, except militia muster grounds. I shall use this law for the purpose of showing that upon that unfortunate day of November, 1870, the defendants, John R. Kelly and Charles A. Kelly, appeared in Dawson and went to that show ground in violation of the public law of the state. In other words, that they were unlawfully there. The next statute to which I call your attention is an act entitled An Act to Levy and Collect a Tax for the Support of the Government for the years 1869 and 70, and for other purposes, approved March 18, 1869. Acts of 1869, page 160, section 11 provides that all circus companies shall pay $100 for each day they may exhibit in cities containing a population over 10,000, and $50 in all cities containing a population between 5 and 10,000, and $25 in all towns or other places with a population under 5,000. I shall use this act in connection with the evidence for the purpose of showing that Ames Circus Company was in Dawson lawfully on that day, that having complied with the law of the state as well as with the ordinances of the town, by the payment of $50, it had a right to be here. I shall take the position in conclusion and hope to maintain it to your satisfaction, that if Colonel Ames or the men of his show, acting under his authority, after this assault was made upon them, had taken the life of any of the assailants, they would have been justifiable under the law. That it was not only their right to protect themselves, but that it was a sacred duty of still higher obligation to protect and defend the helpless women and children and other guests who would come on that day to witness their exhibition in Dawson. I call your attention in the next place to Section 4442 of the Code of Georgia for the purpose of showing that the defendant John R. Kelly, in connection with his brother Charles A. Kelly, was guilty of another violation of the law of the state on that day by engaging in an affray in a public place to the terror of the citizens and disturbance of the public tranquility. And while so engaged in said violation of the law, the offense charged in this indictment was committed, thereby greatly aggravating the moral turpitude of the crime. My first legal proposition is, gentlemen of the jury, that the defendant John R. Kelly is guilty of murder. My second is that if not guilty of murder, he is guilty of manslaughter in the heat of passion and the commission of an unlawful act. I call your attention to the Code Sections 4253, 4254, 4255, 4256, 4258, 4259 to 4261. But, gentlemen of the jury, I call your attention particularly to Section 4259, which is in these words: in all cases of voluntary manslaughter, there must be some actual assault upon the person killing, or an attempt by the person killed to commit a serious personal injury on the person killing, or other equivalent circumstances, to justify the excitement of passion, and to exclude all idea of deliberation or malice, either express or implied. Provocation by words, threats, menaces, or contemptuous gestures shall in no case be sufficient to free the person killing from the guilt and crime of murder. Also to Section 4261, defining involuntary manslaughter, which is in these words: involuntary manslaughter shall consist in the killing of a human being without any intention to do so, but in the commission of an unlawful act, or a lawful act which probably might produce such a consequence in an unlawful manner, provided always that when such involuntary killing shall happen in the commission of an unlawful act, which, in its consequences, naturally tends to destroy the life of a human being, or is committed in the prosecution of a riotous intent, or of a crime punishable by death or confinement in the penitentiary, the offense shall be deemed and judged to be murder. Also to Section 4267, which is in these words: if a person kill another in his defense, it must appear that the danger was so urgent and pressing at the time of the killing, that in order to save his own life, the killing of the other was absolutely necessary, and it must appear also that the person killed was the assailant, or that the slayer had really and in good faith endeavored to decline any further struggle before the mortal blow was given. So much for our code, gentlemen, which is the law of this state. There are also principles of the common law or decisions of the courts, both in England and this country, which are of the same binding force and effect, and which time and experience have demonstrated to be good law, and by universal acceptance and acquiescence have become law, to be observed as such, recognized by juries and enforced by the courts. By these principles you will see that what a man, under certain circumstances, might lawfully do in one place, he cannot lawfully do in another place. While he might lawfully drive a horse at great speed along a private road, in an unfrequented place, he cannot lawfully drive a horse at a like speed along the crowded streets of a city and in a public and much frequented thoroughfare. While, if an accident happened, in one it would be adjudged misadventure, in the other it would be adjudged murder. While a man engaged in building a house in an unfrequented spot might lawfully throw from the scaffold rubbish, he might not lawfully do so in a city, where the streets are crowded continually with persons passing to and fro. In the one case, if death ensued from the act, it might be simply misadventure. In the other, it would certainly be considered murder from the very recklessness of the act, showing of itself an utter disregard of human life. That, while persons might engage in innocent play with weapons not dangerous or likely to inflict serious bodily harm on either, the same persons cannot lawfully engage in sport with weapons dangerous or likely to produce death from the negligent handling thereof. What might be lawful in the one case would not be lawful in the other. What would be misadventure in the one case would be murder in the other. The application I wish to make of these authorities is this, that while the Kellys might have been justifiable or excusable for shooting at the showman in a private place, strictly in self-defense, or in the defense of habitation or property, they were not and could not be justifiable or excusable in shooting recklessly at the showman in a public place and in the direction of a crowd of persons, where death would be likely to ensue from the consequences of their acts, and those persons in no way connected with the difficulty in which they were engaged, to show that what might be justifiable or excusable homicide in the one case would be adjudged murder in the other. End of section 87. Section 88 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford. Dawson, Georgia, 1871, Part 4. I also call your attention to the case in First Gallison's Report 625, United States versus William Ross, as peculiarly applicable to this case. You will see, gentlemen, that this decision was rendered by the great Judge Story, whose commentaries upon the Constitution and whose work upon equity, agency, bailment, contract, and almost every other department of the law now constitute our standards in all the courts of all the states of this Union. Says the learned judge in this case, to constitute the crime of murder, it is not necessary that the slayer should have a particular enmity or malevolence against the deceased. It is sufficient if there be either a deliberate malice in the act or circumstances of cruelty or malignity, carrying in them the plain indications of a depraved, wicked, and malignant spirit. Nor is it necessary to constitute murder that the party should himself inflict the mortal wound. It is sufficient if he is present, aiding and abetting the act, in common sense and reason as well as law. The ruffian who stands by and directs or encourages the bloody deed is equally guilty with him who applies the poniard. So in this case, gentlemen, I contend that it matters not whether John R. Kelly or his co-defendant Charles A. Kelly fired the fatal shot which deprived David W. Oxford of life. Both are alike guilty, as I shall endeavor to demonstrate to you, in conclusion from the evidence. Under the circumstances of this case, the act of one and its fatal consequences was the act of both, and the acts of the two combined constitute the crime charged in this indictment, says the learned judge further. If a number of persons conspire together to do an unlawful act, and death happens from anything they do in the prosecution of the design, it is murder in all who take part in the same transaction. More especially will the death be murder if it happens in the execution of an unlawful design, which, if not a felony, is of so desperate a character that it must ordinarily be attended with great hazard of life, and a fortiori if death be one of the events within the obvious expectation of the conspirators. And what other obvious expectation could the defendants in this case have entertained when firing their pistols with deadly aim? and as fast as it was possible to fire shots in succession from repeaters, at and towards a tent or canvas used for the purpose of a show, filled with and surrounded by women and children and male citizens, but that death must ensue in prosecution of the original design. The law presumes, gentlemen, that every man intends to do just what the legitimate consequences of his own acts accomplish, and where one, reckless of human life, fires a gun into a crowd and kills his dearest friend, it is murder. The slayer is considered an enemy of mankind and deserving of punishment as a murderer, because in such a case, all the circumstances of the killing show an abandoned and malignant heart, and the law implies malice as the prompting and impelling motive. I call your attention also to some few of the numerous decisions of our own Supreme Court, applicable to the case now before you, and still further illustrative of the principles of law I contend for. And first, I cite the case of Epps v. State, 19 Georgia, page 120, in which the court, per Lumpkin, J. says, "We concur, however, with the court below in holding that if it, the killing, had been accidental under the circumstances, it would still have been murder. If one goes to the house of another to take his life, and a death struggle ensues, on the one part to execute the felonious purpose, and on the other to escape, and death ensues from the fortuitous firing of a gun, what is there in such a case to mitigate the offense? A man points his rifle at me with intent to shoot, and by some means the ball is prematurely discharged, and I am killed. Can this be manslaughter?" A very pertinent inquiry made by that great and good judge, I, and a most merciful and righteous judge also. I next cite the case of King v. State, 21 Georgia, page 223. Exception was taken to the charge of the court to the jury. In that case as follows, viz. 7th, because the court erred in charging the jury that if the prisoner was present when the injury was inflicted upon Suggs, and participating in the affray, and attempting to strike or inflict a blow, whether he struck a blow or not, he was equally guilty with the person who did strike. Upon this ground of error, the court, per McDonald J., rendered this decision. The charge of the court was given in reference to the evidence submitted to the jury. The prisoner was using a knife and attempting to cut or stab the prosecutor at the time the latter received the blow. In fact, he was defending himself against the knife when he was knocked down. There was evidence to justify the charge. All the circumstances given in evidence show that the prisoner and his brother, who gave the blow, had a common intent to murder, or inflict other violent personal injury upon the prosecutor, and the jury had a right to infer and find a murderous intent. What a striking analogy between the case and the one at the bar. Two brothers engaged in that affray, two brothers engaged in this, in both cases with a murderous intent. In that case, however, the intent was not consummated, but in this, alas, how fully and completely was that intent carried out, in the killing of two human beings and in the wounding of a third, that third person, too, a woman. I also cite the case of Lyon v. State, 22 Georgia 401. In that case, counsel for defendant requested the judge in the court below to charge the jury that an actual assault by the person killed upon the person killing may reduce the offense to the grade of manslaughter. The Supreme Court, in its judgment as to this point, say, "We think there was no error in the refusal of the court to give the charge as requested. The request was simply an abstract principle of law, proper or not, according to the proof in the case in which the proof was made. In this case, the defendant was a trespasser on the prosecutor's premises. At a late hour in the night, he carried deadly weapons with him, which was unlawful for him to carry, and the evidence shows he was quite ready to use them. Just as we say in this case, the two Mr. Kellys carried deadly weapons with them to that show ground. on that bloody day, which it was unlawful for them to carry. And the evidence in this case also shows that they were only too ready to use them, and did use them with most fatal effect. But the courts say further, in the case referred to, his going armed with a loaded pistol prepared to meet any emergency is evidence of malice. Lyon was convicted of an assault with intent to murder. Under the facts of that case, the Supreme Court laid great stress upon the fact that the prisoner went to the house of the prosecutor armed, in violation of law, with a loaded pistol, prepared to meet any emergency, which fact alone, they said, was evidence of malice. What was the necessity for these loaded pistols at an assemblage of the people of this state, for the purpose of amusement? None whatever. Then may we not legitimately infer a malicious intent on the part of the prisoner and his brother in carrying to that place on that day pistols loaded with powder and ball, prepared for any emergency, particularly when the carrying of said pistols or any other arms in any manner, whether openly or concealed, to such a place was expressly prohibited by law. One more case, gentlemen, and then I shall close, so far as the law is concerned, and that is the case of Hill v. State, 28 Georgia 606. Our good old Judge Lumpkin also pronounced the court's judgment in that case. He says, "We affirm the judgment of the court below on all the grounds taken in the motion for a new trial, and there is but one that we think requires any comment. Hill was indicted as a principal, and the evidence makes it probable that Griffin struck the blow or blows which killed Mrs. Sadler. Can Hill be convicted under the indictment?" Mr. Justice Foster says that the identity of the person supposed to have given the stroke is but a circumstance and a very immaterial one. The stroke of one is considered in law and in sound reason the stroke of all. They were all principles in law and principles indeed. It is not necessary for you in this case, therefore, to inquire whether John R. Kelly or Charles A. Kelly killed David Oxford, if he was killed by either of them in manner and form as charged in this bill of indictment. Both are guilty of his death, and both are principals in the crime. I have been thus particular, gentlemen of the jury, in reading and commenting upon the law applicable to this case, because it is all important that you should have these legal principles firmly fixed in your mind when you come to consider the evidence, with a view to a final conclusion, in making up your verdict. You are not to take what I say as evidence, insofar as I may correctly quote the evidence. Neither are you to accept the statements of any counsel as evidence in this case. The witnesses sworn according to law give you that. It is my duty to weigh and consider that evidence before you in order, not that I may improperly influence your findings, but that I may aid you in coming to a just and righteous conclusion. If I know my own heart, I have no other motive, no other end in view, than the impartial administration of justice. If the evidence and the law point unerringly to the guilt of the accused, so find him. But if they pronounce him innocent, in God's name I bid you so declare by your verdict. I would not hurt a hair of his head. I would not have his blood dripping from my garments, for 10,000 such words as this. If you have upon your minds at the conclusion of this case a reasonable doubt as to the guilt of the accused, give him the benefit of that doubt, and find him not guilty. Our good old mother, the state of Georgia, thirsts not for the blood of any of her children, and even now her bowels of compassion yearn over this unfortunate son who is accused of crime. She is not vindictive. She would not punish any, but that the safety, the peace, and good order of society demands it at her hands. She would punish in mercy and love, simply to show the wicked and lawless that if they incur it, the penalty will be inflicted, to deter others from the commission of like offenses, and to assure the good, obedient, and law-abiding of her protection, to vindicate her laws, to maintain and defend their majesty and supremacy, is the only object I have in view. I have nothing to say against the prisoner. He is innocent unless you find him guilty. Let the evidence in this case judge him, not me. I shall contend in conclusion that the evidence clearly and as unerringly points to his guilt as the needle to the pole. I shall contend that all the state's witnesses are consistent and make out a clear case of guilt, that the witnesses for the defense are all inconsistent and contradictory to each other, save one, and that one corroborates and sustains the state's witnesses. To some of the witnesses for the defense I shall, in conclusion, give the charity of my silence, and leave to your minds the full effect of the impressions made by their evidence, as detailed from the stand. They have my sincere sympathy and condolence. But I put my brethren for the defense upon notice that there is one witness whom I shall take great pleasure in picking, and I flatter myself, gentlemen of the jury, that when I get through with the skeleton of his evidence, there will not be flesh enough left upon its bones to sweeten the tooth of its sugar. Your mercy, gentlemen, may be appealed to by counsel for the defense, but permit me to say in all sincerity that jurors have nothing to do with mercy. The law knows no mercy. An eye for an eye and a tooth for a tooth are its inexorable demands. You are here to try and determine for the country a cold, lifeless, unsympathetic, unprejudiced question of fact. Is the prisoner guilty or not guilty of the crime charged in this indictment? That is the sole question before you. Mercy is as foreign to the question as prejudice, which you are sworn you have none of, either for or against. Mercy is a very appropriate plea for executive clemency, but not before a jury. You are responsible to God and your country only for a faithful, impartial, and conscientious discharge of duty, and there your responsibility ends. The law is responsible for the consequences of your verdict when thus rendered. If a penalty is to be inflicted, the law inflicts it, not you. Let no morbid sensibility influence you in your finding, but let all the ends thou aimest at be thy God's, thy country's, and truth's. Mr. Harper for the defense. Mr. Harper, gentlemen of the jury, this has been a long and tedious investigation. For 3 consecutive days it has dragged its slow length along, and yet no conclusion has been arrived at. A most earnest, and I must say, extraordinary effort is being made by the state of Georgia, through her prosecuting attorney, to take away the lifeblood of this unfortunate defendant. For the second time within a very short period has he been arraigned before a jury of his country, charged with the high crime of murder, all on the same memorable day and in the same tragedy. Men from all parts of the state are being pardoned who have committed the most aggravated offenses, some before and some after conviction, by the authority of the state, and yet, strange to say, in this particular case so anxious is that same authority to convict this man that the regular state's counsel has been ignored and other counsel substituted, who it seems that nothing but blood will satisfy. In view of all this, gentlemen, I hope you will not grow weary and become stupid under the pressure of the gloomy hours of this long investigation, but I beseech you to let your minds be active in your search for the truth, and stand as just and true men, with open hearts, ready to receive all the light that may be shed upon this transaction by the counsel, who, I humbly trust, have studied this case with the view of ascertaining the whole truth. I want you to hear me, gentlemen, not for myself, but for John R. Kelly. I speak to you first in his behalf, and also want you to hear me in behalf of his wife, the companion of his youth, who comes before you with her bosom yearning for him, and says to you in all the innocence of a Christian woman, "Gentlemen of the jury, spare to me my husband." I want you to hear me for his little boy, who comes before you today with his little prattling hands upon your knees, and with the first accents of his infant tongue says, "Gentlemen of the jury, spare me my father." I want you to hear me for this honored old father, who is before you with his gray hairs and his time-furrowed cheeks, saying, neighbors and friends, if it be possible, spare my boy. I also ask you, gentlemen, to hear me on account of that pious old mother, who comes before you bathed in tears of sadness and sorrow, and begs you, in view of her mother's peculiar love, to spare her darling son, if you possibly can do so under the evidence, and turn him over today into the hands of the great God, who made him, who has said in his own divine language and by his own divine authority, vengeance is mine, I will repay. Having given you so many great reasons why we think we're entitled to a patient hearing at your hands, I want to give you now a rule, and ask you to try this defendant by that rule. It is a wise and just rule, one which ought never to be departed from or forgotten in cases like this. And now I ask you to listen to this rule. We, as jurors, must look at all the influences which have surrounded our fellow man, and then sound his heart by the plummet we have applied to our own. We judge not according to appearances. We trace the cause from the effect and consider whether there is any necessary connection between the act and the alleged motive of it. And when we have heard all, and gone through with the anatomy of the heart, we who feel the influence of all motives which prompt to action, and all passions that stir the human breast, know how to judge our fellow. Hence the inestimable value of trial by jury. But what a mockery it becomes, gentlemen, when the issue of life and death is tried without evidence, and without due deliberation. In view of this important fact, we, who have resting upon us the great responsibility of this defense, have made upon our part, as I think I can truthfully state to you, an earnest and an honest effort to place plainly before you all the facts and circumstances connected with this tragedy, from beginning to end, so that you might, if possible, under the facts and circumstances taken together, bring order out of all this confusion, and return in this case a verdict which will satisfy your consciences, as well as meet the ends of law and justice. I shall make it my business, gentlemen, more particularly to deal with the facts that are to guide you in your secret deliberations, and also to govern you in the final determination of this important issue. The law is written in the books, plainly to be read and understood. You are the judges of that law, in all criminal cases, as well as of the facts, and if you should return a verdict unsustained by the law, you and you alone are responsible for it. We are determined you shall know what the law is, which we think ought to govern this case, which will be read to you by my brother Wooten, who will follow in the defense. I will state to you that our Supreme Court in the case of Jones v. State, 36 Georgia 428, solemnly decided that when a felonious assault is made upon a man by another, with a weapon likely to produce death, the party assaulted has a right to defend himself against that assault by any means at his command. Now then, let us reason together about these facts, apply the law just referred to, and be guided by that rule which I laid down a short time ago, and asked you not to forget, and see whether or not the state of Georgia has sustained, by satisfactory evidence, and beyond all reasonable doubt, the charges she has made against this defendant. Let us walk together now in the light of the evidence. On the 2nd day of November last, Robert Russell, a good citizen of your county, came to Dawson, accompanied by his wife and little ones, at the special instance and request and by a published invitation of Colonel Ames and his showmen, to gratify their curiosities in looking at the show which they proposed on that day to exhibit. Came to town peaceably, went to the show ground peaceably, and remained peaceable and quiet until his wife was grossly insulted by the ruffian at the door of the sideshow, who, as the evidence shows, violently caught her by the shoulder, snatching her nearly to the ground, and causing her to drop the little infant she held in her arms, all under the flimsy pretense that Russell was trying to pass in more than he had paid for. Right there, gentlemen, he ought to have been discharged from the employment of Colonel Ames, instead of encouraged by him. And had he done this, in my opinion, this fatal affray would never have taken place, but would have passed off quietly and peaceably. Russell, seeing that the ruffian was not so much as rebuked for his maltreatment to his wife, but, on the contrary, was encouraged in it by Colonel Ames himself, became indignant and demanded an explanation. And just here the row began, which resulted in the death of Colonel Ames and David W. Oxford. And who began it? I ask you, gentlemen, who began it? Who is responsible for it? The next thing, as soon as the altercation began, so says the witness J.B. Event, he saw a showman run to the ticket wagon, gather a pistol from a drawer, and started back in rapid haste, and said loudly and distinctly, "I'll stop the damn row." And just about the time this man got back with his pistol to the sideshow, he heard a pistol fire, the ball passing so near over the witness's head that he heard the whizzing of the ball. The next thing was a showman hallooing out loudly for Colonel Ames and his gunmen. The next thing, according to the testimony, defendant John R. Kelly was pushed out at the door by a party of men saying, "You may scare some folks, but you can't scare us." A showman was then seen, according to the testimony, presenting a pistol at the breast of Kelly, telling him he had the advantage of him. He had a derringer, and if he did not leave the ground, he would blow hell through him. Kelly refused to leave, and then it was the next firing began. Kelly fired first in the air, next into the ground, after which the firing continued until the showman retreated under the small canvas. End of section 88. Section 89 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford. Dawson, Georgia, 1871, Part 5. Now let us take the evidence in detail, beginning at the state's first witness, and see whether or not John R. Kelly is guilty of the high crime of murder. Remember, gentlemen, that the law I have read to you in the language of the Supreme Court is this, that when a man is assaulted with a weapon likely to produce death, he has a right under the law to defend himself and to use any means at his command in his own defense. Now remember the rule I laid down in the outset, and let us see what motive prompted John R. Kelly to act. David Young, the first witness, said he saw a showman approaching Kelly with a pistol, shifting as he walked from his pocket behind to his pocket in front. Young remarked, "That man is going to shoot now." If Young, standing at a safe distance and not in the row at all, thought that this man was going to shoot Kelly, what do you suppose Kelly thought? If Kelly thought the showman would shoot him, did he not have a right to shoot in his own defense? Our law, gentlemen of the jury, does not require a man to wait until he is shot at or knocked down before he can resent it. He has a right, by prompt action, to prevent bodily hurt by shooting down his adversary, whenever the surrounding circumstances are sufficient to excite the fears of a reasonable man. Did he, under this evidence, have enough to excite the fears of a reasonable man? If he did, he was justifiable in shooting at the showman, and if in defending himself he accidentally shot Oxford, admitting for the sake of the argument that he did shoot him, he is not under the law guilty of any crime. David Young tells you that this showman did approach Kelly and tell him he would blow hell through him. But my brother Irving says that man was trying to keep the peace. A new way indeed to keep the peace. If that is his way of keeping the peace, I would never send him out as a peacemaker. Further, gentlemen, who shot David Oxford? If one of the showmen shot him, Kelly is not responsible for it, as I think I can show you. There was a difficulty between Kelly and the showman. Kelly, as we claim, was acting in self-defense. Who shot first? I say, the evidence, if it shows anything at all, shows that Kelly did not shoot first. And then I say, if he was shot at, he had a right to shoot, as often as was necessary for his own defense. Now, there is one thing no one denies. Brother Irvin, in all his zeal and vigor in the prosecution, can't deny it. It is this. The first pistol fired by the Kellys was fired by John R. Kelly, pointing his pistol up into the air. Now take the testimony of Milton Gamache, a man, in my opinion, more likely to have seen this matter just as it occurred than any other man who has been before you as a witness. A cool, deliberate man, not easily alarmed or excited. He tells you that he saw John Kelly when he fired his pistol up into the air, heard several pistol shots before he saw that, but does not know who shot them. Now, gentlemen, you know that John Kelly did not fire those first shots, because all the witnesses say that the first shot he fired was up in the air. Charles Kelly did not shoot, because Mr. Gamache and all the other witnesses say that Charles did not fire at all until John had discharged his pistol 2 or 3 times. Now the question arises, who did the first shooting? All our witnesses tell you the showman shot first. My brother Irvin tells you, however, they are not to be believed. And if they are not, why don't he bring somebody here that you can believe to tell you who shot first? Because we say, in the law that I read you says, that if he was assaulted with a weapon likely to produce death, then he had the right to use any means at his command in his own defense. Where are those showmen today? Why are they not here to tell whether or not they commenced the firing? None of them were heard, except Colonel Ames, and strange to say, he is not represented in this court by a single relative or friend. Neither has $1 been appropriated out of his large estate to aid in this prosecution. Gentlemen, that of itself is a significant fact in this case. It shows, gentlemen, that they began this row by encouraging the ruffians who first insulted Mrs. Russell, and after firing their pistols on the Messrs. Kelly, and finding they had mistaken the courage and bravery of the enemy, they had waked up, they retreated, and so illegal was their conduct on that occasion none of them are here to tell what part they took in the matter. If they were here, gentlemen, let it be for us or against us, you would not be left to grope about in the dark, under the cloud of doubt which overhangs this whole transaction, but you could know from them how it all happened. Our witnesses tell you the showman began the firing. The state's witnesses tell you they can't swear who began it, and you are bound, as the testimony now stands, to believe the showman did begin, for you know they are all cutthroats and thieves at heart, a majority of them, and they go prepared to stand by each other, right or wrong. And when the call was made for Colonel Ames and his gunmen, they responded promptly and quickly, and they are responsible today for this unfortunate occurrence, and have all fled as the wicked do when no man pursueth. We also proved by 3 other witnesses that the showman did the first firing, and whether or not the first or the last firing caused the death of Mr. Oxford is left entirely to conjecture. One thing we do know, Mr. Russell testifies that he was by the side of Mr. Oxford when he received the fatal shot, and that he was on the far side of the canvas from the shooting, that about the time Oxford was struck with the fatal ball, he, the witness, was in a stooping posture, looking back in the direction of the door to the sideshow, and that he saw a showman with a pistol in his hand, in a shooting position, with the smoke emanating from the barrel, proving conclusively that it had just been discharged. And how do you know, gentlemen of the jury, but that pistol sped the fatal ball which caused the death of David W. Oxford? But Major Irvin tells you that Russell is not to be believed, and that he intends in conclusion to utterly demolish his evidence. By what rule can he do that, gentlemen? Up to the 2nd day of November last, no man in this country, not even the gentleman himself, could boast of a fairer name than could Robert Russell, a man of undoubted integrity, perfectly honest and upright in all his dealings with his fellow man, and truthful in his sayings, and today, for the first time, counsel is urging to be imputed to him falsehood, and that only because his evidence does not come up to Brother Irvin's theory of his prosecution. No other witness contradicts him. Nothing in his manner of testifying will authorize you to disregard his evidence. And how are you, too, when you retire to your room, say on oath that Robert Russell swore falsely, or even that he was mistaken, and did not say what he has solemnly swore he did say? Now, under this evidence, is it not as reasonable to suppose, yea, more reasonable to suppose that Oxford was shot by the man Russell testified about, than to say that the defendant, or C.A. Kelly, whom they say were acting in concert, killed him? If this be true, how can you find the defendant guilty? Now, gentlemen, I have labored to present to your minds in as brief a manner as possible the leading points made by the facts in this case. It is your solemn and responsible duty to weigh this evidence all taken together, confused and conflicting as it is, reconcile it if you can, so as to make every witness speak the truth, and find a true verdict according to all the evidence, not a portion, but the whole of it. Some of you may say we can't do that. The witnesses differ so much we cannot reconcile their different statements. Well, gentlemen, this may be, as has been the case in numerous instances, and under all this evidence I cannot see how it can be otherwise in this case. But fortunately for you, the law, in its wisdom and mercy, has not left you at sea, and should you find yourselves in this predicament, it has pointed out your duty and tells you what to do, and that is to find a verdict of not guilty. Major Irvin has told you, gentlemen, that the law knows no mercy. I am proud to say that he is sadly mistaken about that. The law says where you, after hearing all the evidence on both sides, have resting on your minds a reasonable doubt as to the guilt of the accused, you are bound, under your oaths, to acquit. This, gentlemen, is a copious stream of mercy, found in the law, running in favor of every man, woman, or child accused of crime, clearly recognizing the Bible rule that it is better for 99 guilty to be set free than for one innocent to suffer. You must be clearly convinced beyond all reasonable doubt that John R. Kelly killed Oxford, and that he did it with malice aforethought, before you can find him guilty of murder. Gentlemen, the great responsibility of this case rests upon you. By your verdict, this unfortunate man is to be returned to his family and friends, or else forever to be consigned to infamy and shame. This is sufficient to make you shudder on account of the task before you. John Kelly is a young man, raised in your midst, a true man, a brave man, true to his friends and true to his country. Wherever the banner of his country waved in triumph, or lowered in defeat, he could always be found as a faithful sentinel at his post of duty. I cannot believe, gentlemen, that he is a murderer or has a murderous heart. He has done wrong, it is true, but if he has committed no crime, you can excuse him for the wrong. We all do wrong. It belongs to our natures to do wrong. Many tears of sorrow have already been shed by this unfortunate young man. The great sunlight of heaven will never again shine upon his pathway as it has heretofore, no matter what your verdict may be. And I do hope, gentlemen, that you will try this case strictly upon its own merits, regardless of what may be said or done by others, and find it in your own honest hearts to return a verdict in this case, returning him to his family and his friends, and let him go his way and sin no more. Mr. Wooten for the defense. Mr. Wooten. That spirit of persecution whose footprints are the graves of its victims is not yet dead. It lives to add fresh conquests to its record of blood, and it exhibits its Mullet features in the case before you. As a part of the history of this unfortunate affair, it may be stated that the defendant, John R. Kelly, now for the second time within the short space of 6 months, stands before a jury of his county for murder. It seems to avail him not that he has already passed through the fiery ordeal and been triumphantly acquitted in a former trial, involving the gist of the transaction now under consideration. You, gentlemen of the jury, have doubtless been impressed with the extraordinary character of this prosecution. The Solicitor General, who is appointed by law to represent the state in such cases, has been, without cause, superseded by able and distinguished counsel, acting under special power from the governor. That functionary, who is so lavish in the pardon of guilt, very readily engages in the prosecution of innocence. Why this unusual appointment at an unauthorized expense of the state? Could not this trial have proceeded by the ordinary appointments of the law? Certainly no reason to the contrary has been shown. In keeping with this singular procedure is the bill of indictment in this case. In that multifarious document, the state's counsel are not content with charging the prisoner with the murder of David W. Oxford, but it is sought to prejudice an unfortunate man in the estimation of the country by imputing to him numerous offenses for which he is not now on trial. Is it intended thus to outlaw the prisoner? If he were indeed guilty of all these crimes, tortured by a sense of guilt and writhing under the rigor and venom of a relentless prosecution, he might, in the language of Cain, exclaim, "My punishment is greater than I can bear." But he would have no reason to expect the same treatment, while the great Judge of heaven and of earth, moved by compassion, set a mark upon Cain, lest any finding him should kill him. Counsel for the state evince a disposition to outlaw the prisoner and to set a mark upon him, so that any finding him may kill him. In view of these facts and of the spirit manifested in this trial, this may be properly denominated a persecution instead of a prosecution. Under the Mosaic dispensation, when innocent men were pursued by the avenger, they found in the cities of refuge an asylum of safety. From this persecution, the prisoner flees to you, gentlemen of the jury, as to a city of refuge, and asks at your hands what he feels assured will be accorded to him, a fair and impartial trial. The matter submitted for your consideration is a homicide, the killing of a human being of any age or sex. In order to arrive at enlightened and correct conclusions in the premises, it will be necessary to consider the law on the subject of homicide. According to our law, it is of three kinds: murder, manslaughter, and justifiable homicide. Murder is defined by our code to be the unlawful killing of a human being in the peace of the state by a person of sound memory and discretion, with malice aforethought either express or implied. Code of Georgia 4254. So that we discover that the great distinguishing feature of murder is malice aforethought, either express or implied. Malice is an essential ingredient, and if it be wanting, the killing cannot be murder. The next grade of homicide is manslaughter, which is the unlawful killing of a human creature without malice, either express or implied, and without any mixture of deliberation whatever. Code of Georgia 4258. If, for example, the killing be the result of that sudden, violent impulse of passion supposed to be irresistible, then the law, which makes allowance for the infirmities of flesh and blood, relieves it of the guilt of crime of murder. But, gentlemen of the jury, the killing of one man by another is not always criminal. There is another grade of homicide, and to which your special attention is invited, on account of its applicability to the facts and circumstances of the case before you. I allude to justifiable homicide, which is defined by Code of Georgia 4264 to be the killing of a human being by commandment of the law, in execution of public justice, in self-defense, or in defense of habitation, property, or person, against one who manifestly endeavors or intends by violence or surprise to commit a felony on either. Here the law, speaking in the language of truth and of humanity, enunciates the doctrine that emanated from the throne of the Most High. It points to a divinity in man which time and transgression have not been able to extinguish. It stands as an imperishable monument of the Bible-taught truth that God created man in his own image. Numerous instances illustrative of this doctrine might be adduced. If an officer kill a man in obedience to the sentence of the law, or by permission of the law, in advancement of public justice, he is not guilty in legal contemplation. Take the case put by Sir Francis Bacon. If two persons are lost at sea and get upon a plank which is insufficient to hold them both, one has a right to push the other off in order to save his own life. If the prisoner in any one of the battles in which he was engaged during the late war had slain a hecatomb of the enemy, it would have been a credit to him as a virtuous and meritorious achievement, bedecking his brow with laurels and making him a hero and a patriot. Upon the same footing of innocence and justification does the law place acts performed in obedience to the stern and inexorable mandates of self-defense. The all-wise legislature of the universe has written the laws of self-defense in enduring characters on the tablet of the human mind. Blackstone speaks of it as the primary canon in the law of nature. It extends through the animal creation and is shared by the beast that once discoursed of reason. It is interwoven with the human heart, and there is nothing in the law either of God or man to hinder its operations. Any effort to do so would be vain and futile. As well might you attempt to quench the light of the sun or to destroy the action of the law of gravitation upon matter. 'Tis nature's voice, and nature we obey. This is the highest and most potent principle of your nature. Implanted by the hand of God, nothing can annihilate it. You value liberty and property, but if you eradicate this law, you destroy the foundation of both. In all ages of the world, deeds done in pursuance of its behest have met the sanction of civilized legislations. Our own code, 4269, prescribes that the homicide appearing to be justifiable, the person indicted shall, upon trial, be fully acquitted and discharged. Now, gentlemen, having adverted to these general propositions, and fixed in our minds the definitions which I have read in your hearing, let it be conceded for the sake of the argument that it was the prisoner which sped on the fatal ball which produced the death of David W. Oxford. If we examine this case for a while on that supposition, you will find that the evidence places it under the last named grade, that is to say, justifiable homicide. But before we advert to the evidence, I propose to read you from the best authorities the law of justifiable homicide, in order that we may view the evidence in the light of the liberal and enlightened views expressed on that subject by the great fathers of the law. And first I invite your attention to Wharton's American Criminal Law, which is as follows. A man may repel force by force in defense of his person, habitation, or property against one or many, who manifestly intend and endeavor by violence or surprise to commit a known felony on either. In such a case he is not obliged to retreat, but may pursue his adversary until he find himself out of danger. And if in a conflict between them he happen to kill, such killing is justifiable. The right of self-defense in cases of this kind is founded on the law of nature and is not, or can be superseded by any law of society, where a known felony is attempted upon the person, be it to rob or murder. The party assaulted may repel force by force, and even his servant attendant on him, or any other person present, may interpose for preventing mischief, and if death ensue, The party so interposing will be justified. Russell on Crimes contains the same doctrine, also Roscoe's criminal evidence. Thus, gentlemen, we perceive not only the great forbearance of the law, on account of the frailty of human nature, but its high sanctions of the principle of self-defense. But we hear the complaint that innocent blood has been shed, that whatever may be true as between prisoner and the showman, deceased was an innocent third party, and it is urged that prisoner's relations to the showman, even though he was acting strictly in self-defense, cannot avail him. Such, gentlemen of the jury, is not the law. It is true that deceased was an innocent and unoffending man, and I am confident that Job never cursed the day of his birth with more bitterness than does the prisoner of the part which necessity, yea, the inflexible dictates of self-preservation, compelled him to take in the unfortunate affair, which resulted in the death of David W. Oxford. If deceased was slain by the hand of prisoner, it was the result of accident. It is not pretended that prisoner sought the life of deceased. Just at this moment your attention is called to the law applicable to cases of misadventure accidental killing. In Wharton's American Criminal Law, we find the following. Thus A, having malice against B, strikes out and misses him but kills C. This is murder in A, and if it had been without malice and under such circumstances that if B had died, it would have been but manslaughter. The killing of C also would have been but manslaughter, where the prisoner, having had a quarrel with his wife and aimed a blow at her with an axe, which fell on the head of his infant son, then in her arms, by which he was instantly killed, it being shown that the prisoner was ignorant of the child's position, and was at the time in the heat of blood, seeking to avenge himself on his wife for a supposed injury. It was held that, as the case was to be considered as if the wife had been the victim, the same grade of homicide would attach to the killing of the child, as it would have done to that of the wife if she had been killed, so that a misadventure accidental killing may, or may not, be criminal, according to the circumstances. The shedding of innocent blood does not necessarily attach guilt. A man is hunting in a proper place, and hearing a rustling in the bushes, he takes it to be game, shoots, and by mistake kills his own son, who, without his knowledge, is secreted there. This is a case put by some of the books. It is not pretended that the father in that case ought to be punished by law. If a man attack me with the intention to take my life, and in order to save my life, I strike at my assailant, but missing my aim, I kill another person, the killing would be justifiable, as I had the right to kill my assailant, and the killing of the third person was by accident. From all of which this principle is clearly deducible, that when a person in the performance of a legal act, by accident, takes the life of another, he is not guilty but justifiable. Nor can this principle be affected by the place or circumstances. This same doctrine of self-preservation asserts its omnipotence in all places and on all occasions, and in so doing successfully commands the assent of mankind. Suppose a peaceable man is attacked in a public place by a band of demons in human shape, and to save his own life he shoots, but happily misses his assailant but kills an innocent bystander. Will it be contended that he ought to die or suffer the penalty of a felon for that act? Although he knew he was in a public place, and might have foreseen the possibility of such a result, yet he is appealed to by the strongest law of his nature, a law that imperiously commands him to consult his own safety, even though it may involve the sacrifice of others. Roderick Dhew's sense of honor was so exalted that he would right the wrong, whatever it is given, if it were in the court of heaven. In like manner, this law of self-defense asserts its supremacy under all circumstances when life is in peril. To apply this principle to the case before you, if prisoner shot in self-defense, or to prevent a felony upon his person, it was a legal act, or an act which the law allowed him to do, and if in the performance of it he, by accident, mistake, or misadventure, took the life of David W. Oxford, he is not guilty, but justifiable. This being true, gentlemen, supposing the prisoner to have fired the fatal shot, the case hinges upon the state of the matter between him and the showman. Did the prisoner shoot in self-defense or to prevent felony upon his person? Let us advert to the evidence to find an answer to this question. In the great volume of evidence in this case, a number of facts altogether irrelevant to the issue have been elicited. I do not propose to tax myself, nor to burden you with the discussion of irrelevant matter. End of section 89.